to House calendar. Committee substitute for Senate Bill 331, committee substitute for Senate Bill 603, Senate Bill 712, House Bill 5245, a committee substitute for Senate Bill 714.
Introductions. Gentleman, the 43rd, Dr. Tony.
Thank you, Mr. Speaker. I'm pleased to announce that sponsored by the West Virginia Academy of Family Physicians and celebrating the 35th anniversary of Doctor Day program, our family doctor today is Vincent Moore from Marshall University. Please give him a warm welcome.
Standing committee reports.
Your Committee on Technology and Infrastructure has had under consideration Senate Bill 173, modifying certain guidelines for motor vehicle dealers, distributors, wholesalers, and manufacturers, and Senate Bill 802, updating consumer credit and protection laws on certain agricultural vehicles and equipment, and report the same back with recommendation that they each do pass.
Report to be received.
Your Committee on Finance has had under consideration Senate Bill 574, Supplemental Appropriation to DOT, Division of Highways. Senate Bill 696, Supplementing and Amending Appropriations to Department of Homeland Security, Division of Emergency Management. Senate Bill 700, Supplementing and Amending Appropriations to Miscellaneous Boards and Commissions, Hospital Finance Authority. Senate Bill 701, Supplementing and Amending Appropriations to Department of Education, School Construction Fund. Senate Bill 703, Supplementing and Amending Appropriations to Department of Homeland Security, West Virginia State Police. Senate Bill 707, Supplementing and Amending Appropriations to Department of Commerce, Division of Natural Resources. Senate Bill 708, Supplementing and Amending Appropriations to Department of Agriculture, West Virginia Spay-Neuter Assistance Fund. Senate Bill 709, Supplementing and Amending Appropriations to Department of Arts, Culture, and History, National Coal Heritage Area Authority, and Senate Bill 710, Supplementing and Amending Appropriations to State Board of Education, Aid for Exceptional Children, and report the same back with recommendation that they each do pass.
Report to be received. Other standing committee reports this time. If not, select committee reports, executive messages, Senate messages, resolutions, petitions, bills introduced, motions. Gentleman, the 53rd, Dr. Pritt.
Thank you, Mr. Speaker. I would ask for unanimous consent to be included as a co-sponsor on House Bill 4313 if there is room available.
4313. There's not space on the bill. Nope, there is space on the bill.
There is, okay.
Are there objections to gentleman being added to the bill? No objections are heard. Gentleman, the 53rd, Douglas Pritt, will be added as a sponsor on House Bill 4313. Lady in the 56th, Douglas Young.
Thank you, Mr. Speaker. I have the same request for House Bill 4734 and 4883, and there's space on both of them.
Okay, if there's space available, are there objections? No objections are heard, and lady will be so added. Other motions? Gentleman, the 54th, Douglas Pushkin.
Thank you. I ask unanimous consent to be added as a sponsor to House Bill 4883.
4883, there is space available. Are there objections? No objections are heard. Gentleman will be so added. Other motions? Other motions. Unfinished business. Gentleman, the 96th.
Mr. Speaker, I ask unanimous consent that all bills on unfinished business be moved to the foot of all bills.
Gentleman, 96th, asks unanimous consent that all items of unfinished business be moved to the foot of all bills today. Are there objections? No objections are heard. All items of unfinished business will be moved to the foot of all bills today. Bills on third reading.
Committee substitute for House Bill 4010, relating to providing notification of utility service disruption to its customers.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman, the 21st, I got Cannon to explain the bill.
Thank you, Mr. Speaker. This bill would require utilities to have an outage communication plan in place to notify customers of both planned and unexpected disruptions to their utility services. Each utility will include in its outage communication plan a methodology for prior notice to any affected customers for planned service disruptions. And the plan shall include a method for notifying customers electronically and provide estimates about the length of the time of the disruption. Each utility will provide that plan to the Commission.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 93 ayes, 0 nays, and 7 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4010 relating to providing notification of utility service disruption to its customers.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4258 to require railroad companies to provide alternative entry and exit ways.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman 21st, Dr. Cannon, to explain the bill.
Thank you, Mr. Speaker. This bill amends code to require railroad companies to address road openings and to provide an alternative entry and exit way to one-road communities when the crossing is blocked due to maintenance, repairs, or construction as a matter of public health and railroad worker safety. I urge adoption.
You've heard the bill explained. The question now, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? The clerk will close the machine and ascertain the result on this question. There were 94 ayes, 0 nays, and 6 members absent. The majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4258 to require railroad companies to provide alternative entry and exit ways.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 4305 relating to granting in-state resident status to economic development participants.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman from 38 to explain the bill.
Thank you, Mr. Speaker. The bill would grant in-state resident status to economic development participants. To meet the definition of economic development participant, the person or the person's parent or legal guardian must have received economic development incentives to locate to West Virginia pursuant to Code 5B23B. And the person must file a letter of intent to establish residency in this state with the intended higher education institution. That's the purpose of the bill, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There were 85 ayes, 11 nays, and 4 members absent. The majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 4305 relating to granting in-state resident status to economic development participants.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4313 creating the Parents' Bill of Rights.
Objections to having this bill explained in lieu of having it read in full. No objections are heard. Gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to codify a Parents' Bill of Rights. The committee substitute. It creates a short title, it makes legislative findings, and provides a definition of a parent. It prohibits government actions which infringe on parental rights without a compelling state interest and when such actions are narrowly tailored to achieve that state interest. It provides a non-exhaustive list of parental rights. It provides for a civil action by a parent for any such infringement and allows a parent to raise the article as a defense in any court or administrative proceeding. It provides for when the article applies to current and future laws. That's a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now, shall the bill pass? Gentleman from the 52nd, Dr. Rowe, is recognized.
Thank you, Mr. Speaker. Well, here we go again. We got another lawsuit in the code book. If we pass this and it becomes law, hooray, hurrah. Well, what kind of a lawsuit is it? Let's look at that. This doesn't add anything about parental rights. Parental rights are secured in the Constitution, so we don't have any trouble on what parental rights there are. They're there. You can sue now for a violation of constitutional right. But what does this bill do? We had a fellow come speak from Georgia who's in a law firm that brings lawsuits all over the country for based on laws like this. And what this law does is that you don't just get to sue the local administrator, the principal, the teacher, the choir director, or any of those folks, they will be protected by BREM. See, they don't have, they've got money and a lawyer. Hooray. Now that's current law. But what this does is this says that they can sue anybody that's acting under color of law. You say, well, who's that? Well, it's the PTA. It's every volunteer that goes into a school, every volunteer that goes into a hospital. If they're somehow caught up in denying a student's constitutional rights to their parents, this law doesn't do anything other than really cause trouble and a lot of heartburn for volunteers. So if you want to impose on the people who try to volunteer and make their schools better, vote for this bill. If you're concerned about them and you don't want them sued because they don't have BREM, and you say, well, maybe they'll have homeowners coverage and can get a lawyer paid for that away. Well, maybe they can. I don't know. Or maybe, I don't think car insurance would apply, but homeowners insurance might apply for their volunteering at a school where the constitutional rights of some parent are claimed. And remember, they don't have to prove their case to inflict the harm because it costs them money to hire an attorney. I think that the members need to look at the section there. The effective section is on line 16. A parent may bring suit against the state, any agency or locality thereof, any government official, or any person acting under color of law based on any violation of this article, and seek appropriate relief, including but not limited to injunctive relief, money damages, personal attorney fees, reasonable attorney fees rather, and court costs. Plus a parent can use this as a defense. This is not the kind of bill we ought to be passing. We shouldn't inflict on our volunteers this kind of liability. And to my knowledge, they're not covered by BREM. So, who's going to pay for their lawyers? And all it takes is a claim. It doesn't have to be successful, doesn't have to be true. All it takes is a claim. So if you don't want to punish your volunteers in the schools and hospitals, vote against this bill.
Is there debate on this bill? Gentleman from the 76th, Garcia is recognized.
Thank you, Mr. Speaker. Will the Chair of Judiciary yield for a question?
Yes.
Thank you, sir. So how is the Governmental Tort Claims Act affected by this? That's the act that really provides for a number of different immunities. Do those all go away with respect to these provisions?
I'm advised by counsel it would not affect the Tort Claims Act.
So counsel says it's not affected?
Yes.
Well, in these instances, there aren't certain immunities because this applies not only to state entities, but also to municipalities.
Political subdivisions of the state, yes.
Okay. Thank you, sir.
Gentleman from the 79th, Hanson.
Thank you, Mr. Speaker. Would the Chair of Judiciary yield?
Yes.
I have a question about how this might apply to that Baby Olivia video that is receiving a lot of attention in the Senate in recent days, which is, you probably are aware, a bill is probably on its way here that would require showing that video related to fetal development in certain classrooms. And so my question is, me as a parent, if I objected to that video being shown to my kids, what would be my recourse under the Parents' Bill of Rights?
Well, the bill obviously codifies a parent's fundamental rights, and if a parent would not want their student exposed to that type of education, a parent could notify the school that should not happen. And if the school ignored that, then the parent would have a cause of action in that situation.
So I would only have a cause of action if they forced my child to watch that video.
Yes, that is my understanding. Yes, sir.
Okay. Would you agree with some of the statements previously made that this opens up very broadly to different entities that could be subject to suit. So, for example, this would open up school systems potentially to suit, local school systems. Is that right?
I mean, you have to read the bill for what it says. It does state that a parent has a cause of action, and it does outline a non-exhaustive list of rights of a parent, which is codifying the fundamental rights of parents.
Right. Does this bill provide for the rights of parents to make health care decisions for their children?
Yes, it does.
Does it? Are there any exceptions to that?
You would have the compelling state interest test if the state would have a compelling state interest to override a parent's decision on any of these enumerated rights, and it would be subject to strict scrutiny.
So we have a bill later on the agenda today relating to parents and their health care providers being able to make decisions about certain types of health care for trans kids. Would this bill provide parents with the right to retain that type of health care decision for their children?
It does state that unless otherwise authorized by law. It does state that. So
Okay.
what the law states would still prevail.
So this legislature could take steps to restrict parents' rights in terms of health care decisions.
I believe that would be regulation of medical industry, not parental rights.
Sorry, could you repeat that?
I believe that would be a regulation of medical industry, not parental rights.
The bill that we're dealing with later today?
No, what you were referring to.
I was referring to the bill that would take away the exceptions right now related to gender-affirming care, which right now, I mean, no child is going to take part in that type of health care unless their parents are already involved in that decision-making process.
Can you give me a specific question, a specific situation? If
Sure. The specific situation, and then I'll end with the questions. Specific situation is if the parent of a trans child is in discussions with their healthcare provider and decide that due to the child being suicidal, that certain type of healthcare is required to help the child, which seems to me to be like a basic parental right related to health care. So the question is, how would this bill impact that parental right?
well, health care is a very broad law, very broad concept, but if you would read the bill on page 2, subsection 5, the right to make health care decisions for his or her minor child unless otherwise prohibited by law. That's the best answer I can give you.
Okay, thank you for that clarification. I have concerns about this bill, as you could probably tell from my questions. I have concerns that this legislature, over the last several years, have taken numerous steps on issues related to culture wars and have employed some clever titles for these bills. I think the short title of this bill, the Parental Bill of Rights, is a great title, almost an Orwellian title, because this bill will provide some rights for parents so long as they agree with the majority party, so long as those parents agree with the majority religion and the types of bills that this legislature is passing. But I'm concerned that it's opening up a very broad cause of action, as my friend from Kanawha explained, and that this cause of action can be employed on a number of hot-button issues related to race, issues related to gender, issues related to women's health care. And it's a great name, just like we've considered bills related to race that are called anti-stereotyping, but would actually lead to less history being taught in our schools. Or we passed a bill earlier this session called the Women's Bill of Rights that actually guts the Human Rights Act for women. This is the Parental Bill of Rights. Again, a great name, another culture war bill. More time being spent on issues that are not solving the most important issues faced by West Virginians. So I oppose the bill.
Lady from the fourth, I got Winston Reed.
Thank you, Mr. Speaker. Will the chairman of the judiciary yield?
Yes.
Where will the burden fall in terms of directing the child's education? Will it be on the parents to notify the school district of their personal beliefs, or will the school have to release curriculum and lesson plans to make sure that the parents are able and willing to have their children participate?
On some subjects, there's already requirements that the school notify parents, like sex education material and things like that, and parents then have the option to opt their child out. In that situation, if the child is opted out, but the school would ignore it, then there could be a problem under the statute. If the school pays attention to what the parents have said and follows that edict, then yes, you wouldn't have a problem.
And what if it's something that they haven't been notified of that becomes an issue? Child comes home from school, we learned this today in blank. What then happens when you look at these cause of action at the end?
And in that situation, are you saying that the parents found out that their child was taught something that was objectionable after the fact?
Correct. Something that maybe wouldn't necessarily be notified or known by the school system that would potentially be considered inflammatory, that may offend that parent's.
In that situation, any reasonable parent would immediately notify the board, stop that, and then if they didn't, there could be an issue. They could bring a cause of action. If the parent brought a cause of action without notifying the board, even after the child was taught something objectionable, that would be a discretionary call with the judge as to whether to allow the case to go forward or not.
And will it be up to the school systems to determine sort of what they believe to be objectionable for their areas, or how will that be enforced?
That would be a situation where, I mean, school boards are going to have to use common sense. Like I said, there's already certain subjects that boards are supposed to notify, or teachers are supposed to notify parents. And so that would be a case-by-case basis.
Okay, thank you.
Sure.
Lady from the 56th, Young's recognized.
Thank you, Mr. Speaker. Will the Chair of Judiciary yield quickly for a question?
Yes.
Thank you so much. So in the findings, it says that there's a fundamental right of parents to direct the upbringing, education, care, and medical care of their minor children. But then when I'm looking at what that includes but is not limited to, everything seems pretty broad. Would you agree with that, that it's just like general rights?
I mean, I would only answer what you see in the bill is what's there.
Okay. My question's on Section 5, the right to make healthcare decisions for his or her minor child unless otherwise prohibited by law. Do you know what healthcare decisions are prohibited by law under this section?
We just passed a bill that gender-affirming care, sex transition surgeries are not authorized for minors. So that would be one example.
Okay. Is that the only example?
No, it's not exhaustive.
Okay. So we're saying that parents have the fundamental right to make a decision for their child unless we say otherwise. Would you agree that's what this says?
You have to read the bill, and it's plain on its face.
Okay, thank you so much. That's exactly what it says. It says the right to make healthcare decisions unless otherwise prohibited by law. I trust parents. I don't think we should be making decisions for parents. So for that reason, I can't support this bill. Thank you.
Is there other debate on this bill? Gentleman of 51st to close debate on the bill. Question now before the House is shall the bill pass. Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 83 ayes, 14 nays, and 3 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4313, creating the Parents' Bill of Rights.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House and the Senate. Next bill on third reading.
Committee substitute for House Bill 4408, to allow the development of a specialized intermediate care facility for individuals with intellectual and developmental disabilities.
Are there objections to having this bill explained in lieu of having it read? If not, ladies from the 73rd to explain the bill.
Thank you, Mr. Speaker. This bill allows the development of a specialized intermediate care facility for individuals with intellectual and developmental disabilities. This bill fixes a process gap concerning the reallocation of ICF IDD beds. The bill clarifies that a bed from a closed facility is returned to the Healthcare Authority for reallocation. I urge passage.
You've heard the bill explained. The question is, shall the bill pass? Gentleman of the 54th, Douglas Pushkin.
Thank you, Mr. Speaker. Would the chairwoman please yield?
Yes.
Thank you. I have a couple questions about trying to figure out what this bill exactly does now in the posture that it's in at this time. So it says the bill was originated in finance. That's what it says on the bill, originated.
Just the committee substitute.
Okay, the committee sub. So this bill came through the Committee on Health and Human Resources, and then there was a committee substitute in finance, correct? And that's what was originated?
Yes.
Okay, because it looks a little different. When you say it's for it'll help with the creation of a, first of all, does this bill allow for the creation of a larger, like, institutional type facility for those with intellectual and developmental disabilities?
It does not. It allows for beds that have currently been allocated a certificate of need that have gone away due to closure by a company to go back to the Healthcare Authority to be reallocated to another company. Because you know there's a moratorium on these beds, there's a cap. So once the beds go away, then there was no way to reopen beds.
Now, yeah, what I'm looking at here, that's pretty much all it does. It says that those certificates of need go back to the Healthcare Authority, right? And
That's correct.
Because where we passed, there was a law passed, I don't know when, that allowed for these 6 facilities to be open, and then they never opened, correct?
That's correct.
So it's striking the language that allowed for the creation of these 6 facilities because they never opened. There was no money put into it. And so all this does is send the CON back to the Healthcare Authority, basically.
Yes, and Disability Rights West Virginia helped me craft this language to fulfill the goal that we had to get more beds, or at least not lose beds, so that individuals would not end up in a higher level of care, such as a psychiatric hospital.
Okay, thank you very much for yielding. Appreciate you. Mr. Speaker, just briefly, the bill originally was to allow for a larger facility for people with intellectual developmental disabilities. I would have opposed that because I don't think that's the correct setting. It goes against case law. However, that's not what this bill does. But the problem is we created this law years ago and no money was put into it. Currently, there was a recommendation that we pay the personal care workers a substantial raise. That was not in the governor's budget, but we're not really addressing a serious issue in the state. And we can clear off the waiting list, but if people don't have the staff to help these folks with severe intellectual and developmental disabilities, they're not going to get help. But that's not what this bill does. This just sends the certificate of need back to the Healthcare Authority. That's all it does. I'll pass.
Is there other debate on the bill? If not, laid in the 73rd to close debate on the bill.
Thank you, Mr. Speaker. I would urge passage of this bill. We want to make sure that we have enough beds in the right, I don't know how to say this, but we want to make sure that we have beds available so that individuals do not end up in psychiatric hospitals. We want them to be able to be cared for in the most appropriate setting. As facilities have closed due to workforce shortage or abuse at their location, then the beds are gone forever due to our certificate of need process and the moratorium that's in place. We need these beds. There could be new companies that are interested in coming here to replace those beds that I hope pay a higher wage, have better benefits, or I hope that we find funding to do that so that we can pay these individuals a higher wage. So I think this is very beneficial to these individuals, and I would urge passage.
Debate on the bill has been closed. Question now before the House is shall the bill pass. Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4408 to allow the development of a specialized intermediate care facility for individuals with intellectual and developmental disabilities.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4591 give a 10-day right to appeal to the Supreme Court of Appeals a Secretary of State decision to not certify a candidacy.
Are there objections to having this bill explained? We'll having the bill read. If not, Gentleman the 8th, Delegate Kelly to explain the bill.
Thank you, Mr. Speaker. Good morning, ladies and gentlemen. The bill attempts to place into code language which provides that the Secretary of State or other election officer shall, upon receipt of certificates of announcements, verify the party registration, residency, and correct district. The Supreme Court of Appeals has original jurisdiction over appeals from the decision of the Secretary of State's refusal to certify a candidacy for public office. An applicant who is denied certification of his or her candidacy may appeal this decision to the Supreme Court of Appeals no later than 10 days of the decision from the Secretary of State. That is a brief summary of the bill, Mr. Speaker.
You've heard the bill explained. The question now is shall the bill pass? Is there debate on the bill? The gentleman from the 79th, Delegate Hansen is recognized.
Thank you, Mr. Speaker. Would the Vice Chair yield? I have a question just about one part of this bill, which is about the requirement for the Secretary of State, upon receipt of certificates of announcements, to verify the residency of the prospective candidate. How will they do that?
Well, we would think that they would have a driver's license or other ID.
And how would they do that if the certificate were mailed?
Provide a copy of it. I would think they would provide a copy of it.
So it would be based on a driver's license. Do you recall the testimony that we had from the Secretary of State's office when this question was asked in committee?
I do not, sir. Refresh my memory, if you would.
Okay. Well, my memory of it is that they had concerns about whether they would have to staff up and whether it would be a somewhat cumbersome process for them to actually do that residency verification, that it was a little bit more complicated than just submitting a driver's license.
Okay.
Okay, thank you for yielding.
Yes, sir.
Yeah, this is my only concern with this bill. I think this bill has great intentions. We all want to make sure that people reside in the district in which they're running. That's just good government, and it makes a lot of sense. I just do have some concerns about whether the Secretary of State's office has a process in place where they could actually verify people's residency. Thank you, Mr. Speaker.
Is there other debate on the bill? Is there other debate on the bill? If not, the question is shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Lady in the 56th, your vote's not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4591, give a 10-day right to appeal to the Supreme Court of Appeals a Secretary of State decision to not certify a candidacy.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. Gentleman from the 96th.
Mr. Speaker, I move that the bill take effect January 1st, 2025.
The question is on the gentleman's motion that the bill take effect January 1st, 2025. Those in favor of the motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 0 nays, and 4 members absent. 2/3 of members having voted in the affirmative, the chair declares that bill effective January 1st, 2025. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4709 relating to vocational and technical education programs.
Are there objections to having the bill explained in lieu of having it read? Gentleman from the 38th to explain the bill.
Thank you, Mr. Speaker. The bill states that a 4-year pilot program would be established to provide participating middle schools with an elective course to better prepare students to take advantage of West Virginia's career and technical education programs and to improve their college and career readiness. The bill also requires that the State Board of Education implement these provisions by rule as prescribed in the bill. The state superintendent of schools is also required to report annually to the OC about the program and also continuation of the program after its 4-year pilot program status. Mr. Speaker, that's the bill, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 97 ayes, 0 nays, and 3 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4709 relating to vocational and technical education programs.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 4721 requires surveyors to offer to record surveys of property.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman to 68 to explain the bill.
Thank you, Mr. Speaker. The purpose of House Bill 4721 is to require land surveyors to offer to record maps or plats of measured parcels of land made by the surveyor. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman to 51st, Douglas Fast.
Thank you, Mr. Speaker. Would the chairman yield for a quick question?
Certainly.
I have no objection to the bill. I'm just wondering if the surveyor is to offer to record, who is to pay for the recording?
They can charge a fee for it. They just have to make the offer so the individual getting the survey done knows that it's not automatically recorded.
Thank you.
Is there other debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Gentleman to 16th, Douglas Westfall. The clerk will close the machine and ascertain the result on that question. There were 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4721 requires surveyors to offer to record surveys of property.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4722 create a credit against the severance tax to encourage private companies to make infrastructure improvements to highways, roads, and bridges in this state.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman the 12th to explain the bill.
Thank you, Mr. Speaker. This bill would allow new tax credits for a portion of the cost of the investments in road or highway infrastructure improvement projects paid by certain taxpayers that may be applied by the taxpayer against a portion of the taxpayer's payments of severance tax on coal. The tax credits may not be applied against any portion of severance tax that is dedicated or allocated to counties and municipalities. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Gentleman to 52nd Docket Row.
If the chairman would answer a few questions.
Yes, sir.
Now, do these improvements have to be on public property and available to the public, or can they just be roads in and out of the mine portal or whatever?
These roads would have to be approved by the DOH, so I assume they would be public facilities that would be improved.
Okay, thank you, sir.
Yes, sir.
Is there further debate on the bill? Is there further debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 94 ayes, 3 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4722, create a credit against the severance tax to encourage private companies to make infrastructure improvements to highways, roads, and bridges in this state.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House and Senate. Next bill on third reading.
Committee substitute for House Bill 4734 to provide a pay increase to state correctional workers in West Virginia.
Are there objections to having this bill explained in lieu of having it read? None are heard. Gentleman the 12th to explain the bill.
Thank you, Mr. Speaker. This bill would amend the provisions of the West Virginia Code relating to salaries of employees of the Division of Corrections, Division of Juvenile Services, and Regional Jail Authority. The bill would authorize a bonus of $6,000 for any such employee who had accumulated 3 or more years of service. The bill would also authorize that those who become so employed receive a sign-on bonus of $3,000 to be paid upon accumulation of 3 or more years of service. I urge passage.
You've heard the bill explained. The question is, shall the bill pass? Gentleman the 8th, Docket Kelly.
Thank you, Mr. Speaker. Ladies and gentlemen, this is this body saying we heard you last year. We're going to make good on our promise. I want to thank the Chair of Finance for running this bill. Thank everybody in advance for your vote. These folks are heroes, and I appreciate your support. Thank you.
Gentleman from the 66th, Docket Nestor.
Permission to speak to the bill, Mr. Speaker.
Yes, gentleman is recognized.
As this body knows, I've been working on this bill for a number of years at this point, and I think it's important for this body to understand that I, like everybody else in this room, loves to give pay raises to state employees because it does one thing. It says, hey, we're doing our job, we're making more money, we're creating better infrastructure, and we're able to compensate the people that work for this state and make it work, make it turn, and make it happen. We're able to reward them, we're able to keep them here, we're able to provide for their families. So pay raises, they're very important, and I, like everyone else in this room, loves to give them. But I want to tell you that when I've been working on this bill for a few years, it wasn't because one person. I have 3 correctional facilities in my district. I have Denmar, or I used to have Denmar when I was in the 43rd. I have Huttonsville Correctional Facility, and I have Tygart Valley Regional Jail. And I want to impress upon this body and everyone listening out there today that nobody from any one of those facilities is employed in any capacity, whether it was the Division of Juvenile Services, which will be affected by this pay raise, or this sign-on bonus, recruitment intention bonus, anyone in the Division of Corrections, or anyone that worked for the Regional Jail and Correctional Authority ever came to me and said, hey, we're not getting paid enough. What are you doing down there in Charleston? We need more money. I don't have enough money to pay for this, that, or the other thing. So what I think is really unique about this pay raise bill, which is more of an incentive, is that it does 2 things. It thanks these people for what they did through COVID. And what they didn't do was come to us and say, hey, you're not doing your job because we're not getting paid enough money. No. The complaints I heard from the members and employees of these facilities were, hey, I'm in a dangerous environment. We have people that are non-uniformed correctional personnel, people of stature of 5'3" or female, that are secretarial workers at Huttonsville, overseeing a dormitory of convicted felons, some of which have been convicted for sexual assault. They didn't come to me because of complaints about not having enough money or not getting paid enough for what they do each and every day. They came to me because they were scared. There's still talks in my community from riots that occurred in the early 80s at Huttonsville that took lives of state troopers. All right, these are very serious things. I'm thoroughly embarrassed, as I'm sure we all are. We had the National Guard in these facilities. We were in a state of emergency, and we were actually expending more money to have the National Guard in these facilities than what we would have needed to do if we'd have had them staffed. So, like Delegate Kelly, I want to thank him for his work in making my bill go through. Thank you, Delegate Kelly. I'd like to thank Delegate Brooks and Delegate Hott and each and every one of the members of this body that helped make this bill a reality. I don't think $3,000 is enough, but I think it's a start. And I know that our Inspector General, Mike Conacher's done a great job. We had 1,000 vacancies, now we're only down to 300. So with the passage of this bill, you're not just going to give monies that are due and owing that have been earned by members of the Division of Corrections and Juvenile Services and Regional Jail Authority. You're also going to thank them for how they conducted themselves and their bravery for staying with their jobs, because they're going to get $6,000 with 3 or more continuous years of service. So it's a great bill. It's a great day for me. I urge passage. Thank you, Mr. Speaker.
Is there other debate on the bill? Does the gentleman wish to close debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Gentleman in the 51st took it fast. Clerk will close the machine and ascertain the result on that question. There are 99 ayes, 0 nays, and 1 member absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4734 to provide a pay increase to state correctional workers in West Virginia.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. Lady from the 71st, Delegate Kimball.
Thank you, Mr. Speaker. I humbly ask unanimous consent to acknowledge that my vote on House Bill 4722 was in the negative, and it should have been in the positive.
Lady can record the vote preference with the clerk.
Thank you.
Further action on committee substitute for House Bill 4734. If not, the clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4784, establish setback from residential properties for new windmills being constructed throughout the state.
Are there objections to having the bill explained in lieu of having it read? If not, gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. This bill establishes a requirement that before the Public Service Commission awards a sitting certificate for a wind energy system, there must be a minimum distance from the wind turbine to the closest residence or property line. The bill defines a residence and provides that a wind energy system owner must demonstrate to the PSC that the design and construction of a wind energy system or an addition to an existing wind energy system meets the following requirements. Number 1, the minimum setback from any landowner's property line is equal to 1.1 times the total combined height of the turbine, tower, and maximum blade height to the nearest point on the property line. Number 2, the minimum setback from any residence for the wind turbine is to be 1.5 times the total combined height of the tower, turbine, and maximum blade height to the nearest point on the outside wall of the residence. And number 3, the minimum setback from paved public roads and overhead transmission lines of 115 kilovolts capacity or greater shall be equal to 1.1 times the total combined height of the tower, turbine, and maximum blade height to such paved public road or transmission line. That is a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 84 ayes, 10 nays, and 6 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4784, establish setback from residential properties for new windmills being constructed throughout the state.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4812, capping amount of monies to third-party vendors who collect business and occupation taxes on behalf of cities.
Are there objections to having the bill explained, though, of having it read? No objections are heard. Gentleman from the 97th to explain the bill.
Thank you, Mr. Speaker. The purpose of the bill would amend provisions to the West Virginia Code relating to the business and occupation or privilege tax imposed by municipalities. The bill would limit the fees charged by a third-party vendor who contracts with the municipalities to collect B&O taxes for the municipalities to no more than 20% of the amount tax collected. That is the bill, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman, the 52nd row.
Thank you, Mr. Speaker. If the gentleman would help me understand what's going on in this bill.
Yes, sir.
Will the municipalities lose taxes on this?
No. What this is outside organizations that go to municipalities that have taxes owed to them by outside businesses, and they basically will find like a vendor list, and they will go on basically fishing expeditions to try to collect taxes that are owed by the municipalities, and they take 50% of that tax. So this would just reduce the portion of money that they would take to 20%.
Okay, in other words, they're bill collectors, and they have a fee of 50% on collection.
Yes.
This would lower that.
This would lower this to only 20%.
Thank you, sir. Thank you. Thank you, Mr. Speaker.
Gentleman from the first, I got McGeehan.
Thank you, Mr. Speaker. You continue to yield. This only applies to the business and occupation tax, is that right?
It does.
Do you know how many, just offhand, municipalities engage in these third-party contracts for this?
I do not. I couldn't answer that.
Would you happen to know how the, so if you're a home rule municipality and you remove business and occupation taxes and then replace it with a 1% sales tax like many do, would you know, do many municipalities that fall within that category, do they also use these third-party vendors to collect that 1% sales tax?
I'm sure they could, and some of municipalities have not replaced their B&O taxes with the 1% sales tax. They've done some maneuvering to change those taxes or lower those taxes on maybe in areas that they're not collecting. So there was a workaround with some municipalities for that, but I would certainly say that there probably are municipalities that are doing that.
Yeah, okay. I appreciate the bill. This needs some cleaning up, I think, going forward, even further in the future. So thanks for this.
Gentleman from the 20th, Secretary Foster.
Thank you. This is my bill, and to answer some of those questions, the reason it doesn't apply to the sales tax is because our state sales tax department does it for a 1% fee. So we're just reducing from a 50 to a 20 on this fee, and it applies to B&O licensing fees, those that are not handled by our state sales tax department. So this is basically keeping the money. And of course, it's an out-of-state organization from North Carolina, and you're sending half the taxes that should be going to the city out of the state to North Carolina. So I would urge passage.
For what purpose, the gentleman first seek recognition?
The gentleman from Putnam, yield.
Yes.
Just a question. So municipality that falls under the home rule exemption, and they're granted home rule status, and say they have the 1% sales tax. Do you know how the sales tax is applied? Is it applied just within the city limits, or is it applied Is it applied just within the city limits, or is it applied Is it applied just within the city limits, or is it applied
will vote aye. Those opposed will vote no. For what purpose will the gentleman to first seek recognition?
Will the chair yield?
Okay, does the gentleman yield for a
Yes,
question?
sir.
Yes.
Can you just sort of walk me through how this works in practice? We're raising the financial threshold from $25,000 to $75,000, it looks like. And what would that money be spent towards?
I think the gentleman from the 41st may be able to answer your question if he'll yield to your question.
Yeah, please. Thank you.
Absolutely. So to your question, when we're doing certified sites, when we're trying to get sites for businesses to be, move into West Virginia, sometimes you need a preliminary engineering report. Sometimes you need a phase 1 environmental study. Sometimes you need surveys. And all of these cost money as we're moving toward a certified site. And some of these local EDAs don't have the upfront capital to invest in these sites, and so it creates a matching program to help them do so.
So the money's, we're upping the financial threshold of state money to pay for all sorts of different permits, different, I don't know, what else?
Yes, sir.
Certifications or something like that?
Absolutely. All the steps that are required to get a site ready for a business to come in, locate, and build on that site.
And what exactly is a site? What are we talking about here?
We're talking about a parcel of land that is being developed for industry, business, et cetera.
Okay. All right, thanks. Okay, speak to the bill, Mr.
Gentleman is recognized.
I'm just going to oppose this bill. Take a look around our state. We see a lot of these sort of parcels and what we deem in this bureaucratic language as these ready sites or hardened sites. And really, what they end up as are just empty business parks. And I've got a couple up in the Northern Panhandle. In the wisdom of the Economic Development Agency in my region, they decided to build a $2 million steel warehouse in 2011, I think, that I think finally was leased for the first time last year. And they essentially landlocked about 12 to 13 prime acres of riverfront property from anybody else using it. Just recently, in my hometown, we had a great family restaurant. I don't know about you guys, but I love my hometown. That's why I'm down here. I talk about the world's largest teapot a lot, but we have these great family restaurants still in my local community that are very organic, family-owned. Those are the kinds of things that I think attach us to our local community. And, those sorts of things, there's that very local feel, the local community itself, starting to erode and go by the wayside. Right? Recently, I had this small little restaurant everybody loved. It's called Hot Shots. They made the best wings in town. My mother would always go down there to get some on the weekend. It's a great place owned by a family in town. Okay? Well, there was some economic development that just took place last year. They tore down an old dentist's facility right next door to it, and with some sort of subsidies, put in a Wendy's. So the local businesses, the local little restaurant, no longer there. But we got a Wendy's. So if I go up and down the Ohio Valley and I visit every single small little river town, up and down, and you can go down through all the little small communities throughout West Virginia, and you'll see the same phenomenon that's going on. Everybody's got a Wendy's, everybody's got Taco Bell, everybody's got an Ace Hardware, everybody's got a Walmart. Everybody is the same. It's sameness over and over again. And we don't even notice it's happening. That distinctness,
those layers of local community, local associations that bind families and local communities together, that get in between us and the state, are evaporating. And it's because we don't put a whole lot of thought into things like this. Let's open up markets. We just pay for these permits from state money, enter ourselves into the barriers of local communities that are supposed to protect families, local little restaurants like Hot Shots that had the best wings in town, and eviscerate them. And we don't even realize it's happening. That philosophy that we hold wrongly, that ideology of opening up markets at all costs, that's the same sort of ideology that leads into what those people keep professing over and over again. Same side of the coin. Sameness, egalitarianism. Look up and down our state. It's homogenization. We're doing what the communists could only dream of, and we don't even realize it. We're losing our attachment to localness, to an attachment to a finite place, family, tradition, church. Yeah, this might be some small little bill, but I'm using it to make the point. So I'm gonna know.
Gentleman from the 99, Kentucky, Clark.
Thank you, Mr. Speaker. My good friend from the 41st yield.
Absolutely.
So, just to clarify things, we're not increasing any money that's already in this pot of money, correct?
That is correct. In the special session last year, we gave the Department of Economic Development $5 million for this program. And my understanding is testimony in the Finance Committee is they had around 4.8, give or take, left in this pot. We're only increasing the threshold per allocation, not increasing their budget whatsoever.
Why would we need to increase the threshold, the amount for allocation?
Because a month and a half ago, I was dealing with a PER that was around $65,000. So we made the point that $25,000 simply wasn't enough to accomplish what we're trying to do with this program. We need a higher threshold because obviously with inflation and everything else, some of the costs of engineering reports, surveys, et cetera, have gone up, and we need to be, responsive to that.
So would you say that we are giving our Economic Development Office the tools they need to help all businesses in the state of West Virginia?
Yes.
Thank you, sir. Folks, I just want to make sure that everybody understands, like we heard, this is no increase in money. This is just increase in the amount of grants that can go to each individual project. As you all know, the cost of building things has skyrocketed over the last few years. This gives all of these grants an opportunity to get the money needed to have site readies. Anybody know anything about economic development within the state of West Virginia knows that we do not have site ready programs available for businesses who want to come in. Some of these businesses want to come in right away. They're not asking for any incentives, they're not asking for any of those projects, but we don't have sites ready for them. I know in my county, one of the biggest things that we have is we do not have any sites ready. I get constant calls from companies, hey, Wayne, we want to come in, but we don't know where to go. Do you have anything available that has water, sewer, road access, all of that? We don't have it. This gives our Economic Development Office an opportunity to do that. So I don't want to get into a social issue here. This is strictly giving our Economic Development Office the tools they need to function accordingly, and I urge passage. Thank you.
Gentleman from the 11th, Doug Fehrenbacher.
Thank you, Mr. Speaker. I'd like to speak to the bill.
Yes, gentleman's recognized.
I have the honor and privilege of serving on the Wood County Economic Development Authority, and to build on the comments from my friend in the 99th, this is needed because of the pace of business. When a business is considering establishing some business in the state of West Virginia or our surrounding states, they want a response in typically 2 to 7 days. They will send information out and say, I need so many acres, I need a building, I need the following utilities. And very often, the entities that receive those survey requests know of properties, but they may not have the answers. Where's the nearest utility? How many specific acres are there? And this, as the delegate from the 99th confirmed, does not increase the amount of money that is being spent. It is giving more money so that this information can be made available and so that those properties and or buildings can be marketed and made available, creating jobs and opportunities in West Virginia. This is a good bill. I support its passage. Vote yes.
Gentleman from the 52nd, Doggett Rowe.
Thank you, Mr. Speaker. Would the gentleman from the 41st answer some questions about the program?
Absolutely.
Do the expenses extend to actually installing water lines or making improvements on the property, or is this just planning?
Given the budget, and it was capped, it was around $5 million in the allocation, this wouldn't necessarily be for hard infrastructure. This is for the studies and the preparation to get to the hard infrastructure.
Could it be for? I mean, I was reading through the statute, and I didn't see anything that really prevents funds from being used to run a water line.
I would make the argument that there's nothing preventing that, but I would also make the argument that's not what the target of the bill was for, if that makes sense. We use a lot of these as we go into reports when we submit for federal grants on a much larger scale, say USEDA or ARC or what have you. And so having these reports, having these studies out of the way allows us to go to the federal government to get the bigger dollars for the hard infrastructure.
Now, and I saw something in the statute about a 50% match.
Yes, sir.
Or one-to-one match. Is that, what is the match?
Currently it is a 50% match, and so if you have a $100,000 preliminary engineering report, you have to come up with $50,000 local match to do so.
Okay, thank you.
Yes, sir.
May I speak to the bill?
Gentleman
very
is
briefly? Mr. Speaker, I think this is a good bill. If you want to vote against economic development, this is a good bill to do it on. I mean, this is putting local money into, this is putting state money into the local coffers to be able to develop industries, factories, any sort of economic development. And, I just think this is a good idea. The statute, as the bill, all it does is raise the cap amount. It doesn't change the program substantially. And I think that this is a good bill to help local communities develop their best assets so that they can bring in jobs to their local economy. And I think this is a good bill to do that. So I would encourage it. But if you really don't want to do economic development and slow it down a little bit, this would be the bill to vote no on. Thank you, Mr. Speaker.
Gentleman from the 44th, Doggett Kirby is recognized.
Thank you, Mr. Speaker. There's a lot of new members in here since the last time we had a good economic development debate, so I'll just give you the cliff notes. You're going to hear the word economic development and think, oh, that sounds great. We're going to help small businesses, existing businesses in this state. We're going to help out the mom and pop restaurants, the local hardware store. No, I wish that were the truth. What we're actually looking to do, and this bill may be a little bit better than some of the bills we've passed through here in the past year, but what we're doing is we're ignoring the businesses within our states that are screaming out for help, for regulation reform, for lower taxes, for better schools, for better infrastructure, and we're taking hundreds of millions of dollars. That's not hyperbole, that's hundreds of millions of dollars a year, and we're pumping it into corporations, and with the promise of 100 jobs, 200 jobs, 300 jobs. While I understand, I think, the intention of this bill, the reality is that we've got states leaving, or businesses leaving this state at record pace. So I know there's 2 sites that are ready to be developed in Weirton and in Grant County, where we've lost almost 2,000 jobs in the past month. So instead of focusing on new corporations and new companies coming in, I think we should take care of the ones that are here already. Thank you.
Gentleman from the 41st, Doug Maynard's recognized.
Thank you, Mr. Speaker. Just want to briefly stand up and say, I want to address a couple of concerns that I've heard on the floor today. To my friend from the 1st, I share his affinity for local mom and pops. As many of you know, maybe you don't, I grew up in a small town called Mount Hope in Fayette County. And when I was growing up, we had numerous local mom and pop shops that you could go to. We went to as kids growing up, and those no longer exist. And they no longer exist because Mount Hope was a coal town. And as we all know, we can make the arguments about the federal government coming down on coal. We can make the arguments about technology, about the rise of other industries taking the place of coal, what have you. But the fact remains, Mount Hope was a coal town, and it left my hometown, and it left it desolate. And you can walk through that town now, and it is a ghost town. So I do share the affinity of my friend from the 1st for those local flavors, those local mom and pops, and I'm committed to do everything we can to make sure that we support those folks. As my friend from the 44th has said, I would make that commitment to you as well. What I will say is the two biggest challenges facing West Virginia today are our sites and our workforce readiness. And I know this because I have worked in this industry for quite some time now. And every single day we field calls, we field emails, we field messages from companies looking at West Virginia, looking at the good things we've done over the last decade with this majority that we've had, getting the regulations right, getting the litigation environment right, lowering our taxes, and they're excited about looking at West Virginia. But unfortunately, too often, when we get these messages, when we get these requests for what we have, we don't have the inventory to host some of these folks looking to move into our state. And so that's the purpose of the bill. We've got great land ready to be developed. It just takes a little bit of money. Some of these local EDAs, they don't have the entire capital to start down the path to get these sites ready. And so this gives them a little boost. And you know what? This isn't just for big corporations. This isn't just for Amazon. This could be for local mom and pops. And guess what? Rising tide lifts all boats. And so bringing more people into this state circulates more money into the economy. And guess what? Maybe it will support our existing businesses that way. But if we keep losing population, if we keep losing jobs, none of that matters. So I get a little animated when I hear this talk about, we're just supporting these big corporations and we're just handing out money to folks without taking care of our own. If I'm not mistaken, we passed the largest tax cut in West Virginia history last year. Thank you, Mr. Majority Leader, for your efforts on that. Thank you, Mr. Finance Chair, for leading your efforts on that. Thank you, Mr. Speaker, for leading the efforts on that. And every one of you that were here. And guess what? That's a pay raise for everybody, and that helps all of our existing businesses here. So we can walk and chew gum at the same time. It is not either or. It is not we're helping one at the expense of another. We can do it all, and we have been doing it all, but we've got to do a little bit more, and that's why I did this bill, and I hope you all will support it. Thank you.
Gentleman from the 9th, I got Barnhart's recognized.
Thank you, Mr. Speaker. I rise in strong support. Today on this bill, we're doing two of my favorite things. We're supporting economic development, and we're supporting our infrastructure. And I can point to various opportunities back in my district and back in my home region where we have benefited from this program and programs like it. There was a time in West Virginia where we had the desert island mentality. In other words, just leave the sites open, and if somebody wants to develop it, then they will. But we can't do that anymore, folks, because today we have to compete for economic development. And when they're looking at sites, as my friend from Wood County mentioned, they want them to be site ready. They want them to be ready to put a shovel in the ground and to provide real economic development for the people of our communities. And it's not just the large corporations, it is the mom and pops too. I can look back at projects in Pleasants County where we're trying to develop a nice little business plaza there on one of our former high school site, and we have benefited from programs like this. This is going to help not just the big corporations, but help the small businesses as well. It's a good bill. I hope you'll join me in supporting it. Let's move West Virginia forward, not backward. Thank you. Support the bill.
Gentleman to 47th, Longenecker is recognized.
Thank you, Mr. Speaker. For me, this is something that is a matter of principle. There's not one person in this room, I think, right now that does not want economic development to come to West Virginia. But as an 18-year-old who was learning about civics, who was learning as a teenager about how my country became one of the greatest countries on earth, I discovered something, and it stuck with me my entire life. And I've been around the world and seen countries that did not do it this way, and it solidified what I had learned as a teenager. And that's simply this. When you overtax American citizens, and in this case West Virginia citizens, to the point of budget surpluses, you've taken more from those businesses than what was needed to fund the basic essentials of government, and then you transfer that wealth from those people who earned it to these people who did not earn it. That's a socialist economic model, period. And I cannot support that here in America. So I'm a no on this. I want economic development, but I also want it to come about the way it did before we had all these free socialist giveaways to these companies that'll never plant their headquarters in West Virginia. And that's through a free market capitalist system. Thank you. I'm a no.
Gentleman from the 35th, Doug Vance is recognized.
Thank you, Mr. Speaker. Would the lead sponsor from the 41st yield?
Yes, sir.
So this is to help create sites or get sites developed for businesses to come in, correct?
Yes, sir.
Okay. Does it specify where the sites are that need to be?
Yes, under the Department of Economic Development, they have specific program criteria where local EDAs submit sites, and they're actually going through this process now. We passed this bill, I think, maybe 2 years ago, but the program is just now getting up and running, and there is a whole host of criteria that has to be met to become a certified site. And this bill that we passed and the money that we dumped in there in the last special session is helping sites around the state, come up to that criteria.
Okay, so I heard you mention Mount Hope. It
Yes,
being
sir.
a coal town and it being desolate. So does Mount Hope, is it a certified site for economic development to come into?
Not to my knowledge, but so the way the program works is the locals, whether it be private individuals that have sites or local EDAs, they work through the local EDAs to submit their sites to the Department of Economic Development, and then the Department of Economic Development puts them on the list and says, okay, here are the things you have that are correct and meet the qualifications, here are the things that you do not have yet, and then we want to help you get those up to speed as to where companies are looking to locate.
One more question here.
Yes, sir.
So if the local economic development authority sends in to meet these requirements and they have two things they need, are they guaranteed from our state economic development for them to get that for them, or is there another process?
I couldn't hear the last part of what you said. I'm sorry.
If the local economic development authorities have a list that you said of requirements and they lack, say, two things, they need help from the state, does the state economic development people, will the authority automatically help them out, or is there another process on who they choose?
Oh, I think their whole purpose of existence, part of their scope is to help those folks and those local folks and those sites get up to speed to where they need to be. This is a main priority for the Department of Economic Development.
Okay, thank you.
Yes.
Speak to the bill.
Yes, gentleman is recognized.
I kind of, want to and don't want to on this bill, but to me, he spoke of Mount Hope, my whole county, McDowell County, Mingo County, Logan County, Boone County. We passed the bill to try to help them out, and it's still sitting over in the Senate, probably won't be heard, but there's no guarantee that it's going to help. It may say, yeah, well, we'll come into these towns and help them, but then again, they may still just sit there desolate as ever. And then what you see on the economic development stuff that's going on, as we kindly heard a little bit, or maybe not, but is you've got navigable rivers that they want to go to because it's easy. They have border counties because it's easy. They have 4-lane highways because it's easy. But the ones that are needing the help the most, that is the hardest hit, that's in the middle of somewhere that don't have these things, they still are not reaching out to. And I don't think that this bill is going to reach out to those areas even more. I think that they'll still take the easy way out and the easy path, and they'll go to more on the border, which I'm okay with, and they'll go to more on the rivers, which I'm okay with, and more to have these roads, which I'm okay with. But I'm not okay with them still putting us under and not helping us out. So for that, I'm going to have to be a no on this. Thank you, Mr. Speaker.
Gentleman to 74th, Doug DeVault.
Thank you, Mr. Speaker. You know, I hear some of this, and to my colleague in the first, I'd really like to have some wings here in a little bit after hearing him talk about them. But I see the people in this hall and what you bring to the table. I see lawyers. I see coal miners. I see a lot of different professions. But we talk about helping the mom and pop stores. I am a mom and pop store. And I want to tell you, the one thing that helps me is customers. You cannot give my businesses money in a grant, $500,000, doesn't help me. What does that buy me, 6 months? I'm right back in the same boat I was in. I have to have customers. I don't think we realize the $25,000 in this, when we're changed to 75, what that does. $25,000 doesn't buy you around the corner, folks. We just built a new tire shop 2 years ago. In the middle of construction, we had the fire marshal come in and decide a 2-inch water line is not enough for our sprinklers. They decided 6-inch. Cost me $40,000 to upgrade about 100 feet of water line from 2-inch to 6-inch. So whenever we're going from a $25,000 grant to 75 for trying to get surveys, trying to get all the information that, as my colleague from Wood County said, to give to economic development people. If we don't have it, they're going to go somewhere else. I'm just kind of amazed. We talked about the mom and pop that got torn down, turned into a Wendy's. Wendy's pays big money for property. I used to eat breakfast every morning at a mom and pop little restaurant. Lady was there at 6 o'clock every morning. Someone came in and offered her $1 million for the property. What do you think she did? She retired. So we have got to have development. Money doesn't help the little guy. Yeah, taxes, reform with employees, yeah, I get that. That's all important. But we can't do grants to small business. That's not what we need. We need people. So for this bill, as my colleague from Kanawha County said, this is a good way to not vote for economic development. I'm a yes, a strong yes, and I'm kind of surprised at the no's. Thank you, Mr. Speaker.
Gentleman to 72nd, Doug Riley.
Thank you, Mr. Speaker, and thank you to the gentleman from the 41st District. He and I talked about this bill early on, and I do want to make one point very clear. This micro grant program, it is for the small counties. It's for the counties who don't have the funds to make those investments. Larger counties, maybe like the gentleman from the 92nd, they have funds. They can go to the matching program to where they can put money in and get matching money to do it. But the $25,000 that was originally in there was for the small counties, like Roane County, like Wyoming County. The gentleman who used to be here from the 15th was very specific in saying, what are you going to do for my county when we pass this bill? So if there are places that are underserved and don't have those opportunities, this is the bill you vote for. This is the opportunity that gives them the additional funds to say, you know what, maybe I can go take a piece of property through the voluntary remediation program so we can get it cleaned up. Maybe I can get that bat survey done so maybe I can lure someone there. So if you want to help the small rural counties who may be down on their luck, this is an opportunity to help them up. I urge passage.
Children of the 13th, Delegate Heckert's recognized.
Thank you, Mr. Speaker. Been a lot of good discussion today on this. What it may do, what it may not do, but what it may do is that no single site may receive any amount greater than $75,000. Not shall, may. It gives them a little room. There's a lot of counties need a lot of help. There's a lot of things that need to be done, and we're working on them one by one. But it may not receive any greater than $75,000. It gives a little more cushion to make things happen. I urge passage. Thank you.
Is there other debate on the bill? Gentleman from the 100th, Delegate Ridenhour is recognized.
Will the sponsor of the bill please yield?
Yes, sir.
So this is money that we put in last year.
Yes, sir.
About how much did we put in last year to?
Special session, I believe we put around $5 million.
Okay, but is this money from that $5 million, or is
Yes,
this
sir.
from our session last year?
No, this is from that special allocation from the special session last year, $5 million.
So $5 million.
Yeah,
Okay,
and just to
and-
reiterate, there is no increase in that $5 million or that budget. It is just increasing the allocation they can draw from that $5 million.
Okay, and then this money will then be allocated by the Economic Development Authority?
Yes, sir.
Okay, so they'll make the determinations as to which entities will receive?
Yes, sir.
Okay, so they'll centrally plan everything?
They will make the decision on where they put that money.
So
Yes.
we're then ceding that authority to this entity instead of letting businesses determine where they want to go, what they want to do, based upon market conditions, not based upon specific authorities from the Economic Development Authority.
Actually, the locals have to apply for this money. So it's not a top-down approach. It is a bottom-up approach because the folks at the local level have to apply to DED for these funds based on their needs and their site needs.
But economic development's the one that's going to make the ultimate decisions.
They will make the decisions as to where the money gets spent, yes.
Okay, thank you. Speak to the bill, Mr. Speaker.
Yes, gentleman is recognized.
So this, again, to me, looks like central planning, and this is something that really we've seen around the world over and over again, doesn't really work that well. We can couch it the way we want to. We can come up with rationales for why this will work this time. But central planning really doesn't work. If we want to see how economic development worked, we can look to the late 1800s, early 1900s, when there was an absolute explosion in growth in the United States because businesses were allowed to go unhindered in most cases from a government and any kind of central planning. So I think that we need to get away from this type of central planning. We need to allow the businesses in our state to grow. We need to cut our taxes. We need to cut, in particular, the regulations that choke off a lot of our businesses. So I'm a no on this. Thank you.
Gentleman the 12th to close debate on the bill.
Thank you, Mr. Speaker. How many of you been to Wirt County? How many? 5,000 people. Not one industry. The gentleman from the 11th knows that several of his employees from his place of work came from Wirt County. They came from Calhoun County. They came from Upper Roane County. What industries are up on the upper Little Canal River? None. Now, the opportunities down through the years, we've had, believe it or not, a manufacturer that manufactured emergency rubber craft for the Navy. That business, they were in the city of Elizabeth, and they were in the city of Grantsville. Now, They're not there any longer. And as the gentleman's talked about the problems in other parts of our state, sure, we understand that. And this opportunity that the gentleman from the 41st urged me, and it was an oversight on my part that we didn't get the bill on the agenda, and I apologize to him. But this is an important opportunity. As you've heard from the gentleman from Harrison County talk about, if you want to help these counties, I urge passage. You don't understand. My daughter is no longer teaching in Wirt County, but she taught there for 11 years in special ed. Wirt County is a lot alike a lot of your small communities. They're very clannish and very closed. I see the gentleman from the southern part of the state shaking his head. When a stranger shows up, the whole county knows it, don't they? They do the same in Wirt County. And during COVID, when the schools were closed, my daughter, who lives in Wood County, would go ride the bus to take food to those kids, her kids, as she called them, because they were special needs. And she took care of those kids. Now, we'd like to help those counties. And this is one of the tools that we can do that with. But don't take away, because you have a success story in the Eastern Panhandle or other places in the state, to take away from the opportunities for the central part of the state to be able to take advantage of this. Please, please, I urge passage.
Debate on the bill has been closed. Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine. Every member has not voted. Clerk will close the machine and ascertain the result on this question. There were 86 ayes, 13 nays, and 1 member absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 4822, creating the Certified Sites and Development Readiness Program.
Are the title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4883, relating to increasing annual salaries of certain employees of the state.
Are there objections to having the bill explained? In lieu of having it read, none are heard. Gentleman 12 to explain the bill.
Thank you, Mr. Speaker. The bill would amend the provisions of the West Virginia Code relating to the salaries of school teachers, service personnel, and employees of the state police. The bill would increase the annual salaries of state police personnel by $2,900, teachers by $2,460, and each classification listed in the code. The monthly salaries of school service personnel would increase by $140 for each classification listed in the code. I urge passage.
Question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman, the 6th, Douglas Stevens.
Thank you, Mr. Speaker. I'm asking for Rule 49.
Chair suspects a number of people are. At this time, the clerk will please prepare the machine pursuant to a request for a ruling by the chair under House Rule 49 on eligibility to vote on this question. Those members who seek a ruling from the chair pursuant to House Bill 49 on your eligibility to vote on this question based upon being a recipient of funds allocated under this bill will please register your request with the clerk by pressing your button. Has every member seeking a ruling by the chair pursuant to House Rule 49 pressed a button? If so, the clerk will record those names. It is a ruling of the chair that all members seeking a ruling for the chair pursuant to House Rule 49 constitute a class of greater than 5 individuals. Therefore, all members are eligible to vote on this question. The question still is, shall the bill pass? Is there debate on the bill? Gentleman from the 38th, Doug Ellington.
Thank you, Mr. Speaker. I speak in support of this bill. It does have a number of other individuals that will benefit from it. But as my committee had spoke earlier, we would like to see that the teacher and service personnel raises were back up to the 50th percentile. So we're going to keep working on that in the future, but it's every year we just keep doing this, raising incrementally. So, but I will support this bill, and I urge passage.
Is there other debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 99 ayes, 0 nays, and 1 member absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4883 relating to increasing annual salaries of certain employees of the state.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4919 relating to the Promise Scholarship.
Are there objections to having this bill explained in lieu of having it read? If not, gentleman to 72nd, Delegate Riley to explain the bill.
Thank you, Mr. Speaker. The bill will reinstate a Promise Scholarship Award for a student who receives the award but loses it. If he or she successfully reattains the credit hour and minimum overall GPA qualifications set out in the Higher Education Policy Commission's rule governing eligibility. This opportunity for reinstatement is only available to any student one time. And if reinstated, the student forfeits a term of eligibility for each term in which a student is enrolled to meet the renewal requirements as authorized by the bill. I urge adoption.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4919 relating to the Promise Scholarship.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 4945 relating generally to the Hope Scholarship Program.
Are there objections to having this bill explained in lieu of having it read? If not, gentleman 98, Delegate Espinoza to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to make several specific changes in the Hope Scholarship Program, including that the annual Hope Scholarship Program appropriation calculation will be based on the estimated number of participating students instead of the number of participating students in the prior year, and clarifying that providers may not assess increased or additional fees against Hope Scholarship students based on participation in the program. It clarifies that Hope Scholarship students have the same educational privileges and access to programs available to other non-public school students. The legislation also clarifies that qualifying expenses may only be spent on K through 12 programs, that a charter school may invoice a Hope Scholarship student's account for services rendered consistent with all other public schools. It permits the state treasurer to designate a proxy to attend board meetings, as with every other board that the treasurer chairs. It requires parents to notify the board if a child re-enrolls in public school or completes secondary education so that the board may terminate participation in the program. It exempts all records maintained by the Hope Scholarship Board containing personally identifiable information of a Hope student, parent, or applicant from the Freedom of Information Act. It eliminates the requirement that nationally normed achievement assessments used for yearly academic Hope reporting include scores in science and social studies for years when those subjects aren't tested. It permits the board to promulgate rules for the auditing of education service providers, and it requires education service providers to certify the results of background screenings of employees. That's the bill, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on this bill? Gentleman, the 25th, Delegate Hornbuckle is recognized.
Thank you, Mr. Speaker. Would the gentleman from the 98th yield?
Yes.
Thank you, sir. First question I have, sir, is on page 2, line 7. Let's see here. So with the estimation that you speak of, What's the formula for the estimation?
Essentially, and I'm moving to the page now, essentially on December 10th of each year, the Treasurer's Office would be able to make an estimate. And the purpose of that provision is to recognize that because each year under the enabling legislation that this body has previously passed, under that legislation, there's a new kindergarten class that's coming in every year. So, I mean, that almost guarantees that there's going to be additional participants each year based on the experience that we've seen in the first few years of the program. The issue with the way that the appropriation request is currently made is it's based on last year's enrollment. And with a new kindergarten class coming in every year, you're always going to undershoot what the appropriation request will ultimately be, and it'll probably necessitate, in many years, a supplemental appropriation. This just helps ensure that that request is closer to what the actual participation rate looks like.
Yes, sir, and I appreciate, you actually took care of my next question, because I was going to ask who is going to do the estimation, but I don't think I found an answer on the first one. Is there going to be a formula, again, for that estimation, or is the Treasurer's Office just going to pick the number out of the sky?
I believe they base that on applicants is what they'll do. You know, the applicants that they receive from the time of last year's enrollment to to December 10th, they'll base it on that. And as the current code provides, it's the board that actually will make that request or that estimate.
Yes, sir. And is the Hope Scholarship Fund, is that housed in the Treasurer's Office?
They administer the program.
Okay. If we scroll down here on page 8, on subsection E, to notify the Hope Scholarship Board immediately and cease use of the Hope Scholarship funds upon the student's re-enrollment in a public school or when the student graduates from or otherwise successfully completes a secondary school program. So that was added language. And so was that added language, was that there to clarify that they couldn't use the funds after graduation or re-enrolling, or was there a loophole before? Is that why that language is added?
It's essentially just to clarify that the Hope Scholarship is to be used through K through 12 programs. It also, again, requires that parents let the board know if they do re-enter public school, or let's say they graduate early and are no longer eligible for those funds. It just clarifies. Much of this bill, frankly, is just clarifying language based on just the early implementation of the program by the Treasurer's Office.
Yes, sir. Scroll down to page 13.
And may I just add?
Yes, sir.
Currently, according to the Treasurer's Office, there's really no way for the board to know if a child graduates early. There's often a delay in learning that a student has returned to public school. And again, this puts the responsibility on the parents to notify the board of these disqualifying events.
Yes, sir. On page 13, line 15, subsection 2, it talks about testing requirements. And it strikes the language on reading language, mathematics, science, and social studies, and just says tested. And so are they no longer tracking those core areas on their testing requirements?
So again, to be clear, the bill eliminates the requirement that nationally normed achievement assessments used for yearly academic hope reporting includes scores in science and social studies, because there are years when science and social studies are not included in those tests. So this just makes it very clear that in those years that those tests are not administered, they would not be required to report it.
Okay. And we are adding micro schools to this piece of legislation, correct? And they were not prior in the code?
Could you reference that section of?
I believe it's on the first page where we added new language for micro schools. Bear with me, I'm trying to find. Yeah. In the definitions for a participating school?
It does include microschool, that's correct.
And it was not included before, correct?
Apparently it was not. That's a clarification that it would apply to micro schools as well.
Yes, sir. Thank you.
You're welcome.
Permission to speak to the bill?
Yes, gentleman is recognized.
Thank you, Mr. Speaker. Colleagues, I had a member, actually from the 41st, he talked earlier about being able to do two things at once. And I think that we can both support our public schools and have the Hope Scholarship, but we are working on limited funding. We are working on limited funding. I would suggest to the body, before we are set to increase the number of Hope Scholarships, that we strongly consider another revenue enhancement measure, because we are running out of money. I talked about yesterday on second reading, the way the Hope Scholarship is currently set up, it steals money out of every single person's district. It takes money away from your private schools, from your pods or micro schools, and sends them out of state. We did not close up that loophole. We are literally funding out of state schools. That is very problematic with the Hope Scholarship. We are in a crisis. Earlier this year on this House floor, we did not elect to try to help with special education. We have a lack of special education teachers in our system. We have not afforded them the dollars yet. But here we are going to expand this. I just find this as a step backwards, and it's not good for our students. I know that in Jackson County, Wayne County, because of the Hope Scholarship, they have lost teachers. We've done a good job today on voting on some economic development measures. I would submit to you all that taking teachers' jobs, because the schools no longer have the funds, is going back on economic development. What are we doing here? There is a way to do this, but this is not the way. We have to pause and tread with caution. We are in a crisis right now. We have some unintended consequences. I'm afraid that we're going to further go down this hole. I would also submit to you that we had a ruling by our Supreme Court. We had a ruling by our Supreme Court, and Justice Hutchinson said that the West Virginia Constitution provides that the legislature's obligation to provide a thorough and efficient education is limited to doing so only by a system of free schools, not through subsidizing private educational systems. We are not upholding the first end of that bargain. If we continue to erode public education, they cannot be thorough and efficient. By this piece of legislation, opening it up to the estimation and no longer the enrollment, we are going to explode the number, which is a fact. Our public education system cannot be thorough and efficient if they have less dollars, if they have teachers losing their jobs, and the schools not being able to deliver a thorough and efficient curriculum. I would appreciate if you all uphold the West Virginia Constitution and vote this down.
Gentleman, 99, Dr. Clark.
Thank you, Mr. Speaker. My colleague, I appreciate his passion for this. Folks, 2 points. All right? 2. Number 1, if there is no kid in the school, there is no funding for that school. All right? No kid, no funds. Number 2, parents' choice, where they want their taxpayer education money to go. Thank you.
Is there other debate on the bill? Does the gentleman from the 98th wish to close debate on the bill? Gentleman from the 98th, close debate on the bill.
Just briefly, Mr. Speaker, to my friend from Cabell, I would note that the board currently approves
scholarships for those students attending micro schools. So this is not really a change in policy. It essentially just syncs up the code to reflect practice that's spelled out in other sections of the code. I do find it a little bit surprising that my colleague from Cabell would oppose this legislation when his county, Cabell, actually has one of the greatest number of students participating in the Hope Scholarship Program. And again, what bottom line is this program is about student-centered education, allowing parents and students to choose what is best for them. I'd urge passage of the bill.
Debate on the bill has been closed. Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 76 ayes, 21 nays, and 3 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 4945, relating generally to the Hope Scholarship.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4956, creating the Oral Health and Cancer Rights Act.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. And the lady from the 73rd, Douglas Summers, is recognized to explain the bill.
Thank you, Mr. Speaker. This bill requires all health benefit plans to provide coverage for procedures that are necessary for the treatment and management of oral cancer. West Virginia ranks #1 in oral cavity and pharynx cancers. The coverage will help restore whole or partial function associated with eating, breathing, speaking, and swallowing related to a cancer diagnosis. Can you imagine having your tongue removed because of oral cancer, but then your insurance doesn't pay for an artificial tongue? I can't. This act only applies to procedures necessary to receive cancer treatments or are the result of cancer treatment. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 1 nay, and 3 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4956, creating the Oral Health and Cancer Rights Act.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4975, relating to establishing a foster parent information system.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. And Gentleman 97, Douglas Hardy, is recognized to explain the bill.
Thank you, Mr. Speaker. The bill would incorporate a foster parent and kinship parent information system into its existing child welfare information technology system. The bill sets forth the requirements for the new foster care portal system, and the Department of Health must share its analysis of the responsiveness of child protective workers using the system with LOCIA every quarter beginning July 1st of 2025. That is the bill, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman 17, Douglas Pinson.
Thank you, Mr. Speaker. Good morning, colleagues. I rise today not to ask you for your vote, but rather to explain what we're voting on. Last year, we considered this bill and it passed 98-0. I would anticipate the vote would be similar to that this morning. Rather, I want to just explain very briefly what we're voting on. I need to be very transparent with you when it comes to broadband. I recognize that there's an issue. I understand that it's serious for our state, it's serious for economic development, it's serious for our constituents, but I don't know how to fix the broadband issue. I know it's a problem. I know we've got to address it, but to be honest with you, I don't know how to fix it. Well, I'm afraid that foster care in West Virginia is very similar situated. We understand the obstacles that are facing child welfare in our state. We understand the obstacles that are facing foster care. Many of you acknowledge those and say, yes, we realize it's a problem, it's a crisis, it's got to be fixed. but many of us fall short on how to fix it. I would suggest that this piece of legislation that's before us today is a monumental step in addressing some of the problems that are facing West Virginia foster care. Presently, there's 6,078 children in foster care in West Virginia, 6,078 children. These children deserve excellent care. These are children that the state of West Virginia has intruded into their life, oftentimes for excellent reason, and we have taken custody of them. They deserve excellent communication surrounding where they're going to spend the rest of their young life, where they're going to spend their life until they turn 18 years old. I don't think that there's anybody in here today that would argue that when a child is in foster care, the entities that surround where that child is going to spend the rest of their life, they should communicate. They should communicate very well with one another, like CPS, the child placing agency, the school system, the court system, the transportation services, the foster family, and the biological family. All of these individuals and others are stakeholders in that child's life. It's not very well known that these stakeholders, in many cases, they don't communicate well at all with what's going to happen with that child's future. I'm afraid that we have entered into this lull period with West Virginia child welfare, where we acknowledge the problem from many different angles, and we realize it's bad. But oftentimes we don't know how to fix it. Can I suggest to you today that this bill fixes much of the communication surrounding West Virginia foster care? This bill facilitates excellent communication. I would ask for your yes vote. I would ask for your support in this effort as we strive to not just acknowledge the problem, but press toward a solution for the children of West Virginia. Thank you, Mr. Speaker.
Is there other debate on the bill? Gentleman from the 52nd row is recognized.
Thank you. Would the gentleman answer some questions for me?
Yes, sir, I'd be glad to.
As I understand the bill, it applies once a child's been taken out of its home and it assumes a foster care status. Is that correct?
Yes, sir, that's correct.
And there's a whole bunch of services and communication requirements that are in the bill, and this will help that child and services to be provided to that child, correct?
Yes, sir, that's correct.
Now, is it also correct that we really don't have anything in place that protects children and families before a court petition is filed to remove the children from the home?
So you would be suggesting like the central intake line would receive a report and CPS would acknowledge that there's services that could be utilized, services that could be used to improve this family situation, the foster child's, or the child at that point would be a foster child, but the child, but that child's not actually removed from the home? Is that what you're referring to?
Well, I'm just trying to figure if there's anything in the bill that would address what I perceive as a serious problem of us not providing services to families before a petition is filed. Now, once the petition to remove the children from the home is filed, then there are services that are provided. Legal services are provided, social work services, and a number of people come into play, but by that time it may be too late. Like, for example, if a family had a housing problem and they lost their housing and they became unhoused, then merely getting them housing may be sufficient to keep them from being divided as a family.
No, sir. To your point, this bill would only apply to children who come into state custody and either by foster placement or kinship placement become what we commonly refer to as a foster child. To the gentleman's credit, though, you have long suggested that those support services, some of those counseling services, should be made available prior to the petition actually being filed. And on that point, you and I would agree. Yes, sir.
All right. Thank you, sir. Thank you very much.
Gentleman's
May I speak to
recognized.
the bill? Mr. Speaker, this bill is a good bill. It's a bill that everyone should vote in favor of, but we're still not helping the children who are in families in distress, who may have one problem such as housing or something that's a matter of neglect in the sense that the parents don't have jobs that would let them pay for housing and to keep the kids and the family together. Those services are not being provided by the state. The services for attorneys and guardian ad litems and that whole big process in the court system occurs once a petition is filed. And in a lot of instances, the family gets split up just because of their circumstances and not having services available. This bill will help make sure that once a child is removed from the home, that the information's provided and that services can be provided that are particular to the child. So the bill itself is very good, but it's only one step. We need to take the other step and help these families before they're split up in court in abuse and neglect proceedings. I'm told that something like approaching 50% of the time of circuit courts is now taken up by abuse and neglect proceedings. And whenever we hear a statistic of 6,078 children in foster care, how many court cases is that? Pretty close to that. I would wager we're over 5,000 court cases to produce that many children in foster care. So there are lots of folks who are just getting lost in the cracks of our system, and I support this bill wholeheartedly. I hope that next year the legislature can take some positive actions to help the families in distress before a petition is filed in court. Thank you, Mr. Speaker.
Gentleman to 42nd, Douglas Steele.
Thank you, Mr. Speaker. Good morning. Yeah, the gentleman from the 52nd stole a little bit of my thunder. That was kind of what I was getting at. You know, I figure we're all going to vote for this bill because it's about communicating with foster parents and everything else. I've seen a lot of bills along this line come along this session and the last couple sessions, and the thing that keeps getting brought up is CPS isn't doing this, CPS isn't doing that, CPS is dropping the ball here, CPS isn't communicating very well. And I think when we look at the number of people in foster care, or the number of kids in foster care, and the number of people involved in our court system through abuse and neglect cases, and the lawyers that get piled upon with court appointments to take care of these cases, you know, you kind of step back and you take a look at it. It's like, why are we going through this? Why are we blaming CPS for a lot of these problems when all they're really trying to do is address the problem sitting in front of them that they didn't create? I would say to you today that the problem is that we cannot legislate the hearts of man. We can't do it. We can't change a parent's heart and make them be a good parent. We can't get them through the court case to where they have to make the decision for themselves to make that life change. I don't know that any number of information systems or anything else is going to change that. What could really change that? And one of the kind of the sayings that I have when I'm going to court for these abuse and neglect cases, another lawyer will see me and will say, "Oh, what are you up to today?" And I say, "Oh, you know, highways and hedges, seeking to save that which was lost." And we kind of joke about it because it's essentially charity work that we do so much. And the gentleman's right, it's 50, 60, 65% of court cases in a lot of jurisdictions.
And I think about that statement, and I think, well, what about the preachers out there? What about the churches out there? It used to be that the church would come in and take care of somebody's kids and make sure that they were getting fed, and if somebody wasn't taking care of their house, wasn't making sure the kids were getting to school, or somebody was beating on the kids or something, the church would step in and do something like that. So maybe if we could stop blaming CPS for doing the job that we've sent them out there to do, unarmed, undermanned, underfunded, with an unfulfilled mandate, an unfulfillable mandate, that they somehow magically pull out a magic wand and make all these people act the normal that we consider. I think if we're really going to have change in the system, we've got to start evaluating two things. One, your society is going to have to start caring. You're going to have, your people back home are going to have to get out of their church pews and go out there and go knock a door and go help out somebody's kid. And go help out a single mom that is so worn out that she's not keeping it all together. They're going to have to get out of their church pews and quit judging people and go actually help somebody. The other thing that we're going to have to do is we're going to have to get our heads around the concept that we are not legislating that people be good parents. We need to legislate that they be safe parents. Our judgment as to what the quality of a parent is not going to apply the same way throughout the state and everywhere else. And this goes back to the basic training of social workers, the basic training of attorneys, that we get down this path of once people get involved in this case, that in order to get their kids back, they have to live a life for 18 months that, one, is completely foreign to them. It's nothing they've ever seen before. But two, they have to live closer to the cross than probably 99% of the people in here. Putting them through an impossible task, something that they've never lived before. And what resources have we armed CPS with to help take care of that problem? An information system. Now, that's great. That's great. We want to complain about them not doing their job. We want to complain about them not getting the results we've seen, when at the same time, we have created financial incentives for the destruction of our families. People get adoption bonuses when these families fall apart. There is a financial incentive to destroy the nuclear family sitting in law right now. And what we've got to do in here is start caring more about putting that nuclear family back together. Not just caring about it as legislators, but caring about it as a state, as a society. The destruction of the nuclear family is the worst crisis facing this state and this nation today. And we do nothing but feed into it. By charging CPS with dropping the ball, with charging, foster placement agencies with dropping the ball. My goodness, we have created financial incentive. We created an industry out of destroying the families of this state. And set up impossible standards for people to parent by. And who does it affect most? The impoverished. We're not taking the kids of upper white middle class people. That's not what's happening. We're taking the kids of the most vulnerable, the most undefended. And I would tell you, if we're going to see real change in CPS, we need to start doing exactly what the gentleman from the 52nd brought up. Pre-petition services. Actually getting into the houses and helping folks out. You got a dirty house case? One hearing with 7 private attorneys costs more money than a call to ServPro to go over and clean that house up and try to keep that family together. But we won't authorize that. We ain't got a bill for that. We're going to create a computer system that's going to do absolutely nothing to help that family stay together. If we really care about the nuclear family and we really care about those kids getting raised in a household by people that absolutely love them, let's start supporting the families. And let's incentivize CPS keeping a family together rather than tearing it apart and paying adoption bonuses and everything else to destroy families. Because I'm telling you what, if we don't figure it out here in the next 12 to 18 months, the federal government's going to come in and figure it out for us. Because we are taking kids from their parents at a clip that is alarming. Alarming. And for some reason, we don't seem to have a huge problem with that. We've got to get down to the fact that what we care about is that we have safe parents and we have kids in safe environments, not dictating a quality of parenthood that I would say that even the majority of people in here couldn't live up to if they were to go through a case like that. To go to work every day, have to take a drug screen on the job, at times during the job. Your employer knows what you're going through. Everything else. We're putting people that aren't used to keeping a calendar into a situation of living the most Andy Griffith life you can possibly think of. And it is a foreign idea to them. And if we're going to see change, we've got to do something pre-petition. Not just here in the legislature, but out there in the streets too. The neighbors need to get up. The folks at home need to get up. We are never going to legislate the hearts of man, only their actions. And folks have to wake up and take care of that. Maybe this information system is just going to be something that knocks your socks off, like, Chat GPT or something like that. I don't know. But I have a feeling we're going to have the same number of kids in foster care, and we're going to be still taking them at the same clip, and we're going to still be destroying those nuclear families at the same clip, regardless of this passage or not. I'm going to vote for it. But I think it's a good opportunity while we're talking about this. If we're going to focus on this going forward, we have to change our mindset to keeping families together, which is something I believe 100% of the people in here actually believe in. But we're not pursuing that policy, and that's what we need to pursue. Thank you, Mr. Speaker.
Gentleman, the 22nd, Doug Linville.
Thank you, Mr. Speaker. First, I rise in support of the bill overall, and I appreciate the impassioned speech of my friend that just spoke. The lead sponsor and co-sponsor, first co-sponsor, have put a lot of work into this, and I certainly appreciate that. I think what they're endeavoring to do and what they're endeavoring to place in the law is a very, very good thing for those among us who find themselves in the most difficult of circumstances. And I think that's good work, and I think that it should be applauded, and I certainly think that we should pass the bill. I am reviewing the fiscal note, though, and I just want to draw the body's attention to something, that when we write a law, if it's never enacted, it does no good. And I would ask that should we enact this into law, that you take a close look at this fiscal note and you see exactly what and why and how that this is supposed to happen. Supposedly, they've reached out to the vendor for the PATH system, a system that's been utilized supposedly for 8 years and never been fully implemented at a cost of $400 million. It's my understanding when we were questioning about that in the Finance Committee last year during their budget hearing. And it appears that this child welfare communications vendor has been discussed with the very vendor that's never fully implemented what the law was and what the order was back in, I believe it was 2014 or something like that. It was years and years ago. So I would add a word of caution to the members, please, that in the interims, as we can consider this in Health and Human Resources accountability, and would ask the chairs to watch the implementation of this law and actually make sure that it gets done, not 7 years from now, not maybe, possibly, eventually, but actually do it. Because if not, it won't be worth the paper that it's been printed on. So with that, Mr. Speaker, I do urge passage, and I actually urge implementation. Thank you, Mr. Speaker.
Gentleman, the 35th, Doug Vance.
Thank you, Mr. Speaker. Permission to speak on the bill?
Yes, gentleman is recognized.
I rise today in support of this bill as a proud foster parent and now adoptive parent. we've had placements, just a story I'll tell everybody. I know this ain't the cure-all, and I do appreciate the gentleman from the 42nd saying that we need to do a lot more work, and we do. But I think this is a step and a start in the right direction. We've had placements, foster placements in my house from the state and from one of the agencies. And the agencies, when they come in, they are very good. They give you all the information that you could ask for, plus. They give it to you, they hand it to you, they'll sit there and answer any questions, they'll talk to you about it or anything. The state, when they come in, they said, here's the kid, 5 minutes later, they're out there. We had a kid that had a medication. We were told they were on no medication. We get in their bag, there's a medication that was prescribed to that kid. We didn't know what it was for. We called the state worker and said, hey, we found medication in this kid's bag, prescribed to this kid. Or was it prescribed to him? It was the answer we got. We said, yeah, give it to him. It's all right. It must be good for him. That's what we got. This system will put information in there like that so we know, so that they can be pulled out, so the foster parent knows good if a child's on medication, so they know what to give them and how to give them and if it's all right to give it to them. Not just, if it's prescribed to them, give it to them. And as far as work through the community, I'll say this as a proud preacher, former pastor, the little small community churches in my area reach out every day to families, give families food, do what they can for families, but these small community churches don't have the money that the state of West Virginia has. We have old people that has limited income, and for him to, or for the gentleman to say that, we need to reach out more, but some of us is reaching out all we can. I'm just saying. So I'm going to be in big support of this bill. I think it's needed. The information needs to be out there on the child. What's wrong with it? We had that same placement that had that medication, had a lot of severe mental issues that we had no idea about, had no idea how to help. Didn't know what doctors they'd went to, didn't know who to reach out to or anything. And it was a big concern for a month that we had this child on how to get it the proper help. This information system will help us know at least a step to get to. Thank you, Mr. Speaker.
Lady in the 31st, I got Mazaki.
Thank you, Mr. Speaker. I appreciate the work that the lead sponsors have done. We have worked on this all summer long in the foster care work group. These are communication issues, and they need to be taken care of. And I think this portal will really help us to get this done. Mr. Speaker, I would love to ask for unanimous consent to be added to this bill 4975.
Is there space available on the bill? There is space on the bill. Are there objections? No objections are heard. Lady will be so added.
Thank you.
Gentleman is 64th, I got Burkhammer.
Thank you, Mr. Speaker. So it's kind of been insinuated that we're not working on other things. It's been insinuated maybe that we don't care about things. I look around the room and see a lot of people that do care. I see attorneys that serve as guardian ad litems, using their expertise to try to help the system. I see school teachers that combat this on a daily basis, dealing with the trauma from foster care and trying to help. I see medical professionals in the room that are serving in their communities and helping in every way they can. I see foster parents in the room, adoptive parents, that are doing what they can to try to do it. I see a room full of people that care. And I see a list of bills just today that are 50 deep, that deal with individual issues. We don't pass singular bills in this body. We don't pass just 10 bills and say this is what we're hanging our hat on. Each of us have the opportunity to draft bills as we see fit and work on them. To fix individual issues
that are near and dear to our hearts, to our communities, and to our families. Each of us have the opportunity to step back and say somebody else can fix it, or we have the opportunity to stand up and say, I'm going to try to fix it. And I can promise you I'm not an expert on a lot of things here. I like to share my opinion like I am, but I can promise you that I'm not. But on this issue, I've lived it. I've been given children saying, take care of them, with no background. That doesn't mean that I don't care about all the other issues. That just means that this is an issue that is near and dear to me. And it is a problem. Go talk to every foster parent, not just the ones in this room, and they'll tell you they want communication so that they can care for the child. When we look at some of the things that are in this bill that say, like, the medical records of the child, why would we need them? Maybe because we need to know, have they had their vaccines? Have they went to the doctor? What medications are they on? Who's the doctor they've been seeing? So that we can provide continuity of care so that the child is healthy. There's a lot of work to be done in foster care. There's a lot of work to be done in fighting drug addiction. I really firmly believe we want to fix foster care, fix substance use disorder across the state. Cases will drop dramatically overnight. So I will agree that this is kind of a back-end solution, but there is really a problem. And so I'm going to urge passage of this bill not as the entire solution, but in helping in this area. Once we have removed those children, we want to make sure that that care and communication is thorough, is in depth, so that these children can be healthy. And I believe firmly that this will help throughout the entire system. Why is that? Go talk to a department worker today. Go talk to CPS. Ask them what their caseload is and how they communicate with those folks. Facebook Messenger, text message, email, phone call. How many people? 6, 7, 8 people I've got to call in every case? How long does that take? Just imagine the streamlining of a technology system that would allow you to input data, type it in one time with your report that you have to do, and it just poof, it goes to all 8 of those people. Imagine the time that would save. And imagine a technology system and how streamlining a technology and utilizing technology streamlines a process. If we don't think that'll work, maybe we should turn in our laptops and go back to paper copies. Down in the basement getting paper draft bills and things. We've recognized it just in this body, how technology streamlines things. And I will also say that this is just the beginning. This is the first step in what I believe can begin to grow once we see that this works and how this communication is streamlined and how it makes everyone's life more efficient. I believe that it's going to grow into various things, one of them being pre-petition, biological families, how their process works. I created this bubble sheet, and I know I haven't shared it with everybody, but that this is just the first cog in the wheel.
that once it's proved how technology runs in this system, it can grow and it can bring other people into this system and ultimately helping across the board. So yes, I am passionate about this, just as each of you are passionate in your individual fields and expertise. I believe it's life-changing. I urge passage.
Gentleman to the 13th, Doug Heckert.
Thank you, Mr. Speaker. My good friend from the 75th and I always talk about who does it help, who does it hurt. We have an opportunity to help all of the kids in the CPS system by holding everybody involved accountable for when they're supposed to be there, when they're supposed to be in touch, who knows who did what, who's next, who's on first, and who's on third. It's not that hard. It's not going to fix everything, and it's not going to be perfect. I sat in a hearing a week ago over my grandson. 12 people assigned to look after a 2-year-old. And 5 of them had never seen him, had never been around him. All they knew is my son is in trouble, his mom is in trouble, my ex-wife and I have the baby, and we're taking care of him. I don't need their money. I'm fortunate. But what I do need is a system for every kid that is held accountable for what they're supposed to be doing and when they're supposed to be doing it. It's not about personal interest. It's about what's right by the kids. There's been a lot of good discussion on both sides, all sides. Bottom line is we've got to start somewhere and making a difference. It's not all CPS's fault. They're undermanned, the underwoman, they don't have enough staff, they don't have enough this, they don't have enough that. This will help them be more efficient in looking after little people that depend on someone to do what's right, to make them safe, secure, and prosper. I urge passage. Thank you.
Gentleman from the 54th, Doug Pushkin.
Thank you, Mr. Speaker. First, I believe this bill is going to pass unanimously, and I appreciate the body for voting in that way, how we're going to vote, and I appreciate the lead sponsors and so many people in here who I think everybody in here cares deeply about this issue, especially those, many of you have opened up your homes to children in state's custody and done your part, and deeply appreciate that. And of course, everybody in here has a chance to introduce bills to address the greater issue, whether that's addressing substance use disorder, adverse childhood experiences, all these other issues that we could be addressing. So I'm glad we're having this discussion right now because we hear very little about it. It's one of the most pressing issues in this state, so I'm glad we're able to have this type of discussion on a bill that's likely to pass unanimously. And we all have the ability to introduce those bills, but the sad reality is most of those bills don't make an agenda, and if any of those bills have a price tag attached to it, they don't run. So keep that in mind as we applaud ourselves here next week for passing a flat budget, because that means we're not addressing the issues. You know, a great president once said, "Don't tell me what you value, show me your budget." So we're all going to vote for this bill, but we all know there are greater issues that need to be addressed if we're going to reduce the number of children in state custody. And I hope at some point we can work on it and show people what we really value by actually budgeting for it.
Gentleman to the 35th, Doug Advance.
Mr. Speaker, I ask to be added as a co-sponsor, or unanimous consent to be added as a co-sponsor on 4975 if there's room.
Is there space available on the bill? There is space on the bill. Are there objections heard? No objections are heard. Gentlemen will be so added. Is there further debate on the bill? Gentleman on the 12th to close debate. Gentleman on the 97th to close debate on the bill.
Thank you, Mr. Speaker. First, just a point of clarification. When I've read the bill, I said Lucia, and it would be they'd be reporting to LACRA. So I wanted to make sure that I clarified that. I just want to talk a little bit about what the discussion and the spirited debate that we've had here this morning about this bill. I'm sure this bill is going to pass unanimously. I appreciate the work from my friend from Mason County and my friend from Lewis County who have just worn me out this session to make sure that we were going to get this on the agenda, and we did. And to my friend from Raleigh, it's true. We are never going to legislate morality. Not this body, not anybody will ever legislate morality or personal responsibility. It is something that is lacking in our communities today, and it's very unfortunate that we are in the situation that we are in with our foster care system. But I do believe that this piece of legislation is one more cog in the wheel that is going to help communication from foster families. I think that it's important that we implement this. I do agree with my friend from the 22nd who said we do need to watch this. We do need to make sure that this is implemented. We do know that sometimes state agencies don't always act in the legislation that we pass, or are slow to act on the legislation that we pass. So I would tell all my friends that'll be here next year, make sure that we're doing our due diligence to make sure that this is enacted. And I'm sure our foster care families will keep us informed that that's not happening. But with that being said, Mr. Speaker, I urge passage on this piece of legislation. Thank you very much.
Debate on the bill has been closed. Question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 100 ayes, 0 nays, 0 absent. A majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4975 relating to establishing a foster parent information system.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. For what purpose, the gentleman to 47 seek recognition?
Thank you, Mr. Speaker. Request unanimous consent to return to the second order of business for a brief interjection.
If there's no objection, we will return there in 10 minutes at 11 o'clock for
Thank
everyone.
you.
Is that okay?
Sure, thank you.
Okay. Further action on committee substitute for House Bill 4975. If not, clerk will please communicate. There is. Gentleman from the 96th.
Mr. Speaker, I move that the bill take effect from passage.
All right. Question now before the House is the gentleman's motion that committee substitute for House Bill 4975 be made effective from passage. Those in favor of the gentleman's motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 97 ayes, 0 nays, and 3 members absent. 2/3 of members having voted in the affirmative, the chair declares that bill effective from passage. Clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5077 establishing residency requirements for candidates seeking nomination and election to United States Congress.
Are there objections to having the bill explained? In lieu of having the bill read. No objections are heard. Gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. This bill amends the code to provide a residency requirement for United States candidates, United States House of Representatives, as follows. No person in this state shall be eligible to appear upon a ballot in any primary or general election as a printed candidate to secure a seat in the House of Representatives in the Congress of the United States who has not previously established and maintained a primary residence within the congressional district from which he or she is to be elected for at least 1 year preceding his or her election in accordance with the requirements of this section. That's a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5077 establishing residency requirements for candidates seeking nomination and election to United States Congress.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. Gentleman from the 96th.
Mr. Speaker, I move that the bill take effect January 1st, 2025.
The question is now on the gentleman's motion that the bill take effect January 1st, 2025. Those in favor of the motion will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 95 ayes, 0 nays, and 5 members absent. 2/3 of members having voted in the affirmative, the chair declares that bill effective January 1st, 2025. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5137 relating to requiring the state auditor to conduct audits of all county boards of education.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 68th to explain the bill.
Thank you, Mr. Speaker. The purpose of the committee substitute is to require the state auditor to conduct a financial assessment of each county board of education at least once every 6 years. This financial audit shall also include an evaluation of any county board of education use of local government purchasing cards, as well as an assessment of internal controls. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 98 ayes, 0 nays, and 2 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5137 relating to requiring the state auditor to conduct audits of all county boards of education.
Are there title amendments?
Delegate Phillips moves to amend the title.
The question is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it, and the chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5188 relating to awards and benefits for duty-related disability in the municipal police officers and firefighters retirement system.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman 12th to explain the bill.
Thank you, Mr. Speaker. This bill would amend provisions of the West Virginia Code relating to disability benefits provided in the West Virginia Municipal Police Officer and Firefighters Retirement Systems. The Committee on Finance reported a committee substitute that provides a partial disability benefit similar to the one provided in the West Virginia Deputy Sheriff's Retirement System. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 99 ayes, 0 nays, and 1 member absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5188 relating to awards and benefits for duty-related disability in the municipal police officers and firefighters retirement system.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5192 relating to requiring the Board of Pharmacy to promulgate rules.
Are there objections to having this bill explained in lieu of having the bill read? If not, gentleman 68 to explain the bill.
Thank you, Mr. Speaker. House Bill 5192 gives the Board of Pharmacy the authority to promulgate rules to order, test, screen, and treat a variety of health conditions, including Group A, Streptococcus pharyngitis, respiratory illnesses, lice, skin conditions, and other emerging and existing public health concerns identified by the Board. A pharmacist operating under this section may use any test waived by the Federal Clinical Laboratory Amendments of 1988, the federal rules adopted thereunder, or any screening procedure established by statewide protocol. A pharmacist may delegate the administrative and technical tasks of performing a test waived by the Clinical Laboratory Improvement Amendments to an intern or pharmacy technician under their supervision. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 2 nays, and 2 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5192 relating to requiring the Board of Pharmacy to promulgate rules.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5194, requiring purchases of certain commodities and services from state use program partners.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman 68 to explain the bill.
Thank you, Mr. Speaker. House Bill 5194 removes the permissive may and requires that the director purchase commodities from in-state nonprofit workshops. The bill further provides that the director evaluate the value of the available commodities and services with the advice of the committee on the purchase of commodities and services from the handicapped. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the gentleman on the 51st. If so, the clerk will close the machine and ascertain the result. On that question, there were 99 ayes, 1 nay, and 0 absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5194, requiring purchases of certain commodities and services from state use program partners.
Are there title amendments?
Delegate Phillips moves to amend the title.
The question now is the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5213, to allow Gold Star spouses to receive one free Gold Star vehicle registration for personal use.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. The gentleman 22nd, Douglas Linville, is recognized to explain the bill.
Thank you, Mr. Speaker. The short title of the bill is sufficient to explain the bill. It simply allows the surviving spouse of a fallen service member who fell in the line of duty to receive a free Gold Star family license plate for the remainder of that surviving spouse's life. Mr. Speaker, perhaps to just directly speak to the bill, I will say that if that spouse were still around, they would happily pay for that fee and provide that. But since they've not, and they've paid the ultimate sacrifice for our country, this bill would be one more way to try to show our support and gratitude. With that, Mr. Speaker, I urge passage.
Question before the House is, shall the bill pass? Gentleman 7th, Douglas Sheedy.
Thank you, Mr. Speaker. Ladies and gentlemen, today you have an opportunity to show your support for the veterans of the great state of West Virginia and the nation. House Bill 5213 will award one Gold Star family's license plate to the spouse of a fallen West Virginia soldier, veteran, one who has been taken before their time while serving to protect you, the residents of West Virginia and the nation. This vote is not for notoriety, but to show the West Virginia values to the veterans' families that protect and defend you and every resident of the state and nation. They courageously gave their lives in service to defend and protect all. They swore to protect your rights and freedoms, and this is the least we can do for the Gold Star widows and widowers. This is one small token of appreciation that we can show as a people, that we truly appreciate what their family has done for the United States of America and the great state of West Virginia. I urge adoption. Thank you, Mr. Speaker.
Is there other debate on the bill? If not, yes, gentleman first. I got McGeehan is recognized.
The sponsor yield, please.
I'm not a sponsor, but I'm the chair.
Oh, chair, sorry. Does the bill apply to a widow whose spouse was killed in action, or does it also apply to a widow whose spouse was killed in the line of duty?
So my understanding is that it is to be killed in the line of duty, but let me consult the bill. Council's unsure. Which just says a Gold Star spouse. So it's an entirely new section. Gold Star is not defined. A Gold Star spouse is not defined. I believe the intent of the sponsor, and as was conveyed to the committee, is that it is for those killed in the line of duty, as compared to a otherwise deceased veteran.
Okay, thank you.
Is there further debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there are 100 ayes, 0 nays, and 0 absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5213 to allow Gold Star spouses to receive one free Gold Star vehicle registration for personal use.
Are there title amendments? If not, the title as read by the House will be and remain the title of the bill. Gentleman 22nd, Douglas Linville.
Mr. Speaker, with unanimous consent, I'd like to provide a further response to the gentleman's question that was just given to me, if I could, on passage of the prior bill.
All right, are there objections to that? The gentleman is recognized for that purpose.
All right, thank you, Mr. Speaker. From the application for a Gold Star license plate, it's criteria for Gold Star based on federal law. That being number one, Public Law 534 of the 89th Congress directs the design and distribution of a lapel button known as a Gold Star lapel pin to identify widows, parents, and next of kin of members of the armed forces of the United States who lost their lives as follows: during World War I, April 16, 1917 to March 3, 1921, during World War II, during any subsequent period of armed hostilities in which the United States was engaged before July 1, 1958, United Nations actions in Korea, June 27, 1950 to July 27, 1954, and after June 30, 1958, while engaged in an action against an enemy of the United States, while engaged in military operations involving conflict with an opposing foreign force, or C, while serving with friendly foreign forces engaged in an armed conflict in which the United States is not a belligerent party against an opposing force. Thank you, Mr. Speaker.
Thank you. Ladies and gentlemen, the bill has passed. Further debate on the bill is no longer in order. So with that in mind, for what purpose does the gentleman of 17th Douglas Pinson seek recognition?
Thank you, Mr. Speaker. I would ask for unanimous consent to return to the second order of business for a quick introduction, please.
But Chair's already said we're going to get to that in just a moment. Is there further action on the bill? Okay, if not, clerk will please communicate the action of the House to the Senate on House Bill 5213. For what purpose does the gentleman of 13th Douglas Heckert seek recognition?
Thank you, Mr. Speaker. I'd like to have unanimous consent to be added as a sponsor to 5213.
Is space available on the bill? There is space available on the bill. Are there objections? Okay, there are no objections. The gentleman's name will be so added. Now, ladies and gentlemen, it is 11:05. It is now the hour at which we normally would receive introductions. So at this time, the chair will open the floor for introductions. Gentleman from the 47th, Douglas Longacre.
Thank you, Mr. Speaker. I want to recognize someone that's here a lot. I see him almost every day. And this gentleman, he and I are not on the same page a lot of the time, most of the time politically, but he makes me smile. And that's former Delegate Doyle, who just left the room. But let's acknowledge him he just walked out.
Hey, gentleman, 17th, Douglas Pinson.
Thank you, Mr. Speaker. Joining us in the North Gallery is a constituent and a friend. I'm going to ask Jack Cart if he'd please stand. Mr. Cart is responsible for representing Gold Star mothers over the last several years. He's got a significant interest in the bill that we just passed. If the House would please make Mr. Cart feel welcome.
Gentleman 6th, Douglas Stevens.
Thank you, Mr. Speaker. I would like to welcome some students and their chaperones from the Our Lady of Peace School in Marshall County. If they'd please stand as I say their name. Jackson Bell, Jonah Kramer, Gabrielle Contragero, Camden Fritzman, Caleb Gamble, Braylon Gaffrey, Chloe Groom, Dylan Rubes, Madeline Komorowski, Sophia Kirko, Aspie Mattern, Emma McGovern, Morgan Milay, Erjai Swager, Ava Thomas, Haddon Wood, Leah Witcherly, and their chaperones, teacher Renee Schneid and Principal Maureen Kerr. Would the House please make them welcome?
Lady from the 15th, Douglas Moore.
Thank you, Mr. Speaker. I am very honored and excited to see that I have 14 pages here today. So I'd like to introduce each of them if they could stand, and the people that came with them as well in the gallery. If you could stand as I announce them. Lorelei Truman is with Spencer Middle School. She is here with Vanessa and Ethan Truman, her mom and dad. I have Lily Westfall with Spencer Middle School and Andrea Westfall, her mother. Emma Sloan is with Roane County High School, and her mother is Melissa Sloan. Alexis Metz is with Spencer Middle School, and Robert and Renee Metz are her parents. Isabella Metz, Chloe Gaynor, and Nola Parsons are all here with Eric and Shelley Metz, their mom and dad, to Isabella, and Reese, their 3-year-old little brother. And Olivia Young, Spencer Middle School, Jay and Danielle Wyatt are parents. Bailey Kelly and Jasmine Delcher with Spencer Middle School, Melissa Craddock is with them. Abigail Marlowe with Spencer Middle School, Sarah and Andy Corcoran are here. Addison Griffin with Spencer Middle School, Miranda Griffin is her mother. Alona Kelly with Spencer Middle School, Travis Salisbury is her father. And Chloe May with Spencer Middle School, Eloise Little is her mother. And I just want everyone to please make them feel welcome.
Delegate from 45th.
Thank you, Mr. Speaker. If I could turn your attention to the South Gallery, and I'll ask them to stand. I have my beautiful wife here today, Jennifer, and my beautiful daughter, Faith Ann. They're here today in support of Deaf Awareness Day here at the Capitol. So if the Chamber would make them feel welcome.
The delegate from the 19th.
Thank you, Mr. Speaker. I have a page joining me today. It's Elizabeth Chandler, if she'd stand up, and her mom is up in the South Gallery, Alicia Chandler. Elizabeth goes to Elkview Middle School, and she participates in archery and golf, and she also loves math and science. And if everybody could welcome Elizabeth and her mom, Alicia, I would appreciate it. Thank you.
Delegate from the 26th.
Mr. Speaker, and I'm joined today by several groups that I'd like to introduce. First of all, we have from Huntington High School, the Region 4 Academic Showdown Champions. And if they'd stand up and the House would make them feel welcome. Secondly, we have another special group here today that you've seen me over 10 years introduce every year. We have the Luke Lee Listening, Language, and Learning Lab from Marshall University here with their professor and head of the program, Dr. Jody Cottrell. This is the program that works with children in our schools, actually starts almost at birth, children that have and get cochlear implants and are then able to be mainstreamed in school. So if that group would stand up and the House would make them feel welcome. And lastly, I have a page today. And if Ella Austin would stand up, Ella's been here several years as well. Ella is a student from the Luke Lee Listening, Language, and Learning Lab. And if you get an opportunity, I would urge you to talk with Ella. And she'll tell you all about the wonderful things that go on at this program. She's accompanied today by her father, Travis Austin, and if he'd stand up and the House would make them feel welcome. Thank you, Mr. Speaker.
Gentleman with 25th, Delegate Hornbuckle.
Thank you, Mr. Speaker. Today in the West Gallery, have a super special group of friends here today for Links Day. Links is an incorporation, internationally nonprofit organization established in 1946 to help communities thrive economically, culturally, and also with civic engagement. With us today, if you would rise when I say your name, we have Wendy Thomas, Dr. Cynthia Jones, Vanessa Washington, Sadie Page, Beverly Merle, and former Senator Marie Redd. House, please make them feel welcome.
Ladies from the 31st, I got Mizaki.
Thank you, Mr. Speaker. Colleagues, I want you to meet my husband, Eugene Mizaki. Please make him feel welcome.
Are there further introductions? Gentleman 96th.
Mr. Speaker, I move subject to announcements that the House recess until 11:45 a.m.
Are there announcements? Are there announcements? If not, the question is on the motion that the House recess until 11:45. Those in favor of the motion, please say aye. Those opposed, please say no. The ayes have it. The motion is adopted. We are in recess until 11:45. To order. We are joined today by some very special guests. This is among the most special days we have each year during the legislature. Guests from Shoals Elementary School's Deaf and Hard of Hearing program and the West Virginia School
Haza. I got to know Josh a while ago when his now 7th grade son was in Cub Scouts. Several other Cub Scouts, by the way, have grown up and are in our group right here today. But Josh was over at Peterkin, and we were doing a camp out, and I see this adult sitting down with a bunch of kids, and he's there with a guitar, and it's like, wow, this is like right out of some movie or something. What's going on here? This is crazy. And it's been my privilege to be associated with not only Josh and his family, but the School for the Deaf and Blind, and I hope each and every one of you have an opportunity like that at some point in time, and so pleased that they could be here. So if you'd give them one more round of applause and thanks.
Gentleman 96th.
Mr. Speaker, I move that the House recess until 12:15 p.m.
Questions on the motion that the House recess until 12:15? Those in favor of the motion, please say aye. Aye. Those opposed, please say no. Ayes have it. We're in recess until 12:15. House will return to order. House will return to order. Gentleman from the 96th.
Mr. Speaker, I ask unanimous consideration to go to Senate Concurrent Resolution 21.
Gentleman from the 96th asked unanimous consent to take up now for immediate consideration Senate Concurrent Resolution 21. This is an infrastructure naming resolution. Are there objections? No objections are heard. Clerk will please report Senate Concurrent Resolution 21.
Senate Concurrent Resolution 21, U.S. Army Master Sergeant James E. Jackson, Jr., Memorial Road.
Question now before the House is the adoption of the resolution. Are there amendments?
Delegate Householder moves to amend the resolution on line 5 following the word "in" by striking New York City and inserting in lieu thereof Talcott, West Virginia.
Question now is on the adoption of the amendment just read by the clerk. Is there debate on the amendment? Is there debate on the amendment? If not, those in favor of adoption of the amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that amendment adopted. The question now is, shall the resolution as amended be adopted? Is there debate on the resolution? If not, those in favor of adoption of the resolution will please say aye. Those opposed will please say no. The ayes have it. Chair declares that resolution adopted. The clerk will please communicate the action of the House to the Senate. Let's return now to consideration of bills on third reading. Clerk will please report the next bill on third reading.
Committee substitute for House Bill 5241, requiring the West Virginia Office of the Insurance Commissioner to audit certain PEIA claims.
Are there objections to having the bill explained in lieu of having it read? If not, the gentleman 51st to explain the bill.
Thank you, Mr. Speaker. This bill amends West Virginia Code to require the Insurance Commissioner to perform an annual audit of all claims made to PEIA for PTSD diagnosis and treatment for first responders. The information collected must include the total number of claims filed and the total number of adverse determinations for claims. The Commissioner must report the results to the Interim Joint Health Committee, Interim Committee on PEIA and Insurance, and the Interim Committee on Volunteer Fire Departments and Emergency Medical Services. The Commissioner is given discretionary rulemaking authority to further specify the information that will be collected. That's a summary, Mr. Speaker. I urge passage.
Question now before the House to shall the bill pass. Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 90 ayes, 0 nays, and 10 members absent. The majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5241, requiring the West Virginia Office of the Insurance Commissioner to audit certain PEIA claims.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5289 to allow for the implementation of educational software in West Virginia public schools.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman from the 38 to explain the bill.
Thank you, Mr. Speaker. This bill requires Workforce West Virginia's Division of Workforce Development to implement a project in phases to provide chemistry and other STEM-related training through an interactive game system to high schools and technical schools within the state. Workforce West Virginia will select 10 schools for the first 2 years of this program, and thereafter the program shall be open to all high schools and technical schools in the state that choose to participate. Schools participating in the project shall be provided with instructional resources for students and teachers that use this interactive gaming system for instruction. The bill requires that administrators and teachers at the participating schools be provided access to the interactive game system as part of their professional development and support, and that funding for this program shall be provided by the Department of Commerce to Workforce West Virginia's Division of Workforce Development. Finally, the bill requires that the State Board of Education shall submit to the Governor and LOCIA an evaluation of the interactive game system partnership. That is the summary of the bill, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now before the House is shall the bill pass. Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 94 ayes, 1 nay, and 5 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5289 to allow for the implementation of educational software in West Virginia public schools.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5297 relating to prohibiting pubertal modulation and hormonal therapy when provided to assist in a gender transition.
Ladies and gentlemen, this bill was advanced to third reading yesterday with 2 amendments pending. At this time, the clerk will please report the first of the 2 amendments.
Delegate Pushkin moves to amend the bill. This is HFA Pushkin number 2, 2-27.
Would the gentleman like to explain the amendment in lieu of having it read? Lady Ms. 73rd has raised a point of inquiry. Lady will state the question.
I believe that the 2 amendments might be competing. They both refer to adding a section, an additional number 5.
Does the gentleman agree?
Yes, if the First Amendment would be adopted, then I would just move to amend the second one to number it 6.
Okay, in light of that, we'll proceed with the amendment that's now been announced by the clerk. Okay. So, gentlemen, are there objections to allowing the sponsor to explain the amendment in lieu of having it read? No objections are heard, and the gentleman from the 54th Delegate Pushkin is recognized to explain the amendment.
Thank you, Mr. Speaker. As I began explaining this amendment last night, it's fairly simple. The bill itself, what it does, it removes the amendment that was made by the Senate last year in the bill that was mainly meant to ban surgery for minors. The amendment that was made allowed for some very narrow exceptions in regards to this type of therapy, a reversible therapy, but to very narrow exceptions for patients with severe gender dysphoria. What the bill does, not the amendment, what the bill does is it removes those exceptions. This would create a grandfather clause, if you will, for patients that are already receiving this therapy, that they would not be kicked off their therapy. So it's fairly self-explanatory. I reserve the right to close.
You've heard the amendment explained. Now the question is, shall the amendment be adopted? Is there debate on this amendment? Lady from the 73rd Delegate Summers is recognized.
I just want to clarify, this is number 2, not number 1. Okay, let me relook at my notes, sorry. Okay, this amendment adds back in the Senate's language from last year relating to pubertal modulation and hormone therapy for severe gender dysphoria, and attempts to grandfather those patients receiving treatment for that diagnosis back in. Under the current bill, though, however, that's before us, there is no denial for treatment for minors except for 2 things. 1, irreversible gender reassignment surgery, and 2, prescribing gender-altering medication for the purpose of assisting a minor with gender transition. This amendment inserts language that indicates the pubertal modulation and hormone therapy is prohibited and causes confusion, I believe, to the providers. So I urge rejection.
Is there other debate on the amendment? Is there other debate on the amendment? If not, Chair will recognize the sponsor, gentleman from the 54th.
Thank you, Mr. Speaker. First, I just want to point out that you should still have on your desk, this was passed out yesterday. It is a letter from healthcare providers from all over the state. I believe there are 400 signatures of healthcare providers basically stating the risk that they see in passing the bill as is, well, the bill in general. The amendment makes it slightly better, and more humane, just saying the patients who are already undergoing this can't be kicked off. That's all it does. So I would urge adoption of the amendment.
The debate on the amendment has been closed. Question now is, shall the amendment be adopted? Those in favor of adoption of the amendment will please say aye. Aye. Those opposed will please say no. No. Noes appear to have it. Okay, noes have it. Chair declares that amendment lost. Clerk will please report the next two amendments.
Delegate Pushkin moves to amend the bill. This is HFA Pushkin number 1, 2-27.
Are there objections to allowing the sponsor to explain the amendment in lieu of having the amendment read? No objections are heard, and the gentleman is recognized. The gentleman would like the amendment read. Clerk will please read the amendment.
Delegate Pushkin moves to amend the bill on page 2, section 20, line 40, following the semicolon by striking out the word and on line 43 by striking out the period, inserting a semicolon and the following, and 5, the adolescent's attending physician expresses in a written opinion that treatment is medically necessary to treat the minor's psychiatric symptoms that makes the minor a danger to commit suicide without such treatment, and on page 5, section 17, line 39, following the semicolon by striking out the word and on line 42 by striking out the period, inserting a semicolon and the following, and 5, the adolescent's attending physician expresses in a written opinion that treatment is medically necessary to treat the minor's psychiatric symptoms that makes the minor a danger to commit suicide without such treatment.
Question now is on the amendment read by the clerk. Chair recognizes the sponsor, gentleman from the 54th.
Thank you, Mr. Speaker. What the amendment to 2007 did last year was to create these very, very narrow exceptions. Obviously, if this bill does away with all those exceptions, this adds one extremely narrow exception, and that's if the child is diagnosed as suicidal. That's it. I just want to make it very clear what we're voting about here. I'm not sure what severe gender dysphoria is versus just gender dysphoria. I think it's either one's diagnosed with it or not. I don't know if severe even exists as a condition, but I do know that danger to oneself does exist as a condition. I think we should, at the very least, make this very narrow exception. The patient is a danger to themselves.
Lady from the 73rd, Douglas Summers, recognized.
Thank you, Mr. Speaker. The amendment, as the delegate spoke about, reinserts a fifth exception on physicians may provide any of the following to a person who is under the age of 18. I think the amendment makes the bill more restrictive because psychiatric care is not prohibited in this bill. As I said before, the only thing in this bill that is prohibited is irreversible gender reassignment surgery for minors or prescribing gender-altering medication for the purpose of assisting a minor with gender transition. There's no prohibition to treating someone with severe gender dysphoria, unless you would get to the point where you would be giving them supraphysiological doses of hormones. I would yes, which would assist with transition. So I would urge adoption if you want to require a minor's psychiatric symptoms to be treated after they get a written opinion from a physician, or I'd urge rejection if you'd like to leave the bill in its current format where there are no written opinions required for a doctor to treat a minor's psychiatric symptoms.
Is there other debate on the amendment as read by the clerk? Gentleman to 79, Douglas Hanson is recognized.
Thank you, Mr. Speaker. Would the delegate who just spoke yield for a question?
Yes, 73rd.
73rd, thank you. I'm trying to reconcile what you said with what I thought the bill did, and so I wanted to try to understand that. The bill removes language on page 3 lines 55 to 57. And it talks about therapy limited to the lowest titratable dosage necessary to treat the psychiatric condition and not for the purpose of gender transition.
I'm trying to find where you're talking about. What line?
Line 55 to 57.
Oh, where in the bill that's been removed, the part that's been removed.
The part that's been
That's
removed.
been struck. Okay, sorry, can you repeat that?
Yeah, so I'm trying to understand, so the current state of West Virginia code, where that paragraph is in state code, it does have a prohibition against using these drugs for gender transition. Is that right?
Those lines are there, so they're really unnecessary because that's already in the other part of the bill.
But the bill would remove that.
It's already stated in another part of the bill.
Where's that?
Let me just get it for you. I'm not understanding your question completely, but let me just say, it says, any use of gender-altering medication is for the purpose of pubertal modulation and hormone therapy will be limited to the lowest titratable dosage necessary to treat the psychiatric condition and not for the purpose of transition. That is already stated in the bill because you are not allowed to give super physiological doses, but low doses of hormones for, say, a psychiatric condition of anxiety or depression that they feel can be assisted with low-dose hormones. That's already allowed by not excluding it.
So it's your interpretation of the bill, and I know this is straying a little bit from the amendment, but the reason why I'm asking is because I think you had brought up that this is related to the amendment. And so just to understand, I think your interpretation of the bill is that paragraph D that we're talking about, lines 55 to 57, is already included elsewhere in the bill, and so these types
It's included by not prohibiting it. So when you look at the exceptions that are allowed, that talk about a physician may provide the following to anyone who is under 18. The reason those exemptions are listed there, they have to do with the main purpose of the bill. So if you cannot give someone gender-altering medication for the purpose of assisting an individual with a transition, there are exceptions because there are medically verifiable disorders of sex development where children would need to be given supraphysiological doses of medication because their genitalia is ambiguous perhaps, and they are a girl, and they're going to be given these hormones to be raised as a male. So these are why you have the exceptions, because you're giving those higher doses. They also might have a disorder of sexual development where you need to do that. They may have had a gender transition procedure where they need treatment. That's why there's an exception there. And finally, there's another exception which might require a procedure because the individual has suffered from something that might have impaired their major bodily function. They might need a surgery. For example, they've had trauma to a certain organ of their body, and they might need surgery because of a life-saving measure. Those are why the exceptions are there. When the exception number 5 was entered, that does not really, it wasn't really necessary, but I think that the Senate felt that they wanted to make sure that that could be done. That is not excluded from the bill in its original format from last year.
Exception 5 is specific related to people suffering from severe gender dysphoria, though.
Yes.
So which of the previous 4 exceptions would that person fall within?
They don't need to be an exception because they are not prohibited from being treated for for severe gender dysphoria in the bill. The bill only does the 2 items that I have reiterated.
Okay. Thank you for
You're
clarifying.
welcome.
I think we just have a difference of opinion about that. I think related more specifically to the amendment is pretty targeted to try to prevent suicides, try to help kids. So I would support the amendment.
Is there further debate on the primary amendment? Gentleman from the 55th, Douglas Akers, recognized.
Would the chairwoman of health yield, please?
Yes.
So just to be clear, it's your affirmation as the chairwoman of the health committee for the West Virginia House of Delegates that if there's a child currently being treated for psychiatric conditions with hormone therapy, that this bill will not stop that treatment modality if it's best for that child with regard to that child and that physician relationship.
That is the way I read it. Now, if the dose was so large that it was supraphysiologic and it actually assisted that child in transitioning, then you would reach a certain level. But what has been expressed to me by physicians is that they are receiving lower doses of a hormone, and that tends to help with their anxiety and depression, but it's not doses that transition that individual.
Right, so if I look at the lines 26 and 27 on page 2 of the bill, there's a new insertion that states that there may not be gender-altering medication, and there's a new insertion that says for the purpose of assisting an individual with gender transition. But does the insertion of that language also affirm what you just told us, which is for psychiatric treatment only, that this bill does not prohibit that? So, for example, if a child is determined to be suicidal by their physician, they can be or prescribed these medications for psychiatric treatment only, but not for transitional care.
I think you're stating that correctly, yes. And I added that language about for the purpose of assisting an individual with a gender transition, even though it is already in the definitions, I inserted that there just for clarity.
Okay. Thank you so much. May I speak to the amendment, Mr. Speaker?
Yes, the gentleman's recognized for that purpose.
With those affirmations from our chairwoman from Health, I would urge rejection of the amendment and adoption of the bill when we get to that stage.
Is there other debate on the amendment? Is there other debate on the amendment? If not, Chair recognize the sponsor, gentleman from 54th, to close debate on the amendment.
Thank you, Mr. Speaker. Before I close, would the chair yield again? One question.
Yes, lady does yield.
So it's your opinion that the amendment I'm offering makes the bill more restrictive?
I'm getting the right amendment. Not necessarily more restrictive. However, you are requiring that the adolescent's attending physician express in a written opinion that treatment is medically necessary to treat the minor psychiatric symptoms. That's not required in the bill. Now, that was in the language that was stricken. You had to go through multiple hoops in the language that's stricken. You had to be diagnosed with severe gender dysphoria. You had to get 2 medical or mental health providers, with at least one being a mental health provider or adolescent medicine specialist, and both having relevant training in the diagnosis and treatment of severe gender dysphoria in adolescents. You had to have written opinions. You had to have agreement in writing from both parents. You had to say it was the lowest titratable dose. You're saying in your amendment that they have to have a written opinion. That is not required in the bill as it's before us. So you're just adding an extra step. It might not harm the bill, but you are requiring additional step that's not necessary.
Okay. If that step's not there now, and I'm adding this step, that they would have to have this written confirmation from their doctor that they are suicidal, then you're saying that this amendment makes the bill slightly more restrictive, correct?
I think it does.
Okay. Thank you for yielding. I'll briefly close. I don't think I agree, but if you do and you want a more restrictive bill, I guess what your vote would be to vote in favor of the amendment. However, I'm going to side on the side of the 400 professionals who have also read the bill as it is and are concerned about patients who could be suicidal. Now, the original bill last year, we heard a lot of talk about irreversible harm. Now, this type of treatment is reversible. I said it in committee, I'll say it again, what is not reversible is suicide. I think the least we could do is to put in this safeguard so these patients who are a threat to themselves would be protected. So I would urge adoption of the amendment.
Debate on the amendment has been closed. Question is, shall the amendment be adopted? Those in favor of adoption of the amendment will please say aye. Aye. Those opposed will please say no. No. Noes appear to have it. Okay, noes have it. Chair declares that amendment lost. Are there other amendments to the bill? If not, clerk will please read the bill a third time.
Committee substitute for House Bill 5297 relating to prohibiting pubertal modulation and hormonal therapy when provided to assist in a gender transition.
Are there objections to having the bill explained in lieu of having it read in full? No objections are heard. Lady from the 73rd to explain the bill.
Thank you, Mr. Speaker. This bill continues the prohibited practice of irreversible gender reassignment surgery and prescribing gender-altering medication for the purpose of assisting a minor with gender transition. But it removes the provision placed last year in the bill that allowed pubertal modulation and hormone therapy for severe gender dysphoria after 2 specific providers have made that diagnosis and expressed it in writing. Parents also had to agree in writing, and the medication was limited to the lowest dose necessary to treat the dysphoria. Removing this provision does not impact a minor's treatment for other reasons that are not for the purpose of irreversible gender reassignment surgery prior to the age of 18. And don't forget, this bill doesn't impact adults at all. We're just saying children cannot have irreversible surgery and cannot take medication that transitions them prior to adulthood. I think that's about it, Mr. Speaker. I urge passage.
You've heard the bill explained. The question is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman, the 79th Delegate Hansen is recognized.
Thank you, Mr. Speaker. As you can imagine, I don't support this bill. There seems to be a difference of opinion about what this bill actually does. Current code has a very narrow circumstance in which a certain type of gender-affirming care is legal. And this bill removes that very narrow circumstance. So there is a difference of opinion about what this bill does. In my opinion, the bill will make it harder for parents and their kids to make their own healthcare decisions on a topic that's extremely sensitive and extremely personal. And I think it's rich that this is happening on the same day that the Parents' Bill of Rights passed this body. The Parents' Bill of Rights that says it's a fundamental right of parents to direct the upbringing, education, care, and medical care of their minor children. The Parents' Bill of Rights that says the state may not infringe on the fundamental rights of a parent to direct the upbringing and health care of their minor child. The Parents' Bill of Rights that says all parental rights are reserved to the parent of the minor child.
Gentleman, 78, Delegate Shirelli.
I believe the bill that we are discussing is House Bill 5297, not the Parental Bill of Rights.
That point is well taken. The gentleman will confine remarks to this bill, not to prior bills that have been passed.
Well, I'll tell you why it's relevant to the Parents' Bill of Rights.
The Parents' Bill of Rights delegate is not on the floor. The gentleman has the floor for this bill.
The reason why it's relevant is that this bill removes language that requires parents' consent in order to undertake this type of therapy. There's a very narrow circumstance where parents can work with their medical providers and their children in order to allow this type of therapy. It requires the minor and the minor's parents in this bill to agree in writing with the minor's primary physician that this type of therapy is appropriate for their child, and that's why it's relevant. Because this bill is removing a parent's right to make healthcare decisions for their child. And the language that's being removed not only requires the parent's written approval and the child's primary physician's written approval, but the approval of two other medical or mental health providers, both having training specifically in this area of gender dysphoria. So that's why it's irrelevant. It's irrelevant because, as the gentleman from the 54th stated, there's a letter put on your desk earlier this week from about 400 medical providers from West Virginia who oppose this bill because this type of treatment is recommended by every major medical organization, and it's about protecting kids from suicide. The very narrow exemption that's being removed in this bill puts our kids at greater risk of suicide. Even though I spoke against and voted against the Parents' Bill of Rights, there are some things in there that I think are accurate and true and values that I share. I do share values that parents are the ultimate decision makers for their children's healthcare decisions. I also highly value the opinions of doctors who are providing care to West Virginians who are dealing with such a difficult situation. Have you spoken to any of those doctors who are providing gender-affirming care to West Virginia kids? There's a list of 400 of them on your desk if you want to reach out to one of them, or if you'd like to talk to one, let me know and I'll hook you up. We'll get on a Zoom call with them. Because I think if you actually have a conversation with someone who's providing this type of care, it may change your mind. Because these healthcare providers are making valiant efforts to keep our children alive. They're on the front lines. They're dealing with real-world situations. This body does not include a lot of medical professionals. I'm certainly not one. Just like the Parents' Bill of Rights doesn't allow us to do that, we should not be doing that in this bill. We should not be substituting this body for medical professionals that are working on the ground in our communities to keep our kids safe. That's why I oppose this bill.
Gentleman of the 55th, Douglas Akers, is recognized.
Thank you, Mr. Speaker. When I first heard about this bill, I looked at it very carefully because I did have some concerns. Gender dysphoria is not a new condition. It's been around for a long time, and I did have questions about whether it was going to prevent legitimate psychiatric care under limited circumstances, and I wanted to at least get those answers for myself. And I got a bunch of emails that were obviously generated by a call to action by people who I think simply attack this body for going after kids or going after doctors. And when I asked the questions from the chairwoman of health from the 73rd, I was pretty sure I knew what her answers were going to be, but I wanted to ask her anyway to get that affirmation on the record. I thought that was important. Because when I read this bill, I saw it the way she sees it, which is it's actually less restrictive than it was before. In this simple addition on lines 26 and 27 on page 2, make it clear that gender-altering medication cannot be prescribed only for the purpose of assisting an individual with gender transition, which is already the law in this state. Whether you like it or not, that's what the law is. So we have affirmation that this medication can still be provided for psychiatric treatment which was my main concern, and that's not changing. And no one in this body is against the physicians or healthcare providers who provide this care. I've talked to some myself. I've done that. I know people who suffer from this condition. That's not what this bill is about. And it's the worst part of politics, I think, when we send out these calls to action. That can happen on both sides, not just one or the other, but send out a call to action and we genuinely alarm people and make them think, for example, that their child may be in danger of killing themselves because of a piece of legislation that's not actually going to do that. And I've gotten a bunch of emails about this from parents and physicians who I can tell are alarmed, but they don't actually, and this is no insult to them, they're too busy to read all of our bills. They don't know what the bill actually says. They were just told that it's going to cause harm, and they believed the people who emailed them and trusted them to tell the truth. But that's not what happened here. You know, earlier today, I never would have accused the gentleman from the 25th of saying, or said that he wasn't for children being educated or parents having a right to choose education. I think he was genuinely interested in protecting public schools and the funding that go along with those. This bill is not about trying to take the option of genuine psychiatric care away from these families and their children, and to say that it's taking away the parents' rights somehow. I feel like my mind is somewhat in a pretzel because a child can't consent to this in the first place. A child can't go to the doctor by themselves and ask for these medications. The parent has to consent, or some other legal guardian. That has to happen. And the issue of child consent is the reason why this entire issue came up in the first place. Because can a child truly consent to the more severe or serious types of treatment that were previously banned in this bill? That was the issue that was, I think, at the heart of it was, is the child truly even consenting to what's being done to them? And here the parent still has to consent like they did before, actually in a less onerous manner. So I appreciate the affirmation from the chairwoman of health, the gentlelady from the 73rd. She will not stand up in this chamber and tell us something she does not believe to be true. She tells us that this bill will still allow children who are suffering from gender dysphoria and need this treatment for psychiatric conditions to continue to be treated. I want any parent or physician who's involved in this to listen to that again. We have affirmation from the committee chairwoman where this bill came from, who told us here today that any child or any physician involved in this process will still have the same ability to seek and receive medication for psychiatric treatment if this bill passes as they did yesterday or today. I think it's important for that true message to get out for people who are genuinely concerned about the care they provide to these children and for the families of these children who are concerned for the people who they love. Urge passage. Thank you, Mr. Speaker.
Lady from the 56th, I get Young's recognized.
Thank you, Mr. Speaker. Hi, colleagues. I appreciate my friend from the 55th talking to doctors about this. I appreciate anyone who talked to doctors about this. In the bill, I find it interesting that irreversible gender reassignment surgery says just that. And then gender-altering medication doesn't say irreversible. And that's because it is reversible. It's completely reversible. All that these medications do is stop puberty. And I'm sure, quite frankly, all of us probably wanted to stop puberty for some reason or another because, God, it's awful. And these kids just want a little bit more time. All these medications have been used on children longer than I've been alive for a variety of reasons. They are developmentally appropriate, they are age appropriate, and they are reversible. Every single medical association, every single national medical association supports gender-affirming care in every capacity. And what this bill does is restricts gender-affirming care. Last year's bill restricts it, this year's bill restricts it, just restricts it differently. That's all it is. This is just another color, but it still restricts gender-affirming care. This care can be life-saving for kids, life-saving for children. And I want to talk about that for a minute because a few weeks ago, we had a really, really heartfelt testimony where a lot of people on both sides of the aisle got up and they talked about suicide and how it affected their family and how it affected their lives. And I think we probably all shed a tear, and that was an interesting day, and it was really nice to see everyone show emotion, and I appreciated it a lot. Suicide is the second leading cause of death in kids aged 10 to 14. It is the third leading cause of death in kids aged 15 to 24. When we talk about LGBTQ kids, those rates are 4 times higher. In 2022, in West Virginia, 50% of trans kids thought about suicide. 20% of them actually attempted it. That is horrible, horrible. These are not statistics that we should be proud of at all. Gender-affirming care has been known to reduce suicide by 75%, and I don't think that we should be restricting it in any capacity. If we want to talk about consent and this bill not having consent last time, this time, if you want to write a bill about parental consent, we could do that, but that's not what this bill does. This bill restricts care for kids. It takes away parental rights. It restricts health care, and I think if it becomes law, more West Virginia kids will die. So for that reason, I'm a no.
Gentleman from the 54th, Docket Pushkin's recognized.
Thank you, Mr. Speaker. I just take a bit of umbrage with something I've heard, that the worst side of politics, emails, phone calls, other messages from advocates and people who care deeply about this bill, possibly because it affects their child, their loved one, or maybe their patient. I don't think that's the worst side of politics. I think the worst side of politics is what we're going to see after some of us vote no on this, and we're accused of mutilation or castration. And those are the words you'll see used, and that's the worst side of politics. And I don't really care what it does to those of us who vote. The problem is that this type of legislation that's simply meant to unite people against a common enemy, this type of legislation also has real victims, because it creates a chilling effect where the doctors aren't going to want to practice this sort of thing, and worse than that, it tells a very vulnerable segment of our society, these kids who've probably been picked on enough, tells them that their legislature, their elected officials don't even think they should exist. So, let's try not to take the high road and talk about the bad side of politics, because that's all this is about. When we get called back into a committee room at the last hour before we can get House bills out, just to put out this meaningless legislation that's only meant to help people get elected and meant to be the subject of postcards talking about mutilation and castration. So give me a break on that. That's what this is about. It's the worst kind of election year politics, and unfortunately, real people do get hurt. We should care about them.
Gentleman from the 20th, Docket Foster's recognized.
Thank you, Mr. Speaker. I stand in support of this bill because it removes an exception that was inserted in the Senate side for this type of I don't really want to call it treatment, because it's not used as treatment. They're using, the problem with these puberty blockers is that it's being prescribed as a treatment. The lady mentioned that, saying that it decreases suicide. There's no proven methodology that says that it actually does decrease suicidality. What does help these children, in many cases when they're suffering through gender dysphoria, they're also suffering from comorbid situations such as depression. And I think when we say, well, we're going to treat this by gender-affirming care and switching someone's gender, and that'll fix the problem. Well, the suicidality rate is the same before and after transition, or before and after these drugs are prescribed. And what we're doing by saying, well, let's go ahead and prescribe these drugs, such as Lupron or another, it's not fixing the problem. We're providing a solution that doesn't solve the problem. And by removing this exception, I think we're focusing more on getting these kids the help they need, which is many times these comorbid situations where they're dealing with depression, and situations where something that would not be a life-altering drug that could help them cope with something that is an issue they're dealing with. And I think it's pointing doctors in the direction of actually treating the issue of the suicidality problem and the depression, rather than moving to a solution that's not working. So I would urge adoption of the bill, or passage of the bill.
Lady from the 81st, Docket Hamilton's recognized.
Thank you, Mr. Speaker. I just want to respond to some things that was just stated. We know that gender affirming care is a touchy topic, but legislation that affects gender affirming care removes an access to care that our children are crying out that they need. Data has shown that it is effective in bringing down anxiety, depression, and suicidal thoughts. But here's a caveat that we have not considered, and the reason why some think this data doesn't, the reason why this form of care doesn't work is because when we pass this type of legislation, it sends a message to our other youth, and they begin to increase in their violence in school and in their bullying. Just on Monday in Oklahoma, there was a non-binary kid that was beat up by 3 other students in his school. He had complained of bullying and it was not addressed, another problem that we have in our educational system. This young kid died. He's gone. So can we say that the medicine didn't work? Medicine could work. But what affected this child was not the gender affirming care, but it was the bullying and the violence that he was subjected to because of his declaration and saying that my gender identity isn't what was assigned to me at birth. Sometimes we miss the humanity of what these bills do and how it affect and the messaging that comes across, especially to young minds, minds that can be, that can be easily influenced. So the gender affirming care data shows it does help decrease anxiety, it does help decrease depression, and it does decrease suicidal ideations. But this type of legislation has shown to have a negative effect upon all youth because it does increase violence against our youth and violence through bullying and through physical altercations. So that's the caveat that we have to consider whenever we're dealing with this type of legislation. So I think it's important to lend our ear to what over close to 500 doctors have said in the state of West Virginia, that they stand by this care. It is an access to have a better outcome. Will it fix everything tomorrow? Absolutely not. And if you know anyone or if you ever suffered with depression or anxiety, you know it's a roller coaster in life. If you've ever dealt with people who have suicidal thoughts, they battle this all day. It's just not one time they have a thought. It's all day. And if something occurs to them, it's an internal struggle that they deal with, but then on top of that, they have to deal with the external struggle of how society treats them. They deal with this 24 hours a day, and for a young, fragile mind, they cannot handle it. So I feel like it should be our responsibility and duty to do whatever we can to save the lives of our youth. And if doctors say this care through data shows that it helps, then I'm going to stand with our doctors. Thank you, Mr. Chair.
Gentleman, the 38th, Dr. Ellington is recognized.
Thank you, Mr. Speaker. Would the distinguished chair lady of health from the 73rd respond to a few questions?
Distinguished, obviously.
I'm distinguishing you. Questions, clarification for me. As you know, my specialty as a GYN, I deal with prepubertal and adolescent females. So would this bill in any form affect my ability to do corrective surgery for anomalies or injuries?
Would not.
Okay, just as long as it's not something that would be gender transforming.
That's
okay.
Gender transitioning, unless in the exception they had one of the sexual disorders or developmental issues.
That we currently can do. How about as far as hormonal treatments for various conditions in pre-adolescent females?
It would not be prohibited unless it was supraphysiological for the purpose of assisting in gender transition.
Right, and the supraphysiological puts them at more complications, so that's one thing. A question that came up that I looked at, in the course of my specialty, we have to take call at hospitals, which means these may be patients that I may not have in my practice, but I may have to encounter on call. So let's say you have an individual that is transitioning here, and they happen to be admitted to the hospital. I get consulted. Sometimes when we have people that are on certain medications that we may not be, by DEA, able to prescribe, we're allowed to do so in the hospital setting. Just for that temporary time, we're not allowed to prescribe outside of the hospital setting. So if a person is on these high doses of hormones, would I experience any liability if I had to continue that for the safety of that patient while in the hospital?
I do think it's a little bit of a gray area if a patient, say, comes from Pennsylvania or Virginia where they allow this treatment and they end up in West Virginia hospitals if they are on the high doses. I do know that in our law here, we do not have criminal penalties or revoke licenses in any section for providers. I do know that patients could bring their own medicine and take their own medicine. As far as you prescribing a physiological dose, I do think that's prohibited.
Thank you. That's all I need to know. Thank you. Thank you, Mr. Speaker.
Is there other debate on the bill? Gentleman from the 52nd row is recognized.
Thank you. If the kind lady would answer some questions.
Yeah.
There's been a lot of information, and I'm going back and forth, and it appears that the same information is being struck in two different sections.
Right, because we have an MD board and a DO board currently, so we do have to write those under each section.
Okay.
But it's the same language in both sections.
Right, and I was looking elsewhere, as I understood your answers to other questions, that all of that we're striking is already in there and it's no problem, but I can't find anything that deals with the psychiatric condition that would lead to suicide. I've looked in both sections and I don't find it. Let me read something here that troubles me.
You can't find it because it's not prohibited. This is about prohibitions of practice.
Yeah, but if you're a physician and you were to read this bill, you would feel very concerned about a psychiatric condition that might lead to suicide, because we have in the statute this language that is to be taken out. And it says that the minor and so on charged with medical decision-making from the... Wait a minute, I'm in the wrong section. On page, let's see, page 5, there's one set of these, and it's on lines 48 to 50, and it says that that the diagnosing medical professionals express in a written opinion. I think there was some question about whether there was a written opinion required in the statute or not, but there is a written opinion required. That treatment and that we're talking about in the therapy is medically necessary to treat a minor's psychiatric symptoms and limit self-harm or the possibility of self-harm by the minor. Now, I don't see anything in either section that talks about psychiatric disorders leading to this kind of therapy. And what we're taking out of the law is the fact that, without question, it's a pretty limited procedure. You have to have two physicians sign a written opinion, has to be joined and agreed to by the parent, and it deals directly with psychiatric disorder. If we vote for this bill, that goes out of the law, right? And is there some place, because you said several times that there's some place in here that has all the provisions that we're taking out, and it's sort of a flip, as I understand your answer, that because this is a bill that prevents certain kinds of treatment, the fact that we're not preventing treatment of a psychiatric disorder that might lead to suicide, that's not prohibited. But if I were a physician, I would read this to say that it is. I'd be thinking, if I'm going to use this therapy, how is it that I can use it for a psychiatric disorder rather than the very physical kinds of disorders that are discussed in the bill that we're not altering. And I just wanted to know what your take on that is.
I think your questions prove exactly why the language needs to come out of the bill. It has created confusion amongst all the legislators and probably providers. And so now they're concerned about taking it out, that they can't take care of kids that might have suicidal ideations. The original intention of the bill is only to prohibit 2 practices in the state of West Virginia for minors. 1, irreversible gender reassignment surgery, or gender-altering medication for the purpose of assisting an individual with a gender transition. I think the additional language that was added last year has caused some confusion.
Yeah, but it addresses the issue pretty clearly, I think, by talking about physical conditions. I mean, it's very careful about that they're allowed to treat physical conditions.
Well, because we're talking about irreversible surgery, we need to list what those exceptions might be. If you have had a serious injury where you might have to have a irreversible surgery that might change, right?
Sure.
Then that's why that's specified.
Yeah, I mean, there's no question that they need to have some clear direction about what is allowed and what is not allowed, because the general provision is, I think, at the top, says that physicians cannot do anything that would transition a minor or would provide them with gender-affirming therapy.
It doesn't prevent gender-affirming therapy. Gender-affirming therapy is much more than a hormone. I mean, we allow individualized behavioral therapy. We allow peer group support. We allow medication as long as it is not in doses that are gender-altering for the purpose of assisting in a gender transition.
So we don't need to address psychiatric disorder therapy.
I think it's not that we don't need to address it. I think that the bill clearly does not prohibit it. And we're talking about prohibited practices. That's why that language made it a little bit confusing about an exception, because it's allowed.
Well, I don't read it that way. I think that the provisions are really, almost threaten providers. If they were to provide this kind of therapy, they would be in jeopardy of losing their licenses, because there's nothing in the statute that allows them to use these therapies for a psychiatric disorder, particularly leading to, how do they put it here, self-harm, which is suicide. There's a silence about that, and if we're trying to prescribe certain therapy, the use of certain therapy, shouldn't we have a provision for psychiatric?
I'm just going to have to disagree. Now, I may agree with you that the construction of the bill could be better, but this bill, when it was originally introduced last year, only dealt with surgeries. So then when hormones and some of these other things were added in, I don't know if it was constructed the best. However, I do know what it says, and I do know what it says is prohibited, and it is the 2 things that I've repeated endlessly.
Well, my memory is, in fact, that surgery was added, and then there was an amendment to add in the hormonal therapy. So both were barred, and that was the reason that psychiatric was put into it, because there's no allowance to use those therapies for anything that other than certain physical activities that are listed.
Where does it say that it's not allowed?
Well, it says it by what they're allowed to do. I mean, in the way
those are only the exceptions to the prohibited practices.
Right.
So if you're born male and you need to be made a female because the anatomy is not there to support that, that is an exception. You are going to need to do something that is prohibited. You're going to have to do that. That's why it's accepted there.
Well, It's clearly a statute that forbids medical practice in regard to surgery that would be transitioning surgery or transitioning medications.
That is correct.
Okay. And then there are exceptions listed. And what we're taking out if we vote for this bill is we're taking out the exception that they get to treat with these therapies, just like for a physical disorder, they get to treat a psychiatric disorder when it is to prevent self-harm, i.e. suicide. But if we vote for the bill, we're taking out the psychiatric permission, the permission for a psychiatric disorder. No?
I'm just going to have to disagree.
Okay. All right. Thank you very much.
You're welcome.
I appreciate it. Mr. Speaker, I would like to speak to the bill.
Gentleman is recognized for that purpose.
You know, this is really frustrating, you know, and you really think that when we go into something as tender and difficult as transitions of people on their gender, it's hard to understand it, and the best way to understand it, I think, is to know folks who have done that and who have needed to do that for their own sanity and to prevent their own suicide. I think we need to, I respect the lady's opinion, but as I read this, there's no doubt in my mind that we are taking out the legitimate exception that was in the bill last year for psychiatric disorders leading to self-harm of the patient. And what we're doing by deleting that and saying, well, we don't have it, it's not prohibited. Whoa, 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 whoa. It's the use of the medications. And if with these kinds of hormonal medications, a physician is going to be very careful about prescribing them, because even with a psychiatric disorder, even if needed to prevent a suicide, particularly when reported by parents, a physician's going to have difficulty reading this statute to say that, oh yeah, whenever the legislature returned to this very statute that outlawed any transition therapy either by surgery or by medications, hormonal medications, they really, in taking out the exception for psychiatric conditions leading to suicide, when they took that out, they meant to, they didn't mean to make it illegal, they meant to just let it kind of hang and just sort of be something that you could treat or not treat. I think it's very clear that voting for this bill means that we are voting to take out the words that you see on your screen right there, and it says medically necessary to treat the minor's psychiatric symptoms and limit self-harm or the possibility of self-harm by the minor. We're taking that language out of the law. Thank you, Mr. Speaker.
Gentleman from the 53rd, Douglas Pritz, recognized.
Thank you, Mr. Speaker. Would the Chair of Health yield, please?
Yes.
So I'm taking a look at pages 2 and pages 3 here of the committee substitute. So certainly, I think based on this, where the exception that was added in there, and it's this long litany of things that's like a test, talking about, well, you know what I'm talking about there, that we're taking.
Oh, yes, I've read this many times.
Okay. So I was taking a look at that part there, but then I was also taking and that's the exception that we're taking out, which I think is a good thing. But I was looking at the language on page 2, lines 25 through 27. And there's this phrase that was added in there. And it says, except as otherwise provided in 30-3-20, a physician may not provide irreversible gender reassignment surgery or gender-altering medication, and this is the part that's added in here, for the purpose of assisting an individual with a gender transition to a person who is under the age of 18. Okay, just so we just so it's clear what we're talking about here.
And I'd like to say, I only added that for clarification because that is what the definition on the first page says. Gender-altering medication means the prescribing or administering of the following for the purpose of assisting an individual with gender transition. So I only carried the definition over to that statement to make it clear, more clear.
What page, I'm sorry, what page
So
is that
the
definition?
definition for gender-altering medication is in the first page on line 8 under prohibited practice where we're talking about definitions. Very first page.
The very first page, okay, just briefly.
Under definitions, gendering-altering medication, I carried the definition over to line 25B, where we talk about the exceptions, just to make it clear what gendering-altering medication is.
Okay.
See where I copied the definition?
Well, just where it says gender-altering medication means the prescribing or administering of the following for the purpose of assisting an individual with a gender transition. I see. Okay, so by adding that phrase in there, for the purpose of assisting an individual with a gender transition, I'm just taking a look at that then. Is there, under the bill as it's constructed right now, let's say a doctor states and claims that it's for some other purpose, let's say for mental health treatment, then are there any limitations on what gender-altering medication can be prescribed?
No.
Okay. All right, thank you.
Debate on the bill. Gentleman on the 25th, Doug Hornbuckle.
Thank you, Mr. Speaker. Friends, I will not be accusatory. I will not be accusatory because I know that there is confusion on this bill. I know that some of you in this body today are struggling deep down. I know that for sure. I always aim to be the voice of reason. And with that, I will tell you that you do not have to agree with this potential medication, procedure. You do not even have to agree with what some might think is a lifestyle. You do not have to do that to be able to protect children, is what that boils down to. To protect children. You know, quite simply, this bill, in short, is about protecting vulnerable kids from suicide. That's what this measure is about. Earlier this session, we passed a measure on being against euthanasia, medically assisted suicide. One could argue that this measure could be legislative assisted suicide. This is a very important topic that we're dealing with here today, and it boils back to protecting children from potential suicide. I just briefly want to share some words from a West Virginian from a small coal town. Sometimes in our lives, we all have pain. We all have sorrow. But if we are wise, we know that there's always tomorrow. Lean on me. When you are not strong, I'll be your friend. I'll help you carry on. For it won't be long till I'm going to need somebody to lean on. Please swallow your pride. If I have things you need to borrow, for no one can fill those of your needs that you won't let show. You just call on me, brother, when you need a hand. We all need somebody to lean on. I just might have a problem that you'll understand. We all need somebody to lean on. Lean on me when you're not strong. I'll be your friend. I'll help you carry on, for it won't be long till I'm going to need somebody to lean on. Just call on me, brother, when you need a hand. We all need somebody to lean on. If there is a load you have to bear that you can't carry, I'm right up the road. I'll share your load if you just call me. That's by Bill Withers, but more importantly, that was by a group of kids sung out here not too long ago that all of us nodded and smiled and clapped. They know the way. This is not about a lifestyle. This is about protecting potentially suicidal kids. And I would urge the body to not vote for this measure, because if we could protect just one, it would be worth it. Thank you.
Lady from the 73rd to close debate on the bill. Debate on the bill has been closed. Question now, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 88 ayes, 11 nays, 1 member absent. Majority of members having voted in the affirmative, the chair declares the bill passed. Clerk will please report the title.
Committee substitute for House Bill 5297 relating to prohibiting pubertal modulation and hormonal therapy when provided to assist in a gender transition.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House, the Senate. Next bill on third reading.
House Bill 5305 relating to impaired driving not eligible for deferred adjudication.
Are there objections to having the bill explained in lieu of having it read in full? No objections are heard. Gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. The bill removes a violation of 17C52 of this code, driving under influence of alcohol, controlled substance, or drug, from eligibility for deferred adjudication, except that a court may defer proceedings in accordance with 17C52B of this code. That is a summary, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 0 nays, and 4 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5305 relating to impaired driving not eligible for deferred adjudication.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House, the Senate. Next bill on third reading.
Committee substitute for House Bill 5331 relating to boating safety education certificate.
Number 96th.
Mr. Speaker, I ask unanimous consent to move the bill to the foot of all bills.
Are there objections heard? No objections are heard. Bill will be moved to the foot of the bills. Next bill on third reading.
Committee substitute for House Bill 5338 relating to safe harbor for cybersecurity programs.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman to 72nd, Douglas Riley, to explain the bill.
Thank you, Mr. Speaker. The committee substitute would provide as follows. In the new article of code, Safe Harbor for Cybersecurity Programs, the bill would provide a legal defense to certain types of businesses against certain types of lawsuits, claiming that the business failed to implement a reasonable cybersecurity protections, and as a result, a data breach of personal information or restricted information occurred. The protection will be available to covered entities which are defined as a business that accesses, maintains, communicates, or processes personal information or restricted information in or through one or more system networks or services located in or outside the state. The next section, section 2 and 3, describe the requirements of cybersecurity program that businesses must maintain to get this statutory defense and liability claims for data breaches. Section 4 declares that the article shall not be construed to provide a private right of action, including a class action with respect to any act or practice related therein. Section 5 provides that if an institution of higher education in the state offers a cybersecurity assessment program as part of an undergraduate or graduate program related to cybersecurity to any business in the state, then the school or any employee or student thereof of the offering program is immune from civil liability that arises from the failure of a covered entity conform to the provision of this article. I urge adoption.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 92 ayes, 0 nays, and 8 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5338 relating to safe harbor for cybersecurity programs.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. Gentleman from the 96th.
Mr. Speaker, I move that the bill take effect January 1st, 2025.
The question now is on the gentleman's motion that the bill take effect January 1st, 2025. Those in favor of the motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 91 ayes, 0 nays, and 9 members absent. 2/3 of members having voted in the affirmative, the chair declares the bill effective July 1st, 2025. Clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5340 relating to requiring insurance coverage for a non-opioid drug for the treatment of pain for patients with substance use disorder.
For what purpose does the gentleman on the 27th, Douglas Griffith, seek recognition?
Thank you, Mr. Speaker. I ask unanimous consent to suspend the rules for the purpose of a potential amendment.
Gentleman asks unanimous consent to. Objection is heard. Objection is heard. Clerk will please report the bill.
Committee substitute for House Bill 5340 relating to requiring insurance coverage for a non-opioid drug for the treatment of pain for patients with substance use disorder.
With objection to having the bill explained in lieu of having it read. If not, lady from the 49th, Delegate Tully to explain the bill.
Thank you, Mr. Speaker. This bill is to require insurance coverage for use of a non-opioid medication for the treatment of acute pain patients that have been diagnosed with substance use disorder. This bill defines a non-opioid medicinal drug or drug product. It requires insurance providers, Medicaid, and PEIA to provide coverage of a medically appropriate non-opioid drug for the treatment of acute pain patients who have been diagnosed with substance use disorder. As I previously stated, I urge passage. Thank you.
You've heard the bill explained. The question is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? The clerk will close the machine and ascertain the result on that question. There were 94 ayes, 0 nays, and 6 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5340 relating to requiring insurance coverage for a non-opioid drug for the treatment of pain for patients with substance use disorder.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5344 relating to testimony of cognitively delayed persons in open court and criminal penalties for assault of cognitively delayed persons.
Question is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read in full? No objections are heard. Gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. This bill amends the code to create the crime of sexual assault in the third degree relating to mentally defective or mentally incapacitated victims, provides penalties, and provides when a mentally incapacitated victim may be allowed to testify using two-way video conferencing and two-way closed-circuit television. That is a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5344 relating to testimony of cognitively delayed persons in open court and criminal penalties for assault of cognitively delayed persons.
Are there title amendments?
Delegate Fast moves to amend the title.
The question now is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. The chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5349, West Virginia Truth in Food Labeling Act.
Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Lady from the 73rd, Delegate Summers, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to create the West Virginia Truth in Food Labeling Act. The bill introduces definitions for the term analog product and cell culture product, clarifying the characteristics and origins of these food items. The bill defines misbranded food, and it provides for the labeling of analog products and cell culture products. The Act establishes criteria for determining misbranded analog and cell cultured food items, which will put them into a similar regulatory framework for other misbranding laws that apply to other food items, such as frozen desserts and dairy. It provides exceptions for food sold in restaurants, infant formula, medical food, certain food distributors, and for customs of the trade. It allows for exemptions to be made for certain food items when other requirements are impractical or if it results in deception or unfair competition. Finally, the Act gives rulemaking authority to the Department of Agriculture for enforcement. This is a consumer protection bill, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Gentleman from the 54th, Delegate Pushkin is recognized.
Thank you, Mr. Speaker. Would the chair yield for a few questions?
Yes.
Thanks. Just a few questions. I won't grill you on this. First of all, these regulations you say that puts it in line with, are those federal regulations?
There are state regulations that the Department of Ag already has for other food items.
Okay. Now, I just want to know is this stemming from, like, somebody accidentally ate Beyond or Impossible Burger and thought they were buying real meat? I'm trying to figure out what the actual need for this is. Are people accidentally buying vegetarian products thinking that they're buying real meat?
You'll probably have to ask the lead sponsor that question. However, it doesn't pertain to restaurants, so it's not going to be about that burger.
No,
but it's about letting people know what they're actually eating.
Mm-hmm. Okay. My other question, last question for you is, how would you foresee the enforcement of this? Say Kroger orders a bunch of cases of Impossible or Beyond Burger, and it's not labeled in this uniform manner because it's labeled like it would be in every other state. How would we enforce these types? What's usually enforced by the feds?
It would be labeled misbranded and would be removed from the shelves.
Be removed from the shelves.
Yes.
Okay. All right. Thank you for yielding.
You're welcome.
All right. Well, I would like to say that this is the worst kind of election year red meat. That would be fake. But I do have a real beef with this bill. And if you read it, it's just incredibly onerous regulation on a couple specific products, really. Mainly on, it looks to me like Impossible Burger, Beyond Burger, these types of products that we're putting a lot of really over-regulating. I don't think there's anything really conservative necessarily about this bill. This is big government. This is nanny state. And it will be bad for the consumer because what's likely to happen, two things. This is model legislation. Unfortunately, in states where it has passed, some of those states are in court right now because it's a violation of the Interstate Commerce Act. It's a state trying to regulate packaging that's sold all over the country. I'm not sure how that's going to work. If Beyond and Impossible, they have a package that they're going to sell in Alabama, Tennessee, Kentucky, are they going to have a special package just for West Virginia because the West Virginia legislature decided to put this type of, require them to have a certain type of label? So either they're going to go to court, and we will lose, or they'll just decide not to deal with this market at all, and then consumers will have less choices. So I'd say if you don't like the product, don't buy the product. I don't think anybody is accidentally buying Beyond Burger thinking they're buying real hamburgers. I don't think that the beef industry, who's behind this legislation in other states, has anything to lose. I don't think they're in competition with vegan burgers. People are either vegan or they're not. And I think it does have potential to harm a West Virginia company. There's one company I could find in Moundsville, Primal Spirit Foods, that they make vegan jerky, and it could have an effect on them. But I think these other companies from out of state, either they're going to sue us or they're going to quit doing business with us, and then consumers will have less choices. And there is a religious freedom aspect to this too, because there are certain religions that have dietary restrictions where they can't, say, like in mine, but if I followed it, couldn't have a cheeseburger because you can't mix meat and dairy. However, for those who are more observant than me that want to have a cheeseburger, they would have to use Beyond or some sort of like vegan type burger if they were going to put cheese on it. It restricts options. It's what the effect of this will have is to restrict options of consumers because it's going to take products off the shelf that nobody is buying by accident. So I would suggest glancing through the bill real quick. It is a big government bill. It is a whole bunch of onerous restrictions on a certain type of product that you may not like. If you don't like it, don't eat it, but don't keep other people from being able to have that option.
Gentleman 93rd, Douglas Hornby.
Thank you, Mr. Speaker. Speaking to this bill is about meat grown in labs. And I should have the right to know what's in my food when I buy it in the grocery store. We're growing meat in labs. This isn't about Impossible Burger or vegan burgers. This isn't about big government. This is about knowing what's in your food when you buy it in the grocery store. Thank you.
Lady from the 56, Douglas Young is recognized.
Thank you, Mr. Speaker. Will the chair of Health Yield, so I could grill you on a question or two? Nobody laughed at that one. Come on. My question is under the, I said grill. It's funny. Under misbranded food, it says that the label has to say imitation before and after the name. So is it going to say like imitation meat imitation?
Let me look.
I'm on page 2, line 8.
Immediately before or after.
Or after. Okay, not both, because that would just be weird. Okay, so this is just meat, eggs, fish. Is that right?
No, it is not those things. It is only analog products, which means a food product derived or combining processed plant products, insects, or fungus with food additives to approximate the texture, flavor, appearance, or other aesthetic qualities or the chemical characteristics of any specific type of egg product, fish, meat product, poultry product, or cell culture products, which means a food product derived by harvesting animal cells and artificially replicating those cells in a growth medium in a lab to produce tissue.
Thank you. So this does not affect crab rangoon in any capacity?
No.
Okay, thank you so much.
Is further debate on the bill? Does lady wish to close debate on the bill? Lady in the 73rd, to close debate on the bill. If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there's 86 ayes, 11 nays, 3 members absent. A majority of members voting in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5349, West Virginia Truth in Food Labeling Act.
Are there title amendments? If not, the title as read by the clerk will be in the remaining title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5358, creating an ombudsman program within the Division of Corrections and Rehabilitation to review complaints against a state agency or correctional facility.
Are there objections to having this bill explained, or having it read? No objections are heard. Gentleman from the 8th to explain the bill.
Thank you, Mr. Speaker. Good afternoon, ladies and gentlemen. The purpose of this bill is to create an ombudsman program within the Division of Corrections and Rehabilitation to review complaints against the state agency or correctional facility. The committee substitute creates the West Virginia Corrections and Rehabilitation Ombudsman within the Office of DHS Inspector General and provides definitions, provides duties of the Ombudsman, procedures for operation of the service and review of complaints, accesses inmates and juvenile residents, and confidentiality of records. It provides for limitations of liability for the Ombudsman acting lawfully and prohibits interference with the Ombudsman. It also provides the Ombudsman program will be funded by appropriation of the legislature. That is a brief summary, Mr. Speaker.
You've heard the bill explained. Question now is, shall the bill pass? Gentleman from the 12th, Doug Chris.
Will the Vice Chair yield for question?
Yes.
Your last statement there about funding, was there a fiscal note?
There was.
Do you have an idea how much money you're talking about?
I do, yes. It is approximately $228,000.
All right, sir, and that has not been appropriated, is that correct?
That is true.
All right, thank you.
Yes.
Is there debate on the bill? If not, does the gentleman wish to close debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 98 ayes, 0 nays, and 2 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5358, creating an ombudsman program within the Division of Corrections and Rehabilitation to review complaints against a state agency or correctional facility.
Are there title amendments? If not, the title as read by the clerk will be in the remaining title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5373, relating to changing political parties less than 1 year prior to being appointed to political office.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman from the 8th, Dr. Kelly, to explain the bill.
Thank you, Mr. Speaker. The bill amends West Virginia Code to provide that individuals who are appointed to fill vacancies in elected partisan offices must be affiliated with the same political party that the individual vacating the office was affiliated with at the time of the previous election. The appointed individual must have been affiliated with that office for 1 year. That is a brief summary, Mr. Speaker.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Gentleman from 76, like a Garcia.
Thank you, Mr. Speaker. So, one of the things I love about this bill is an amendment that was put in the Judiciary Committee, and it takes me back to 2015. 2015 was the year of the Republican landslide in the House and the Senate, but the Senate was 17-17. It was split, and there was one member of the Senate that decided to switch from Democrat to Republican, and the Republicans took the majority in the Senate. The next year, that same senator had an opportunity and decided that he was going to resign for a position. And so when he resigned, there was a dispute at that time about whether Governor Tomlin had to appoint a Republican because he had resigned as a Republican, or whether he would appoint a Democrat because he was elected as a Democrat. Based on the language in the code at that time, which was really unclear, the Supreme Court took up the case on a mandamus, and they decided on January 22nd of 2016 in State Ex Rel Bia4 v. Tomlin that the language in the code at that time meant that the person would be appointed, would have to be the same political party at the time of the resignation. So, and I was in the governor's office at that time and was involved with that. And I thought, personally, that was one of the most unfair decisions that I ever seen. To have the people vote for somebody and then to have a person switch parties, leave, and then the person who's appointed, it's not based on who the people elected. It's based on stuff that happened in the meantime. So here we are, 8 years later, and I love the fact that this amendment, I think, fixes something that we since codified that part of the language of the Supreme Court's decision in code, but I didn't think it was right. But one of the things I really appreciated hearing in a bipartisan manner in the committee was, yes, the voters should be the ones who decide who's appointed. I think a lot of what this bill does, and a gentleman from the 46th in introducing this bill, it really is to try to get rid of any type, and I'm not necessarily referring to gamesmanship back then. The senator in question is a wonderful person, a wonderful friend. But I think there are situations where there can be gamesmanship that's used with respect to appointments, what party somebody's from, and I think this just makes the whole process as fundamentally fair as possible and brings it back to the voter. So I've been waiting for this for a long time, and I hope you join me in voting for this bill. Thank you.
Is there further debate on the bill? Does the gentleman wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 95 ayes, 1 nay, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5373 relating to changing political parties less than 1 year prior to being appointed to political office.
Are there title amendments?
Delegate Fast moves to amend the title.
The question is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares the title amendment adopted. Title as amended by the House will be and remain the title of the bill. Gentleman 96.
Mr. Speaker, I move that the bill take effect January 1st, 2025.
The question now is on the gentleman's motion that the bill take effect January 1st, 2025. For what purpose? The gentleman at 20, Douglas Foster, seek recognition.
Just a question of the gentleman.
Gentleman yield for a question.
Yes.
Why January 1st of 2025, since this only has to do with appointments?
That's what we have, January 1st, 2025, unless, do you want to change that? Do you want to make it? Mr. Speaker, I ask unanimous consent that I withdraw my original motion, and Mr. Speaker, I move that the bill take effect July 1, 2024 of this year.
Okay, the gentleman has reformed the motion to make the bill effective July 1st, 2024. Those in favor of the gentleman's motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 97 ayes, 0 nays, and 3 members absent. 2/3 of members having voted in the affirmative, the chair declares the bill effective July 1st, 2024. Clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5379 relating to financial assistance available for a prescription drug.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman 97 to explain the bill.
Thank you, Mr. Speaker. This bill would require pharmacy benefit managers to include any cost-sharing amounts paid by the insured or by another person when calculating the insured contributions to any applicable cost-sharing requirements. The bill would prevent insurers, pharmacies, benefit managers, and third-party administrators from changing the terms of health plan coverage based on the availability or the amount of financial assistance available for a prescription drug. The bill also would provide for new civil penalties up to $10,000 per violation on each of these sections as amended. That is the bill, Mr. Speaker, and I urge its passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5379 relating to financial assistance available for a prescription drug.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5405 providing additional professional development and support to West Virginia educators through teacher and leader induction and professional growth.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Chair recognizes the gentleman of the 38th, Doug Ellington, to explain the bill.
Thank you, Mr. Speaker. The bill authorizes the Department of Education to use up to $15 million in available school aid formula funds to help the county school systems by establishing and expanding regional professional training for teachers and aides to support the full implementation of last year's Third Grade Success Act. In addition, it provides training for teachers who are less than fully certified for the teaching position in which they are employed. Mr. Speaker, that's the bill, and I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5405 providing additional professional development and support to West Virginia educators through teacher and leader induction and professional growth.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5432 to move the essential functions of the Information Services and Communications Division into the Office of Technology.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman of the 72nd, Doug Riley, to explain the bill.
Thank you, Mr. Speaker. This bill will merge the functions of the outdated Information Services and Communications Division into the Office of Technology. The bill would also authorize the Office of Technology to assist the executive branch efforts to develop an agency data retention policies and directives. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, we have 97 ayes, 0 nays, and 3 members absent. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5432 to move the essential functions of the Information Services and Communications Division into the Office of Technology.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5437, relating to time limits imposed on the Division of Highways to grant a highway entrance permit.
Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman of the 22nd, Doug Linville, to explain the bill.
Thank you, Mr. Speaker. This bill amends the code to provide that when a permit to make an opening in a road is requested, that the Division of Highways shall have 60 days from the time of the application to approve or deny the requested permit. If no answer to that permit request is given from the division within that 60 days, then the permit is considered approved. If changes are requested based upon the application for the permit, this request for changes may be done only once, and the request for changes shall be considered satisfied if all changes from the first request are completed. If a matter concerning the application or request for changes is contested, the Division of Highways has 30 days to respond, and if they do not respond in that 30 days, the original permit request shall be considered approved. If the application for a permit is rejected by the Division of Highways within the time frame listed in this subsection, that denial may be contested in magistrate court in the county in which the permit was requested within 30 days of the denial. Mr. Speaker, this is shot clocks once again on regulatory approvals. That's beginning to be used in Congress, but we pioneered it right here about 3 years ago. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman, the 90th, I got Miller.
Thank you. What if they do it and they don't put it in the way the Highway Department wanted it put in?
That would be dealt with the same as it is right now, so that would be violating your permit.
Okay, thank you.
Question remains, shall the bill pass? Is there other debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, we have 98 ayes, 0 nays, and 2 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5437 relating to time limits imposed on the Division of Highways to grant a highway entrance permit.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5510, clarify law regarding the crime of witness tampering.
Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman from 51st to explain the bill.
Thank you, Mr. Speaker. This bill deals with crimes against public justice, criminal offenses, and penalties for intimidation, retaliation against public officers and employees, jurors, and witnesses, fraudulent official proceedings and legal processes against public officials and employees, or making public threats directed at inciting lawless action that could cause bodily harm and is likely to incite or produce such action. This committee substitute removes the requirement for the likelihood of imminent lawless action of a violent nature that could cause bodily harm from the prerequisites for the crime of intimidation and retaliation against a public official, witness, or juror. That is a summary, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, we have 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5510, clarify law regarding the crime of witness tampering.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5514, enhancing training requirements for county boards of education members.
Are there objections to having the bill explained in lieu of having the bill read? If not, gentleman from 77th, Douglas Statler, to explain the bill.
Thank you, Mr. Speaker. This bill requires newly elected or appointed members of a local boards of education to be taught budget management in addition to other topics now required in their orientation training required by the State Board of Education. Required in the orientation for new member training be completed within 30 days of being sworn into office. Enlarge the curriculum of topics that the State Board of Education must provide annually to members. increase the time spent in training annually from 7 hours to 12 hours, adds the legislative education chairs to the State Board of Education's County Board Member Training Standards Review Committee, then adds a requirement that the State Superintendent of Schools report annually to the Legislative Oversight Commission on Education Accountability about the committee's activities, on what training being provided, and participation by the board members. Increase the cap on board members' pay per meeting from $160 to $260, and reduces the maximum number of paid meetings per year from 50 to 40. Changes from may to shall certain directives regarding the state or the County Board of Education joining the West Virginia School Boards Association, and regarding payments of dues to that organization and the National School Boards Association. The committee reported a committee substitute that incorporates amendments of the Committee on Education to require the state emergency meetings and up to trainings, up 5 and up to 2 trainings. That's the bill, Mr. Speaker. I urge adoption.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Gentleman of 65th, Douglas Martin.
Thank you, Mr. Speaker. Will the gentleman yield for a question?
Yes, sir.
Okay, so currently, county board members, they get this training, is that correct? Or
Yes.
is this new?
All the board members are required training a year.
Okay, so so in your language here, it says that if a new board member comes on, then they must take this training as well. So if somebody was appointed.
If someone's appointed, they have to take the training within 30 days of the time that they were appointed.
And does it explain how that's done? Does the state offer a class, or how does that work exactly?
That would be up to the committee to determine that.
The committee? What committee?
That would be the, what is it? It's the Education Training Standards Review Committee.
Okay, and who pays for the training?
The training is paid for right now through the counties. I believe there's a correction.
Is it someone else?
The counties pays the training, I believe, unless I'm completely wrong, for their members to get this training. Only thing this bill does is allow the members now would be able to get paid for 2 trainings that they now cannot do at the present level of the legislation.
Okay, thank you. Thank you, Mr. Speaker.
Gentleman of 98, Douglas Espinoza.
Thank you, Mr. Chairman, or thank you, Mr. Speaker. Will the Vice Chairman continue to yield?
Yes, sir.
Could you go over the change in the number of meetings outlined in this legislation?
Yes. It changes now. They can do 50 meetings. It will change that to 40 meetings, but it also allows for up to 5 emergency meetings. A lot of times, this time of year, they will have RIF hearings. If they close the school down, then they're able to have special meetings into that area. If they have, are required by meetings for student expulsion or something like that, and are asked for a hearing, so that would allow them 5 meetings into that area in emergency. And it also allows that if a disaster in a county would happen, floods or something like that, then it would allow them to address that in those meetings.
But as far as the regular meetings are concerned, it would decrease that from 50 to 40?
That is correct.
What about the pay? Is there a change there too?
There is a change in the pay. Right now, they can go up to $160 per meeting. This would allow them to go up to $260. But again, this is paid by the counties, so the counties is allowed to go up to that level, cannot exceed that level.
So the cap increases from 160 to 260?
That is correct.
How about those special meetings you referenced? Those would also be at that same rate, I presume?
Special meetings would be at the same rate. That is correct.
So more pay and less meetings, is that how this bill works?
If the county chooses to do that.
Thank you. Thank you, Mr. Speaker.
Question still is, shall the bill pass? Is there further debate on this bill? Gentleman from the 14th, Douglas Foggin.
Thank you, Mr. Speaker. Permission to speak on the bill?
Yes, gentleman is recognized.
I would like to thank the author for introducing this. Our board members, a lot of times back home, made up of factory workers, bus drivers, farmers, bail bondsmen, teachers, all kinds of different walks of life, all of whom can do a good job advocating for our children and their education. But I really appreciate that you adding the extra training so that they can be more successful in handling the multi-million-dollar budgets that they're charged to handle. Thank you.
Gentleman to 65th, Douglas Martin.
Thank you, Mr. Speaker. I have a little trouble with liking this bill. I do like the aspect of the making sure that every member is trained. I don't like the reduced amount of potential board meetings. I think if the county needs that many meetings, then they should be able to do that. I don't know why you'd reduce it and then pay them more instead. For those reasons, I'm going to be against the bill. Thank you, Mr. Speaker.
Is there further debate on the bill? Chair recognizes the gentleman of the 77th to close debate on the bill.
Thank you, Mr. Speaker. As the gentleman's concerns was about reducing the amount of meetings, we did work with the School Boards Association on this legislation. We also worked with the Department of Ed and the State Department Board of Education. We worked through this, and if you look at the average amount of meetings that they have across it, generally is around 24. So we felt clearly that 40 would be a number, and we also allowed in the extra meetings that they could do in case of emergencies that they would arise up in their counties to give them the control that they need to do that. We added the extra training very simply as we look across the state, we have seen where the state board's been required to go in and take over some of these school systems. We are trying to eliminate that from happening if at all possible. We want our members of the local school boards having the knowledge that they need to be able to run. As the gentleman said, these are multi-million-dollar corporations that are operating out there in most of the counties. So we want them to have the clear knowledge and the training of what they can and can't do. And that takes more than just 7 hours of training a year. We also addressed in here that we have members of the school boards that would take the job and then not go to trainings. We addressed that issue in there. We clearly want them attending these meetings and trainings. So, ladies and gentlemen, I would urge for the students of the state of West Virginia, a better school board is going to make a better school system. Thank you, and I urge passage.
Debate on the bill has been closed. For what purpose does the gentleman of the 28th, Douglas Ross, seek recognition?
Thank you, Mr. Speaker. I'm currently a Board of Education candidate in my county, and I would like to ask if I need to go with Rule 49.
Under that set of facts, it would be the ruling of the chair that the gentleman would belong to a class of greater than 5 individuals and therefore would be eligible to vote on the question. Clerk will please note the gentleman's request. Gentleman to 14th, Douglas Foggin.
Mr. Speaker, is this the appropriate time to be to ask unanimous consent to be added as a bill sponsor?
Good as any.
5514.
Is space available on the bill? There is space available on the bill. Are there objections? No objections are heard. Gentleman to 14th, Douglas Foggin will be so added. Debate on the bill has been closed. Question now before the House is shall the bill pass. Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Clerk will will close the machine and ascertain the result on that question. There were 73 ayes, 24 nays, and 3 members absent. The majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5514, enhancing training requirements for county boards of education members.
Are there title amendments? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House or the Senate. Ladies and gentlemen, the next bill does need a technical amendment. Are there objections at this time to moving it to the foot of bills on third reading so that the staff can prepare a technical amendment? No objections are heard. House Bill 5551 will be moved to the foot of the bills on third reading today. Clerk will report next bill on third reading.
Committee substitute for House Bill 5583, relating to movement of oversized vehicles on roadways.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman, the 22nd, Doug Linville, to explain the bill.
Thank you, Mr. Speaker. House Bill 5583 amends the code to allow the Commissioner of Highways to issue a special permit that allows vehicles or a combination of vehicles of a size or weight or non-divisible load exceeding the maximum specified in the chapter or otherwise not in conformity with the provisions of the chapter over routes designated by the Commissioner of the Division of Highways during previously at times restricted times, that being nights during holidays and holiday weekends, Saturdays and Sundays, and provides clarity on what types of roads these special permits apply to. That is a summary of the bill, Mr. Speaker, and I urge its passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Gentleman of 20th, Doug Foster is recognized.
Just a quick question for the chairman.
Yes.
One thing on this permit, is this going to be a new permit on top of it or will it apply to is it allowing you to drive at nights and weekends with your current oversized load permit, or is it an additional on top of that?
I believe it is a special permit and not necessarily the traditional oversized load permit, Council. Am I? So, Council does advise me that I was correct. It is a special permit that's somewhat separate than the traditional oversized load.
So it'd just be an additional one on top of your current oversized load permit if you want to drive at night?
That is my understanding.
Okay, thank you. Speak to the bill, Mr.
Yes, gentleman is recognized.
Yeah, and I do think this is a very good bill that has been introduced here. So just from the construction industry perspective, you got to look at many of these highway construction projects are not allowed to be done until after dark. So many times 6 o'clock. So if you're working in the winter, you'll be prevented from actually making a delivery of an oversized load on the highway. So my company has actually had to drive down, park on the side of the road, and wait for 2 hours until they closed the road down so that they could unload an oversized load product. So this gives the ability for us to deliver products that are oversized loads to our highways projects that are at nighttime. So I think this is a very good bill. I wish it was included as an addition to the current oversized load project, but it's still a good bill and gives the ability to do this.
Gentleman to 37th, Gearhart's recognized.
Thank you. Could gentleman from 22nd yield, please?
Yes.
Refresh my memory just a little bit. I know in the committee you chair, there was some conversation, and it seems like the concern for these permits was not that was expressed by the delegate from the 20th. Could you elaborate on the intent of this bill or the specifics as to where the concern was for these permits?
So while I don't want to speak on behalf of the sponsor, it is my understanding that there is a company which was subject to an economic development project. This legislature has approved and modified certain laws in order to accommodate that being green power, and that due to the nature of the vehicles that they produce, and the time it takes to charge and the total distance or range that they have, that generally they truck those out as compared to just driving them out of their facility, and that they had had significant difficulty in delivering their products to market, most specifically on your favorite road in the whole state, the West Virginia Turnpike.
Thank you very much. Ladies and gentlemen, I understand the concern from the gentleman of the 20th with regard to these oversized loads. I do want to be specific, though, that this particular bill is being generated specifically to accommodate the weight of the buses that we now produce in South Charleston for green power. Those batteries in those particular vehicles are pretty doggone heavy, and thus they do cause some additional weight that gets past restrictions, and traveling on our roads at different hours does cause some difficulties. So just to be clear that this is not really generated for your typical construction loads or your normal oversized permits. It is somewhat tailored to a specific industry here in our state and for a specific product that we have discussed. Thank you, Mr. Chairman. Thank you, Mr.
Gentleman 98, Delegate Espinoza.
Thank you, Mr. Speaker. Will the gentleman continue to yield?
Yes.
So this permit, will this be like a one event permit, or will this be a permit that would apply to all deliveries for on certain specified roads for a extended period of time? How will that work?
So the council advises that the permits are ordinarily about a 5-day permit. The intent of the legislation is, again, as I understand, I'm not the lead sponsor, but as I understand the intent of the legislation, it is for certain known loads and for certain known routes to sort of have a blanket allowance to get the products to market. To give you a little bit of background, something similar was done for the Toyota motor manufacturing facility, and then in consultation, the lead sponsor, council, and the Division of Highways worked together to sort of utilize that, and we have, as a House, collectively worked thus far to ensure that while we're solving something for one particular purpose, that it is equally applicable to similarly situated entities.
Thank you for that. There was some discussion up in committee about some of the safety precautions that are typically associated with these oversized loads. Where did we come down on that? The legislation as it's before us, does that provide the commissioner the ability to impose safety requirements that he or she deems required?
It does. So the as amended yesterday here on the floor, it did make sure that the commissioner had flexibility to make sure that, whether there's a parade or something like that going on, or whether a particular route is better suited than over another, that the commissioner would be able to set the permit to utilize a particular route or a particular time.
Thank you. Thank you, Mr. Speaker.
Is there other debate on the bill? Does the gentleman wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 90 ayes, 7 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5583, relating of movement of oversized vehicles on roadways.
Are there title amendments?
Delegate Linville moves to amend the title.
Question now is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House and the Senate. Next bill on third reading.
House Bill 5594, exempting West Virginia University and Marshall University from contracts, agreements, or memorandums of understanding with spending units in state government with exceptions.
Question is, shall the bill pass? Gentleman 12th, Delegate Chris.
Mr. Speaker, I ask unanimous consent to amend on third reading.
Gentleman asks unanimous consent to offer an amendment to the bill on third reading. Are there objections? And no objections are heard. Does the clerk have an amendment?
Yes, sir.
Okay,
Please read it.
Clerk will please report the amendment.
This is HFA Chris 228, number 1, revised. Delegate Chris moves to amend the bill on page 2, section 1, line 31, following the word "and" by inserting West Virginia School of Osteopathic Medicine.
Question now is on the amendment just read by the clerk. Is there debate on the amendment? Is there debate on the amendment? If not, those in favor of adoption of the amendment? Yes, gentleman, 47 Longnecker is recognized.
Point of inquiry, can you elaborate on your amendment, please, sir?
I'm just adding the school to West Virginia University and Marshall University. And if you look at the contents of the bill, we're adding the West Virginia School of Osteopathic Medicine at the same level.
Okay, thank you. I didn't see this amendment earlier, so I just wanted to make sure. Thank you.
It was just put in the system. I apologize.
Appreciate it.
Is there debate on the amendment or questions? Gentleman from the 52nd, Dr. Rose, recognized.
If the gentleman would help us. In adding this, that's a medical school. On line 33, page 2, it refers to the contracts for Medicaid services. So this would not apply to that, but any other contract that they have with the state would be under this.
Yes, sir.
Thank you, sir.
Yes, sir.
Is there other debate on the amendment? If not, those in favor of adoption of the amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that amendment adopted. Clerk will please read the bill a third time as amended.
House Bill 5594, exempting West Virginia University and Marshall University from contracts, agreements, or memorandums of understanding with spending units in state government with exceptions.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman from the 12th to explain the bill.
Thank you, Mr. Speaker. The bill would amend the provisions of the West Virginia Code relating to the purchasing division in the West Virginia Department of Administration. The bill would exempt from purchasing division requiring contracts, agreements, or MOUs between the spending units and West Virginia University, Marshall University, and the West Virginia School of Osteopathic Medicine for services. I urge passage.
You've heard the bill explained. Question now, shall the bill pass? Is there debate on the bill? Gentleman, the 80th, Delegate Williams.
Thank you, Mr. Speaker. I ask unanimous consent to be added as a co-sponsor to 5594.
Is there space available on the bill? There is space on the bill. Are there objections? No objections are heard. The gentleman, the 80th, will be so added. Gentleman, the 34th, Delegate Dean.
Thank you, Mr. Speaker. Would the chairman yield? Yes. Why are we doing this for just those 3 universities and not the smaller regional colleges?
Yeah, based upon the type of contracts, agreements, and memorandums of understanding, the other small colleges don't seem to have those setups as we do at the 2 large institutions and the Osteopath Medical School.
Okay, thank you.
Yes, sir.
Question again is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 87 ayes, 10 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5594, exempting West Virginia University and Marshall University from contracts, agreements, or memorandums of understanding with spending units in state government with exceptions.
Are there title amendments?
This is HFAT Chris 228 revised. Delegate Chris moves to amend the title.
The question is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5595 relating to shortened procedure for road condition claims.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 12th, Delegate Chris, to explain the bill.
Thank you, Mr. Speaker. This bill would amend the provisions of the West Virginia Code relating to the Legislative Claims Commission. The bill would change the current shortened procedure for road condition claims. The current procedure for road condition claims that are under $3,000 and agreed to by the parties are stipulated to, and the claims then go through the regular claims bill before being paid to the claimant. This bill would authorize the payment outside of the regular claims process. The claimant would have to sign a release, and once executed, the West Virginia Division of Highways would notify the state auditor's office of the claim and the amount approved for payment. The state auditor would then issue his or her warrant to the treasurer in favor of the claimant. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Lady from the 73rd, Douglas Summers.
Mr. Speaker, I need to request a Rule 49 because I hit a very large pothole, broke a wheel, busted a tire. I'm going to benefit from this personally.
Sorry for your loss. It would be the ruling of the chair that under that set of facts, lady would belong to a class of greater than 5 individuals and therefore is eligible to vote on this question. Is there other debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5595 relating to shortened procedure for road condition claims.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5604 relating to procurement by state spending units.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman, 72nd, Douglas Riley, to explain the bill.
Thank you, Mr. Speaker. This bill would amend provisions of the West Virginia Code relating to purchases of technical infrastructure by the state. Current law requires that the Director of Division of Purchasing to solicit bids on behalf of spending units for the purchase of commodities, printings, and cost of such commodities or printing is estimated to exceed $25,000. This bill would increase the threshold costs from $25,000 to $250,000 for technical infrastructure to be purchased by spending units. The bill would require that the Secretary of Administration to approve for use at least 2 information technology marketplace portals for use by the state departments, state agencies, local governments, K-12 schools, and state institutions of higher education. The bill defines the term of information technology marketplace portal as a structured digital catalog that customers can use to find, deploy, and manage third-party information technology products and services whose pricing and discount levels are set by third-party providers. The committee substitute also requires the Director of Purchasing to respond to a request to use a competitively procured agreement within 30 days if he or she does not, or if it is approved if he or she does not. The spending unit is authorized to purchase technical infrastructure pursuant to the agreement. Thank you, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Lady from the 56th, Douglas Young.
Thank you, Mr. Speaker. Will my friend yield for a question?
Yes.
Thank you so much. I think this is a good bill, but I'm a little worried. Do you remember, let me see what year it was, in 2020 when we had the issue with Microsoft and Google and spending all the money on all the cloud services and duplicating efforts, and obviously I don't know all the details, but does this have anything to do with that?
No.
Okay, so this wouldn't allow that to happen again?
This allows for 2 marketplace portals so that they're pre-negotiated contracts. It provides for transparency and pre-negotiated contracts for government efficiency and savings.
Cool beans, thanks.
Is there other debate on the bill? Gentleman from 52nd, Douglas Rowe, is recognized.
Yes, sir. A question. Can the purchases be made for under $250,000 if the portal's not used?
It is an optional, it's a may.
Okay, but so for technology services and software or whatever, there's no bidding required until you go over $250,000.
An RFP would be required over 250, but a spending unit may elect to do a RFP under 250.
They may elect, but there's no requirement for that.
Over 250, it's required. Under 250, they may.
All right, thank you, sir. Thank you, Mr. Speaker.
Is there further debate on the bill? Gentleman in the 44th Delegate Kirby is recognized.
Thank you. Would the gentleman continue to yield? And I apologize for my ignorance on this, but as it sits right now, any project that would be under 25,000 would not require a bid, but anything over would. And we're changing that to 250,000?
For technical infrastructure only. So a technical infrastructure, if it's under 250, they can use a marketplace portal, which will have 2 RFPs that go out, or an RFP that goes out. They'll select at least 2 marketplace portals. Those marketplace portals are eligible to use for technical infrastructure under 250. If it's over 250, they're required to go out on a separate RFP.
Okay. So just so as we're voting for this, we understand bids that are under 249,000 would still, or projects under 249,000 would still be through a bidding process.
Yeah, they still can. It's not required. They could use the marketplace portal, which is a pre-negotiated contract. That's why you got on RFP first with the negotiated contracts. But they still, if a spending unit wants to, could.
What's the rationale for this?
So what we heard was in the testimony from procurement is that IT spends are very high. They're very costly. And so the 250,000, the gentleman from the 52nd asked if that was a large number. And the testimony we had in committee was that that was a very small spend as it relates to technical infrastructure. So the idea is that this allows for pre-negotiated contracts, RFP, not just individual, so that you can get that savings. You see this in the federal government and large corporations because you have very siloed divisions across 20 agencies. So you may have 20 agencies going out for the same procurement, when if we leverage the volume, we could get better rates. And so that's the reason.
Thank you. Thank you very much. Thank you. Mr. Speaker.
Yes, gentleman is recognized.
Speak to the bill. I have noticed at least another bill where we significantly increase the amount that would be necessary before the bidding process is mandatory. And I'm sure, like most of us in here, I've seen a lot of articles and news about government waste and misuse of government funds. While I don't question the intention of this bill, I think the effect could be that the taxpayers of the state could be once again left high and dry, and so I'll be voting against the bill. Thank you.
Gentleman, the 22nd, Doug Linville.
Thank you, Mr. Speaker. And just to sort of follow up on the colloquy between my 2 colleagues there. So I think the intent of this bill, so for those of you this has been made clear as mud, an RFP is a request for proposals. So you have essentially a competitive bid at the outset, okay? And they're able to say, look, here's all these products and services under $250,000, right? And it's basically going to be a bulk purchase contract that entities of the state can then go use and purchase off of instead of doing an independent onesie-twosie sort of RFP. So that's, as I understand it, all that this bill is doing. If doesn't modify any of the other purchasing requirements or bid requirements, the only time that you could go up to that $250,000 maximum purchase amount, right, or for any particular item, is when you're buying off of this contract, which was previously bid, right? So it's not removing the ordinary cap for just discretionary, not having to take something out for bid, with the underlying understanding that actually 2 things are happening there. Number one, we've put it out to bid, and we've selected actually 2 different marketplaces to be able to do this off of. So that's thing number one. And thing number 2, as the gentleman from the 72nd pointed out, we can, by buying in greater volume, right, and people not evaluating a deal just based upon a single purchase, that we actually get a better deal for the state. So while I share the concerns just generally about how we procure things, to my friend from, forgive me, Raleigh County, I believe, to my friend from Raleigh County, I think that is contemplated in the bill, and I would urge its passage.
Is there other debate on the bill? Is there other debate on the bill? Gentleman from the 72nd to close debate on the bill.
Thank you, Mr. Speaker, and I do appreciate the comments and understand the concern, but I do think this is an important step forward in modernizing West Virginia's digital infrastructure. I think this bill actually will provide better transparency and more efficient government use, because you'll know what the prices are, so it's completely out there. So it provides that transparency. You have the RFPs. It could be 13 different marketplace portals. It's not just limited to 2. So I think that's really important that the efficiency and the transparency are there. And I think it's what we need as we begin to build this digital infrastructure. So as we cut red tape, as we begin to increase competition with these marketplaces, I think you really see West Virginia begin to move forward. So with that, thank you, Mr. Speaker, and I urge adoption.
Debate on the bill has now been closed. Question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 84 ayes, 14 nays, 2 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5604 relating to procurement by state spending units.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. The next bill on third reading.
Committee substitute for House Bill 5609 relating to confidentiality of child care records and the foster care ombudsman.
Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman of the 64th, Delegate Burkhammer to explain the bill.
Thank you, Mr. Speaker. House Bill 5609 amends the code to allow the foster care ombudsman or its designee to access records containing the identity of the individual making the complaint of abuse or neglect while performing their official duties. This bill also references 499107 to ensure that this information is handled with strict confidentiality. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 95 ayes, 0 nays, and 5 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5609 relating to confidentiality of child care records and the foster care ombudsman.
Are there title amendments?
Delegate Fast moves to amend the title.
The question now is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading. Gentleman 96th.
Mr. Speaker, I ask unanimous consent to move the bill to the foot of the bills.
Chair's in error. We'll let the clerk report the bill first. Clerk will please report the next bill on third reading.
Committee substitute for House Bill 5617.
Gentleman 96th.
Mr. Speaker, I ask unanimous consent that we move the bill to the foot of the bills.
Are there objections to moving the bill to the foot of bills? There are no objections heard. Be so moved. Next bill on third reading.
Committee substitute for House Bill 5623 relating to absentee voting.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman of 58, Delegate Hall to explain the bill.
Thank you, Mr. Speaker. Relating to absentee voting, the purpose of this bill is to codify existing policy of the Secretary of State regarding the verification of absentee ballots. Committee substitute reads that it requires the Secretary of State to create an electronic absentee by mail ballot tracking system and requires certain content to be provided in this electronic system. That is a summary of the bill, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 95 ayes, 0 nays, and 5 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5623 relating to absentee voting.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5632 relating generally to West Virginia Real Estate License Act.
Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman to 68 to explain the bill.
Thank you, excuse me. Thank you, Mr. Speaker. The purpose of House Bill 5632 is to add a definition for property management, amend qualifications for broker's license, and amend obligations of non-resident brokers under the West Virginia Real Estate License Act. I urge passage.
You've heard the bill explained. Question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, we have 93 ayes, 1 nay, and 6 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5632 relating generally to West Virginia Real Estate License Act.
Are there title amendments? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5639, Prompt Payment Act of 2024.
Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman the 12th to explain the bill.
Thank you, Mr. Speaker. This bill will provide, this bill will give private state vendors prompt payment of their legitimate invoices within 45 days after the date of invoice is received by the state. If the state does not pay, then, excuse me, then from the 45th day, the state must pay 3% interest until the bill is paid. I urge passage.
You've heard the bill explained. Question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman the 12th, Doug Chris.
I ask for Rule 49 since I am a vendor of the state.
Chair suspects we need to do a count on that. If you seek a ruling from the chair pursuant to House Rule 49 as to whether you should vote on this question because you are a vendor for the state of West Virginia, please press your button now to seek such a ruling. Clerk will prepare the machine. Okay, clerk will close the machine. It is the ruling of the chair that we do have a class of greater than 5 individuals similarly situated. Therefore, all members are eligible to vote on this question. No members are excused. Is there further debate on the bill? Is there debate on the bill? Does the gentleman wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 95 ayes, 1 nay, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5639, Prompt Payment Act of 2024.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5668, creating the Responsible Gaming and Research Act.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman the 8th to explain the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, the bill provides for gaming data collection and sharing for scholarly purposes. The bill provides for preparation of the report and exempts this data from FOIA provisions. That is a brief, that is the bill, Mr. Speaker.
You've heard the bill explained. The question now is, shall the bill pass? Shall the bill pass? Gentleman the 5th, Doug Fluharty, is recognized.
Thank you, Mr. Speaker. I just want to say in committee we had some discussion from Professor Humphreys at WVU. What this bill is going to do, it's going to create the Responsible Gaming and Research Center at West Virginia University. And we are an R1 institution and poised to become a leader in the country when it comes to gaming responsibility and consumer protection. So as you know, West Virginia has many forms of legalized gaming. We have iGaming, we have sports betting, we have iLottery, and all of this data that's available to us at the current time is not being provided for research in an efficient form. So we know how to protect the consumer and really be at the forefront going forward in this fast evolving economy. And what this will do, it's going to create the program. In order to have an efficient program, you need the data. This data will now go to WVU. It'll create the program. It'll facilitate data research, which will facilitate results for consumers and create jobs, because we'll have a program that students can now go through, and we will be a leader in the entire country. And I just want to thank Dean Hall from the business school, and I want to thank the speaker for leading on this. When this was brought to their attention as a possibility, they said, let's get it done. And they moved fast with it. I was shocked that WVU was so ready and willing to jump in, and it's going to be a great result for not just WVU, but our entire state, and we're going to be a leader in the country. So thank you.
Is there further debate on this bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk, lady from the 82nd, Douglas Warner, your vote's not registered. The clerk will close the machine and ascertain the result. On that question, there were 84 ayes, 12 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5668, creating the Responsible Gaming and Research Act.
Are there title amendments? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5676, relating to changing the maximum amount a county clerk can charge to settle an estate and removing reference to fiduciary commissioner.
Are there objections to having the bill explained? In lieu of having the bill read? No objections are heard. Gentleman from 51st to explain the bill.
Thank you, Mr. Speaker. This bill amends the code to clarify procedures relating to a fiduciary commissioner and both regular estates and small estates during probate, as well as provides clarity to the process of an administrator accepting or rejecting claims, as well when a referral to a fiduciary commissioner is necessary, and also amends the code so that a fiduciary commissioner can charge an estate a maximum of $500 with outlined exceptions. It was previously $300 that a fiduciary commissioner could charge. This would make it $500. That's a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on this bill? Gentleman from the 52nd, Douglas Rowe, is recognized.
Thank you. Could you answer some questions, sir?
Yes.
Now, does this, in Kanawha County, we have a fiduciary supervisor system, and would any of this apply to the Kanawha County system with a fiduciary supervisor?
I believe that it would. It's when you have a situation, first of all, it just re-outlined the code. It's using a lot of existing language, but just placing it in a more fluent manner. And so when you have a situation where you have an appraisement of a estate is filed, the code says it must be referred to a fiduciary commissioner. But if it's $200 or $200,000 or less, and there's no claims filed, then it does not have to be referred to a fiduciary commissioner. So it just simply seems to tries to more fluently lay the language out in the code.
Well, in Kanawha, where there's a fiduciary supervisor, we don't have commissioners appointed. I mean, this would be a radical new procedure for us. I'm just wondering if you're confident that this would apply to the fiduciary supervisor systems.
This is not changing anything of what you're talking about. It's not changing when a probate estate is to be referred to a fiduciary commissioner or not. So if you have a fiduciary supervisor, it's not changing that. So, like, for instance, in the county where I live, if you file an estate and it's $200,000 or less in total assets, then reference to a fiduciary commissioner is not made. On the other hand, if it's over $200,000, reference to a fiduciary commissioner is made. Also, if you have a claim that is filed against an estate, if the claim is not rejected by the personal representative, then it's deemed valid. If the claim is rejected by the personal representative, then reference is made to a fiduciary commissioner. But as far as a supervisor, that wouldn't change.
All right, what about in terms of a creditor making a claim with a fiduciary supervisor? Would it become automatically a valid claim if not objected to by the personal representative?
If it is not objected to within, I believe it's 20 days with a supervisor as well, then it would be deemed valid, a valid claim.
All right. Does this affect small estates?
It would, yes, and it would operate in the same manner. If there's a claim and it's not objected to, then it would be deemed referred to a fiduciary commissioner, et cetera.
Okay, but if we have a small estate, there's no requirement for an appraisement to be filed, and there's no requirement for a fiduciary, for a commissioner, a fiduciary commissioner to be appointed.
Well, it can go to a fiduciary commissioner if you have an objected to claim, yes.
All right.
I mean, people can file a claim against a small estate, and then, of course, you have to have someone to oversee it, basically a judge, so to speak, to handle the claim and make a recommendation.
Who in Kanawha, for example, would be the fiduciary supervisor, not a appointed commissioner?
It would be the same, yes.
All right. Thank you, sir. Yes. Thank you very much.
Question again is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, question again is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 89 ayes, 8 nays, and 3 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5676 relating to changing the maximum amount a county clerk can charge to settle an estate and removing reference to fiduciary commissioner.
Are there title amendments?
Delegate Fast moves to amend the title.
Question now is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Gentleman 96th.
Mr. Speaker, I move, subject to announcements, that the House recess until 3:30 p.m.
Are there announcements? Gentleman 96th.
Yes, Mr. Speaker, your Committee on Rules will meet at 3:15 in the Members' Lounge.
Gentleman 35th, Doug Advance.
Thank you, Mr. Speaker. I ask unanimous consent to be added to as a co-sponsor of HB 4734 and 4883, if there's room.
There's space available on both bills. House Bill 4734 and House Bill 4883. There's space available is on both bills. There is space available on both bills. Are there objections? No objections are heard. Gentleman will be so added. Gentleman from the 66, Douglas Nestor.
Thank you, Mr. Speaker. I request unanimous consent to be added as a co-sponsor to House Bill 4883.
Are there objections? No objections are heard. Gentleman from the 36, gentleman will be so added. Gentleman from the 36, Douglas Green.
Thank you, Mr. Speaker. I ask for unanimous consent to be added as a co-sponsor to Bill 4313.
Are there objections? No objections are heard. Gentleman will be so added. Gentleman from the 93rd, Douglas Hornby.
Same for House Bill 5405, Mr. Speaker.
5405. Are there objections? No objections are heard. Gentleman will be so added. Gentleman from the 20th, Douglas Foster.
Thank you, Mr. Speaker. Inquiry of the clerk. I just wanted to know if we ran out of bill ad forms or not.
Gentleman from the 29th, Douglas Dillon.
Thank you, Mr. Speaker. Request unanimous consent to be added to House Bill 4709.
Are there objections? No objections are heard. Are there, gentlemen, will be so added. Are there other announcements? Are there other announcements? If not, the questions on the motion at the House recess until 3:30. Those in favor, please say aye. Those opposed, please say no. The ayes have it. We are in recess until 3:30. Okay, hello everyone. Let's call this afternoon's Committee on Rules meeting to order. Chair notes for the record, we do have a quorum of the committee present. Take your agenda packets, please, and turn to bills on third reading on special calendar. Chair will recognize the gentleman from 96th.
Mr. Speaker, I move committee substitute for House Bill 5331 to House calendar.
Questions on the motion that committee substitute for House Bill 5331 be moved on to House calendar. Those in favor of the motion, please say aye. Aye. Those opposed, please say no. The ayes have it. Chair declares that motion adopted. Let's turn our attention over onto the House calendar itself now. Gentleman 96th.
Thank you, Mr. Speaker. Ladies and gentlemen, third reading, I move House Bill 4700 to special calendar.
Gentleman's motion is that House Bill 4700 be moved from the House calendar onto the special calendar. Those in favor of the motion, please say aye. Aye. Those opposed, please say no. The ayes have it. Chair declares that motion adopted. Is there other business to come before this meeting? If not, gentleman 96th.
Mr. Speaker, I move that we adjourn.
Questions on the motion to adjourn the meeting? Those in favor, please say aye. Aye. Those opposed, please say no. Ayes have it. The motion is adopted. Thank you. We are adjourned.
You sunk our boat.
You sunk your battleship.
House will please return to order. House will please return to order. Gentleman, the 96th for an update on the calendar.
Thank you, Mr. Speaker. Your committee on rules met, and we moved committee substitute for House Bill 5331 to the House calendar, and we moved House Bill 4700 to the special calendar.
Gentleman from the 20th, Delegate Foster is recognized.
Inquiry of the gentleman, House Bill 5331. What bill was that was moved to House calendar?
Relating to boating safety education certificate.
And what particularly was the objection to motorboating?
Calendar management.
Mr. Speaker, I would move House Bill 5331 from House calendar to special calendar.
Gentleman moves that the bill be moved from the House calendar to the special calendar. That is a rule suspension vote. Clerk will please prepare the machine. Those in favor of moving House Bill 5331 from the House calendar to the special calendar will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there are 12 ayes, 77 nays, 11 members absent, less than two-thirds in the affirmative. The chair declares that motion lost. Clerk will please report the next bill on third reading.
House Bill 4700, banning certain persons from sport wagering activities.
Ladies and gentlemen, this bill was advanced to third reading yesterday with the general right to amend. Are there amendments to the bill?
Delegate Fluharty moves to amend the bill on page 1 by striking everything after the enacting clause and inserting in lieu thereof.
Does the gentleman wish to explain the amendment? Are there objections to allowing the amendment to be explained? No objections are heard. Gentleman from the 5th is recognized to explain the amendment.
Thank you, Mr. Speaker. This amendment in the system is 228-1_1. It clarifies, based on the bill, certain scenarios where the lottery may ban individuals from sports betting. And these bans would occur primarily for 3 reasons, and we're going to allow the lottery to promulgate rules to further investigate these scenarios, but it will include 3 reasons. 1, if the individual had committed battery on an athletic official, a coach, anybody under 61-215A. If they had a prior violation, if they violated an order from the commission previously, so if the lottery commission had an order that individual said, hey, you've been warned and you can't harass again. If they do, as an example, then they could be stricken. And 3rd, if the commission determines that the person poses a threat to the safety of participants in a sporting event and has engaged in a pattern of conduct. So what we're talking about here, this follows a bill in Ohio where there were threats made to players, death threats. Well, the way it works now, in my neck of the woods in Northern Panhandle, you could be banned in Ohio for sports betting, but you could cross the river and participate in West Virginia, even though you may have been making death threats to players or coaches on social media. So we have a rise, and there's a letter on your desk now from the NCAA. And this is signed by the president of the NCAA, and he states in there support for this piece of legislation. And the reason for that is because there has been increased activity in threats to players because of sports betting, because they lose a bet, they get online, they threaten to kill somebody, things that are just crazy. So we should be able to say, this is a privilege, and you've lost that privilege if you're threatening players. And that's what the NCAA supports, and that's what this strike and insert does, is clarify that and allow the Lottery Commission to promulgate rules to do just that. So, thank you.
The question is on the amendment. The question is on the amendment. Gentleman from the 98th, Delegate Espinosa is recognized.
Thank you, Mr. Speaker. I'd like to rise in favor of the gentleman's amendment. I think it's a good amendment and will enhance the overall bill. Thank you.
Gentleman from the 20th, Delegate Foster is recognized.
Does the sponsor of the amendment yield? So your amendment wouldn't include anybody that was engaged in some spirited heckling up in the northern panhandle.
It would not.
Was escorted
It
out
would
by
not.
police officers.
I knew you were going to do that. It would not. Some good old-fashioned heckling.
So good old-fashioned heckling is
Good
still
old-fashioned
okay?
heckling. That's always welcome. I think maybe you should get a bonus incentive on the gambling apps for it.
As long as it's Pitt fans, correct?
That's right. There's an exception for Pitt fans.
Okay, even if you're escorted out by the police, as long as it's Pitt fans. All right, thank you.
Gentleman from the 26th, District Rohrbach, recognized.
Thank you, Mr. Speaker. I, too, rise to support the gentleman's amendment. I think this gives a layer of protection to our student athletes, and I would urge adoption of the gentleman's amendment.
Is there further debate on the amendment? On the amendment. Does the gentleman wish to close debate on the amendment? The question is, shall the amendment be adopted? Those in favor of adoption of the amendment will please say aye. Aye. Those opposed will please say no. Ayes appear to have it. The ayes have it. Chair declares the amendment adopted. Are there other amendments to the bill? Are there other amendments to the bill? If not, the bill will be advanced to third reading. Clerk will please read the bill a third time.
House Bill 4700, banning certain persons from sport wagering activities.
Are there objections to having the amendment explained in lieu of having the bill explained in lieu of having the bill read in full? No objections are heard. Gentleman from the 8th, Dr. Kelly.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill amends the West Virginia Code to require the Lottery Commission to promulgate a legislative rule for banning patrons of sports betting. Currently, the Commission has broad discretion to ban individuals. This bill requires the Commission to propose a list of reasons for banning a patron. The list must include conviction of the crime of assault or battery on an athletic official, violating an order of the Commission, and threatening or harassing an official, coach, or participant of a sporting event. Mr. Speaker, that is a brief summary of the bill.
Question before the House is, shall the bill pass? Gentleman from the 21st, Dr. Cannon.
Thank you, Mr. Speaker. I ask unanimous consent to be added as a sponsor to this bill, House Bill 4700.
Is there space available on the bill?
Yes.
If there's no objection, the gentleman will be so added. No objections are heard. Gentleman from the 21st, Dr. Cannon, will be so added as a sponsor on the bill. Gentleman from the 25th, Dr. Hornbuckle.
Thank you, Mr. Speaker. Same request.
Is there space available on the bill?
Yes, sir.
Space is available on the bill. Are there objections? Gentleman will be so added. Question again is, shall the bill pass? Is there other debate on the bill? Is there other debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. We have 90 ayes, 1 nay, and 9 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 4700, banning certain persons from sport wagering activities.
Are there title amendments?
Delegate Fluharty moves to amend the title.
Questions on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5685 relating to Medicaid cost containment.
Ladies and gentlemen, this bill was advanced to third reading yesterday with the general right to amend. Are there amendments to the bill?
Delegate Rohrbach moves to amend the bill on page 1 by striking everything after the enacting clause and inserting in lieu thereof the following.
Are there objections to allowing the sponsor to explain the amendment in lieu of having it read in full? No objections are heard. Gentleman from 26, Delegate Rohrbach, is recognized to explain the primary amendment.
Thank you, Mr. Speaker. Good afternoon, ladies and gentlemen. This amendment accomplishes 2 changes to the committee substitute. It changes the requirement that a state plan amendment or Medicaid waiver be sent to the Legislative Rulemaking Committee for approval. Instead, the Bureau of Medical Services shall submit the state plan amendment or Medicaid waiver to LACRA. It shall provide the recommendation to Bureau of Medicaid Services on the changes. It also changes the amount to $3 million in state funds that triggers a look at certain budgetary provisions of the bill instead of $3 million in total additional expenditures. So I'll remind you with the 3-to-1 match, what that's basically saying is it's raising the threshold to $12 million in total expenditure. That's a summary of the primary amendment, and I urge adoption, and I know there is an amendment.
You've heard the primary amendment explained. Are there amendments to the amendment?
Delegate Williams moves to amend the amendment. This is HFA Williams 2-27.
Gentleman, the 80th, Delegate Williams.
Thank you, Mr. Speaker. I ask unanimous consent to withdraw this amendment.
Are there objections to allowing this amendment to be withdrawn? No objections are heard. That amendment will be withdrawn. Clerk will report the next of the secondary amendments.
Delegate Williams moves to amend the amendment. This is HFA Williams 227 revised.
Are there objections to allowing the sponsor to explain this amendment? There are no objections heard. Gentleman 80th, Delegate Williams is recognized to explain the secondary amendment.
Thank you, Mr. Speaker. Ladies and gentlemen, my amendment is fairly simple. On page 3, line 2, it inserts new language for that $3 million trigger that the gentleman from Cabell was talking to you about. So it's my understanding that the intent of this bill is to look at Medicaid spending in the state of West Virginia. And if we are going to have spending that is starting to get out of control, we want to come in and take a look at that legislatively as a body. My contention is that the $3 million figure, even in state funding, that figure is relatively small, and with the nature of healthcare, that would be eclipsed guaranteed on an annual basis. So what my amendment seeks to do is, instead of going off of that nominal figure of $3 million, we would instead tie it to the inflationary indicator that the Congressional Budget Office uses for Medicare and Medicaid. And so the practical effect of this is, while we are wanting to keep in check out of control Medicaid spending, this would make sure that we are judging our Medicaid spending by those on a national level. So if you could imagine a graph with Medicaid spending nationally going up like this across the x-axis, then our spending is controlled here. We shouldn't be punished. We shouldn't be punishing our Medicaid recipients for not for having less than the national average of Medicaid expenditures. I know it's fairly complicated. I'm happy to answer any questions that you have, and Mr. Speaker, I'd ask for the right to close. Thank you.
Question now is on the secondary amendment. Shall the secondary amendment be adopted? Gentleman from the 26th, Delegate Rohrbox, recognized.
Thank you, Mr. Speaker. Ladies and gentlemen, I respectfully urge rejection of the gentleman's amendment, but I'm going to go into a few things here about why. First of all, this doesn't trigger anything other than the fact that they have to report there's an overage. Doesn't mean we do anything about it. It just makes us aware. Now, here's the important thing. This bill breaks it down in this amendment by state plan amendments or Medicaid waivers. So it's not in aggregate of the entire program. The entire spend of state Medicaid is, at the current time, is about $5.4 billion. But this breaks it down, and I'm going to give you some examples of why we probably need to take a little closer look than just a big aggregate thing on a percentage basis. And I'm going to give you some examples. Our largest expenditure in the state Medicaid program currently is our long-term care program, $935 million a year. Now, let's say we had a 5% inflation. That would be $47 million. So we'd have to go past that before you'd hit the trigger that we ought to be looking at this. Some other very large expenditures would be the prescription program, which is $434 million. And that's net of the rebates that we get. So another one is the IDD waiver program, $425 million. So I think it's more prudent to adopt essentially the $12 million, the $3 million in state money, the 3-to-1 match to get to the $12 million, so these programs don't get away from us before we look at them. That's all we're doing, is we're looking. That's all we're doing. We're not saying we're going to make any changes. Everything may be justified, But as the fiduciaries of this state, I think the people in this body should look at these things before they get away from us so we can continue to offer these programs. So I urge rejection of the gentleman's amendment. Thank you, Mr. Speaker.
Gentleman with 52nd, Doug Rose, recognized.
Thank you. Would the gentleman from Cabell help us on this?
Gladly.
Okay, now, as I understand it, I'm looking here on page, well, the last page of your bill, and it says that program expenditures greater than $3 million have to be reported. Now, the $3 million, what's a program expenditure? Total program expenditure.
I assume the total program you're speaking of is the state Medicaid program. That's $5.4 billion.
Well, I mean, you know, your amendment says that the Bureau for Medical Services shall submit Medicaid waivers and state plan amendments that grow total program expenditures.
And that's where it gets broken down into the sections, 3 of which I just gave examples, and I have a whole page of examples here that I can give you.
Right. But I'm wondering what triggers it. In other words, the $3 million feels like a trigger, and if it's $3 million on a $5 billion program, that's not even close to the natural inflation rate. I'm just trying to figure out how we apply it.
To the gentleman, it's the growth in that particular expenditure. If you look on line 2 of the amendment, it's the growth. So if you had $50 million the year before in state funds, that would be about a $200 million total expenditure. So we're saying the trigger would be hit if that went to $53 million in state funds, and then you'd quadruple that to get to the, $212 million.
Well, that takes me back to the amendment that's proposed, which pegs it to natural inflationary increases that the federal government would determine for medical costs. And I think they run something like 8 or 10% a year or something. And as I understand his amendment, it wouldn't automatically require every single program to be reported because it had an increase of $3 million. I mean, I don't see any opt-out on this. I think we're going to get the reports every single year if it's only $3 million. Whereas with his amendment, it's triggered, as I understand it, to the federal inflationary rate for healthcare cost increases. So we would be really pegging it to where it would naturally be, and especially whenever we do the consideration about the waivers and everything to follow that.
The gentleman's assumption would be correct if you wanted to continue to boost the Medicaid program up that much every year. There's nothing in this bill other than reporting requirements, so the finance committees can be made aware of what's coming down the road.
Yeah, but we're going to kill them with reports. Every single program, every single dollar they're going to have to report, and then we'll have to figure out what to do with it. And I don't think that his amendment, as I understand it, does not increase or decrease anything. It really just pegs it to where we really are, and if healthcare costs go up 8-10% a year, which I think is in the ballpark of what they do, this will be an automatic report every single year, and it just seems like it's unnecessary. It doesn't affect the costs or how we size the programs, but it certainly creates a ton of paper, and I'm not sure that all we'd have to do is just take every program expenditure every year and look at it and try to figure out if there's things that we can do for it.
And the gentleman's certainly entitled to that opinion, but again, I don't think generating a fair amount of oversight, and as the gentleman says, paper, if that's the way you want to look at it, for a $5.4 billion program, I don't think that's totally unjustified.
Well, when the trigger's $3 million on $5 billion, it's no trigger at all. It's like every single year we're going to get this in our lap.
To the gentleman, it's an increase in state funds. So that's really about a $12 billion trigger as far as expenditures go. The expenditures I'm reporting are total expenditures. So with the 3-to-1 match, that's going to be about $12 million. So yes, I guess we are saying if programs go up, make us aware. It's up to us to fund it. That's up to the finance chairs to work that into the budget. But we need to know these things, and we'll talk about some other reports when we get into discussion of the bill. But we're not on discussion of the bill yet. We're on discussion of the gentleman's amendment to the amendment.
Right.
And I think it's more prudent to go with the essentially the 12 million.
12 million. I'm looking for 12. I don't see 12.
Again, for
Three,
the
I see.
gentleman, it's the 3 million quadrupled with the match. You can think of it because it's $3 million in state funding. State funding.
Do we get 3 reports or 4? At 3 million, I guess it takes me back to my original question. I didn't know what total program expenditures meant unless it is the absolute total,
It's
which
the
is
total
more
program
federal than
expenditure.
state,
But out of that, there is state monies, and then there are federal match monies.
Okay.
So you can look at it either way you want.
Thank you, sir. Mr. Speaker, may I
Gentleman is
inquire?
recognized to speak in debate.
Yes, I'd like to inquire of the gentleman about his amendment and how it would impact.
Gentleman is recognized for that purpose.
We were just having a discussion about it. It feels like that we're going to get all this paper every single year, and we could just order that, and there's no reason to have a $3 million trigger in it. But is that right or wrong in terms of the amendment you propose?
I think with my amendment, we would be giving leadway so that if Medicaid and our administration of Medicaid in the state of West Virginia is performing relatively well to the national average, there's no need for the legislature to get involved. And as you indicate, with this nominal $3 million in state funds out of $1.8 billion state fund budget for Medicaid, that trigger would be surpassed after 2 weeks.
Okay, thank you. Thank you, Mr. Speaker.
Lady in the 73rd, Delegate Summers is recognized.
Thank you, Mr. Speaker. Would the gentleman from the 80th yield?
Certainly.
Okay, I have 2 questions based on what you said. So first of all, you said the people would be punished if we did it this way instead of doing your way. Can you help me understand that?
I guess what I was trying to say is that Medicaid expenses are something that we have taken on as a part of state government to try to provide health care to our citizens. And my fear is if we have this overly scrupulous view that eventually we would see the administration of Medicaid with so-called flat budgets, and that would diminish the value that people are receiving from Medicaid.
How do you determine the value
Of
the programs?
I suppose in terms of what individuals are receiving in terms of care, in terms of the programs that we have within Medicaid, I guess that's where I'm going with that.
Okay, as long as we're just not equating increased spending as increased value. That's not what you're saying.
No, no.
Okay. If the committee gets the reports to show them where the spending has occurred, do you think then that'll give them an opportunity to look at the different programs and see if we're getting results based on the amount of money that we're spending?
I think certainly they could, but I also think that we have that opportunity presently with budget committee hearings and having DHHR come to us on an annual basis. I think that opportunity exists now to an extent.
Do you think as a finance committee member you would have been able to ask Medicaid about all of these different programs that they're doing and be educated to ask them that?
I think we could have asked questions. In that committee, we often have questions fielded about seemingly minute details, and we're given an answer later on that subject.
Okay, thank you.
Thank you.
Gentleman from the 22nd, Doug Linville.
Thank you, Mr. Speaker. Would the gentleman from the 26th yield, please?
Yes.
So I need to ask you a question about the underlying amendment such that I can understand what I would advocate for on the gentleman's amendment to the amendment. So as the bill was advanced by the Committee on Finance, I know that it included that it would go through the legislative rulemaking review process as compared to LACRA. But I think as I'm reading the gentleman's amendment, that essentially LACRA is just being advised, and that in your amendment that you're ultimately offering, that there is no ability to say no. I'm reading words like should, and that sort of thing instead of shall in the gentleman's amendment. So so that I understand the effect of your amendment and the effect of his amendment to it, could you help me understand, is there an ability for LACRA to say no?
No, there's not. It says the commission, which is LACRA, shall provide its recommendations to the chairs of the finance committees.
Okay. So the question before us being on the gentleman's amendment would simply be, you know, when it's triggered that we're even advised that they've done something, but we have no power or control via the power of the purse at that point to say no. When these modifications to the state plan amendments are made, can that commit the state to a certain level of funding in an agreement with the federal government outside of the legislative process?
If we adopt a state plan amendment, then we'd better be prepared to fund it, would be my thoughts. So I think this is just, and when we get to the bill, we're going to get into some of this, but we're really kind of jumping a step ahead.
I understand. I just wanted to better understand the gentleman's. All right, Mr. Speaker, I'll speak to the amendment I know I'm recognized.
Yes, you are. The gentleman's recognized for that purpose.
All right. So I'm going to rise to oppose the gentleman's amendment to the amendment for one specific reason. We heard in the Committee on Finance that supposedly, since 2019, that the Medicaid program has not grown in excess of the national average or national Medicaid inflation rate. But I'd like for you to understand what number that is. Since 2019, the spend in Medicaid has went up $1.4 billion. Compare that to the growth in spending on your state's budget. We're south of $5 billion total. Even right now, we're just south of $5 billion. And that's went up $1.4 billion. Over that same period of time, your state's budget, and while we've cut taxes and everything else, your state's budget has not went up $500 million. So I think the gentleman's amendment would completely, essentially gut everything about what this bill is purported to do, other than some of the other reporting which is required in the bill. But I think anytime somebody can make a $250 million modification, we certainly ought to know about it. And that's, I think, what that averages out to be since 2019. And for all those reasons, I would please ask each of you to oppose the gentleman's amendment to the amendment. Thank you, Mr. Speaker.
Is there further debate on the secondary amendment? Gentleman from the 25th District, Hornbuckle is recognized.
Thank you, Mr. Speaker. I rise to support the gentleman's amendment. I do believe that $1.4 billion that he is alluding to, if that is the only opposition that he has, half of that is from the base budget and half of that is from special revenue, I do believe. So I would support the gentleman's amendment from the 80th.
Is there further debate on the secondary amendment? Gentleman from 52nd District Row is recognized.
Questions again of the gentleman. Based on the comments that we just heard, I looked at the effect of the report. We're talking about we're just getting reports. They just sort of pile up and we can do something with them if we choose. I don't read the statute to say that, or your amendment to say that, because the effect is once the report's made, then within 60 days of submission, the commission, which I'm not sure which commission that is, that's Oversight Commission, shall recommend to the Bureau three things. It proceeds with submission of the Medicaid waiver state plan. In other words, just sort of let it go on. But look at number 2. It should change the Medicaid waiver or state plan amendment. That implies that the Bureau would make that decision. Is that a decision for the Bureau or for the legislature?
If you'll see, it says the commission shall make a recommend or make a recommendation to the Bureau. Right. It doesn't say they shall force them to do anything. And then the last line, it's C on line 8, the commission shall provide its recommendation to the chairs of the finance committee. So they're going to make recommendations to the chairs and back to BMS, Bureau of Medicaid Services.
So number 2 there on line 6 is just a statement by the commission.
You'd be correct.
To make the change, but it's not mandatory that they do.
You're correct. Or it could even recommend that they withdraw it. The ultimate answer here, though, is it's going to go in front of the chairs of the finance committees, because at the end of the day, it's going to have to be funded. So this is just to proactively look at these when they're made and see if it's something that we can fit in the budget and get the finance chairs aware that this is coming. So, and it also, if the LACRA says, okay, this looks like a good amendment or a state plan amendment or a good waiver, then they'll make that recommendation so the chairs can go ahead and start planning on it. I think it allows for a little better planning at the level of the finance committees.
Thank you, sir. Thank you, Mr. Speaker.
Lady from the 56th, Delegate Young, is recognized.
Thank you. Will the Chair of Technology and Infrastructure yield for a question?
Yes.
Thank you. You mentioned a $1.4 billion number. Could you tell me that again?
Yes, that was testimony in the Committee on Technology, or excuse me, not in Technology and Infrastructure, in the Committee on Finance, as we reviewed this bill, that the gentlelady that testified that since 2019, the overall spend in the Medicaid programs of this state has increased $1.4 billion since 2019.
Between 2019 and 2023?
It's my understanding. That's what she testified to.
So during the pandemic?
We're presently out of the pandemic, aren't we?
2019 to 2023, I would say most of that's the pandemic.
Which last year was certainly not. I mean, the president said that the pandemic was over.
Sure, but all of the programs that were put into place just started unwinding within the past year. Would you agree to that?
I would not.
Okay, Medicaid didn't just kick off a bunch of people like months ago?
Again, I would not agree that the unwinding of some of the pandemic programs only began within the last year.
Okay. Of that $1.4 billion, do you know how much of it was state versus federal?
My understanding is that it's about one state dollar for every 3 federal dollars.
Okay, but during the pandemic, it was 1 to 10, not 1 to 4. But you're saying it's 1 to 4?
So again, we're talking about right now, right? So since 2019, presently where we're at is $1.4 billion annually higher, right? So if the pandemic's over, right, and we're looking at fiscal year 25, if we're up $1.4 billion and the expanded eligibility, all those things are there, then I would make the argument to you. Excuse me, have been rolled back, and we are still $1.4 billion higher, right, as the gentlelady testified to in the Finance Committee. That's a significant problem, and it's a $250 million annual increase, roughly.
But that's not what I asked you. I asked you how much of that $1.4 billion was state dollars.
So again, if it's been rolled back, it's $1 for 1 to 3.
Okay, it was my understanding that we only increased by $30 million over that time, but thank you.
Gentleman from the 11th, Delegate Fehrenbacher.
Thank you, Mr. Speaker. I'd like to speak to the amendment. As I looked at the proposal from my friend in the 80th, I went to the Congressional Budget Office website, and I found that Medicare over the time period 1974 to 2023 increased by about 2.1% per year, and Medicaid on a separate line was increased about 1.3% per year. In looking at some of the data that was shared about state plan amendments and Medicaid waivers, as the delegate from the 26th cited, the largest one is on the long-term care or managed care. And at that combined rate of 2.1 and 1.3%, that could mean that an increase of $85 million at the current level of spending they would not have to report against. And frankly, I'd like to get a little bit more specificity. It's very possible I will acknowledge that $3 million in state funding or $12 million in combined funding may be too brief, but I'd rather get at least initially flooded with reports and then attenuate what that number ought to be. But I would be concerned starting out from the very beginning here with something that would be too large an increase, and respectfully would oppose the amendment and ask for its rejection. Thank you.
Is there other debate on the secondary amendment before the chair recognizes the sponsor? If not, gentleman from the 80th, Delegate Williams, to close debate on the secondary amendment.
Thank you, Mr. Speaker, and thank you to everyone who took time to speak to this issue. When looking at any budget, at any sum of money, it is important to look at it using real figures, i.e. a percentage and not a nominal number. $3 million, okay, that's a lot to spend on a vacation, but when you're talking about a multi-billion-dollar health insurance program, not a whole lot of money. And so if we have this in here, presumably as some type of performance metric or performance trigger, why make it so small? If we're looking at it from a performance standpoint, why not use a metric that averages annual Medicaid and Medicare spending and compare it to that? And I guess if we come in here and do this locker review every single year, if it's just that, I don't really have too much concern. But if we're going to make the trigger a measly $3 million, my concern is that what will trickle into the way that we treat Medicaid spending will be the same way that we've treated budgets these past 8 years. Flat budget, flat budget, flat budget. A flat budget isn't a flat budget with inflation. And so if we're going to start really looking at our Medicaid spend and seeing what we're doing and potentially cutting programs to 500,000 West Virginians who need it, I'd say that there should be a good justification to look under the hood in the first place. And that comes with an inflationary indicator that looks at real figures using a percentage as prescribed on an annual basis by the Congressional Budget Office. Not $3 million. I urge adoption of the amendment, and I hope you'll be with me. Thank you, Mr. Speaker.
So debate on the secondary amendment is now closed. The question is, shall the secondary amendment be adopted? Those in favor of adoption will say aye. Those opposed will say no. Noes appear to have it. Okay, noes have it. Chair declares that secondary amendment lost. Are there other secondary amendments? If not, the question now is again on the primary amendment. Is there debate on the primary amendment? Gentleman from the 22nd, Douglas Lenable, is recognized.
Thank you, Mr. Speaker. Would the gentleman yield?
Yes.
So, as the bill came out of the Committee on Finance, it was that the Rules Committee, which I understand we may wish to place that responsibility in another of our entities, but that the Rules Committee had actual authority rather than basically making a recommendation. Can you help me understand why, in the gentleman's proposed amendment, that you would seek to no longer grant that authority to say no?
Well, again, rulemaking didn't have authority, councils informed me. They simply had, again, a supervisory role. So, but the chairman of the rulemaking, joint rulemaking, pointed out that they really don't do this type of budgetary work. And frankly, the committee that is in charge of oversight of Medicaid is LACRA, the legislative, and I'll remind people what LACRA stands for. It's the Legislative Oversight Commission, Health and Human Resources Accountability. We didn't change the name when we broke it up because everybody was used to the name, but that's what it is. It oversees the functions, and we get reports every month about the budgetary matters, and if there are any problems in the facilities, that's where this resides in our legislature, is in the Joint Committee of LACRA.
Sure. So I can 100% support those reports and those recommendations or approval coming from the Legislative Oversight Commission on Health and Human Resources Accountability. And I know that you have the assistance of counsel there, and counsel advised that there was no approval in the committee substitute as it extended from the House Finance Committee. But I'm on page 1, lines 2, 3, and 4. So it goes into, actually it just begins, the Bureau for Medical Services shall submit all Medicaid waivers and state plan amendments that grow total program expenditures $3 million or more beyond current expenses of the most recent available fiscal year through legislative rulemaking and the broader legislature for legislative approval. So does council still feel that given that first sentence of the bill that we had no approval or the ability to deny a state plan amendment?
Yeah. Again, as we do with all of our rules, rulemaking, puts the rules bundles together, and submits them to the whole legislature, that's no different than anything that rulemaking does. But the final authority rests here, and in budgetary matters, it first goes to the finance committees, put together a budget of which we'll all be voting on next week. So I think the authority on anything does not rest with joint rulemaking. They have, again, just like is being proposed here, they have a capacity to recommend something. And they do recommend a lot of things to this body, but the final vote occurs here and in the Senate.
Sure. So totally understand that. My question to the gentleman is, and I began it sort of on the last amendment to the amendment, if the department were to submit a state plan amendment, which is SPA, or they were calling it SPAs in the Committee on Finance, can that commit the state prior to review by this body or our colleagues across the way who have the power of the purse? Can that commit this state to a certain level of funding without legislative action?
It could, but only to the degree that it was part of last year's budget. I mean, normally what they'd have to do is find the money in the budget. If they created something new, they're going to fund it out of something old, usually. It'll be a modification. A lot of these aren't necessarily new programs. They're modifications to existing programs or extensions to existing programs, and they would have to have the money in their budget that they're currently operating under to pay for it. Now, if they want additional funding, then that's where this is going to trigger, the total growth phenomenon as it's called for in the bill, and then that's going to have to come back through the process. And again, the commission shall provide its recommendations to the chairs of the finance committees. So it's going back to the finance committees to work into the budget that's being put together by the next legislature. That's where the buck ultimately stops.
Sure. So let me maybe make this as simple as possible. Would the finance committees, would this entire body and that over in the Senate, if a state plan amendment were put forward by the department, could we have the ability as we review these items to say no?
Yes. That you just don't fund it. You say no when you don't fund it.
Okay, so that agreement with the federal government does not commit this state, this legislature, to some specific level of appropriation?
Correct. Yeah.
All right, very good.
The buck stops right up in House and Senate Finance.
Very good. I urge adoption then. Thank you, Mr. Speaker.
Is there other debate on the primary amendment? Gentleman from the 52nd row is recognized.
Thank you, Mr. Speaker. Could you help me on this? Now, I'm looking at the primary amendment on page 1, lines 11 and 12, and it talks about requiring the Bureau to determine how we could reduce 1% state match in programming. Now, what is state match programming?
Okay, well, to the gentleman, we're starting to get a little bit into the bill here, but we can start down that trail. This is something that we were told that actually BMS often does on an annual basis anyway, to kind of take a look at where, if they had to make some cuts, they could. So,
but do you know what 1% state match budget reduction from previous year means? Is it 1% or is it a state match if we're 1-4? What are we? I think you said 1 to 3 maybe match. That would be a 4% cut.
I think this is the 1% on the state match. So if the state match for a program was $100 million, then it would be $1 million. So that would be a $400 million program.
But 1% of, let's say, just the state. What does the state contribute to Medicaid each year? Is it $1 billion?
Yeah, I think it's let's see, 1.149 million for SFY 24. 1.149 billion.
1.1 billion?
1.149 billion
Okay.
in SFY '24, which is the budget that we're operating under now.
Okay, so if that's the state match, if that's what that means, then instead of it being 1%, it would be, at 1%, that would be what, 100, help me with the math. Is that 17 million or 170 million? What's 1% of 1.1 billion?
I believe it would be 11 million.
I'm trying to convert the percentage into a real dollar
It's
number.
about 11 million, correct?
Okay, I
Yeah.
can't tell you, but,
Yeah.
all right, very good. So somewhere around 11 million.
That's pretty handy in math back in school.
Okay, all right. Thank you, sir. And does this mean in every program? Now, I assume that when we say program, that children's services and maternity and all those would be programs. Would we look at every single program for a 1% reduction?
I think, and again, to the gentleman, I'm going to go back because you were in House Finance.
Yes, sir. Yes, sir.
And I'm going to remind the gentleman that, you know, the angst that everybody had in finance was on subsection A.
Yes.
Now, subsection A is what we amended, and to do it under LACRA, we had to move it to the back of the bill and put it in Chapter 16, which is where the authority for LACRA resides and the responsibilities for LACRA.
And I'm on rulemaking.
I know you are.
Appreciate that
I know
change.
you are. But then the rest of the bill is the same bill that you considered in finance. We just moved everything up. So old B wound up as new A, and likewise. So this is the bill before us currently is the only change in the amendment that we are considering is Article 29E, which is in Chapter 16. But if, you know, we're kind of getting into the bill by going into...
Well, but this is in your amendment. I mean,
well, the amendment's now the bill, but again, if the Speaker will give us latitude, we'll go ahead and debate it. We haven't really moved the amendment forward yet.
Well, I'll pause and let us do that at the next stage. But I do want to point...
To both gentlemen, the chair's understanding is that the primary amendment before the body will become the bill.
That's my understanding.
So for all practical purposes, the amendment will become the bill. So any distinction drawn between this amendment and the bill is moot.
Yeah.
Well, let me, I'm close to done here. The $11 million for state match would mean times 3, 33 million, it would be $44 million reduction for 1% if you add the federal money into it.
The gentleman's correct.
So that would be a pretty big program cut. Okay, but let me go next to I think it was C, about the benefit cliff. And I think this is definitely a good part of this bill, where there are a number of people who automatically lose Medicaid coverage if their income raises just a few dollars sometimes.
Mm-hmm.
And the Bureau is required to examine that and determine how that affects people and families?
Correct. And I was going to speak to this in a minute, but there are 7 other elements of the bill, besides what we've debated in the change out of rulemaking. One of which, the 5th element, is a study of strategies that may be undertaken by the state to mitigate the benefit cliff. So we would like, some of that has to do with what could we do? What would be an acceptable state plan amendment, or can we even do anything like that? So that's the 5th element here, is we would like to see what could we do. The answer may be nothing, but we would like to do that. To the gentleman, I know we've talked a lot about workforce development.
Yes.
And I think this is a key part of workforce development, but we've got to have some solutions that would work. Now, obviously, for us to just proffer up an idea that's not going to work and is going to immediately get turned down is not going to do us any good. So that's the fifth element of the bill, is that report. And that would be a one-time report just to see what we could do.
Well, I agree with you on that one, sir. Thank you very much.
Thank you.
Thank you, Mr. Speaker.
Is there further debate on the primary amendment? Is there further debate on the primary amendment? Does the gentleman from the 26th wish to close debate on the primary amendment? If not, the question is, shall the primary amendment be adopted? Those in favor of adoption of the primary amendment will please say aye. Aye. Those opposed will please say no. Ayes appear to have it. Ayes have it. Chair declares that primary amendment adopted. Are there other amendments to the bill? If not, the clerk will please read the bill a third time as amended.
Committee substitute for House Bill 5685 relating to Medicaid cost containment.
Question now is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read in full? There are no objections heard. Chair recognizes the gentleman from the 26th for further explanation of the bill.
Thank you, Mr. Speaker. We're now debating the full bill. And a large part of this bill, this whole bill, is just about reporting and accountability. One of the reports required is going to be a benefits and eligibility report to be compared to the surrounding states and the 5 states with the lowest per capita cost every 3 years. This report must include any differentials and a recommendation from the Bureau of Medicaid Services whether the agency supports continuation, and if they do, the report must include a 6-year projection of the cost going forward. The second report is a yearly report to the Joint Committee of Government and Finance on how to achieve the 1% state match reduction from previous years. The third report is an annual report in conjunction with any state government agency impacted by Medicaid funding to determine if these functions can be financially covered by a state Medicaid program or more efficiently covered by the state Medicaid program if they're currently covered in another program. Number 4, a study to determine if the existing waiver programs have generated the financial offsets as originally planned. 5, we already talked about, a study of strategies that may be undertaken by the state to mitigate the benefits cliff. 6, a study to report on West Virginia's improper payment rate. And number 7 is a population health outcome report that quantifies the highest expenditure services, the fastest growing expenditures, and areas actuarially identified as having the greatest elasticity in driving down long-term expenditures. That's a summary of the bill, Mr. Speaker, and I urge passage.
You've heard the bill explained. The question now is, shall the bill pass? Gentleman in the 20th, Doug Foster, is recognized.
Thank you. Does the gentleman yield?
Yes.
We have a $600,000 fiscal note on that. Is that still what this would cost?
I don't see any cost in here at all to the gentleman. These are just reports of one of the largest programs in state government, so we can start getting a handle on where our money's going and the cost. As we've talked, our expenditures have went up in the last 18 years, $3.1 billion. So they more than doubled. And we're just trying to get a handle on some of this through some better reporting.
Yeah, but the fiscal note's, what, $650,000? Is that still an accurate fiscal note, or you're saying that we just ignore the fiscal note?
I don't think we ignore the fiscal note, but I think we probably take a look at it, and if we can't, through these strategies, recoup more than $650,000, I think we've made a serious blunder.
And the recouping the $650,000 would be through what process? By the act of the legislature?
I would hope that these studies, if they're properly done and reported, we should be able to find savings that would more than cover the cost of the studies.
All right, thank you.
Is there debate on the bill? Is there debate on the bill? Gentleman, the 25th, Doug Hornbuckle.
Thank you, Mr. Speaker. Will the gentleman yield for some questions?
Yes.
Thank you, sir. You talked about surrounding states. Do other types of states around us have this type of granular spending oversight within LOCR that we're going to do here?
If they don't, they should. Again, to the gentleman, I'm not aware of what the other states are doing to that level. I would hope they have the oversight.
Are there any other agencies in our state that we do this for?
To this level, I'm not really going to say that I know.
Yes, sir. And how do the reporting requirements laid out in this bill before us differ from the ones established in House Bill 4595 that we passed out earlier this year?
I think this is a little bit more comprehensive in the fact that it's taken a look at a lot more at the elements that are the drivers of the cost.
Okay. Do you feel that there are any concerns about the 60-day turnaround on this that this could potentially have?
Well, the 60-day turnaround is in the last part, and all we're doing is having LOCRA, which usually meets monthly, make a recommendation. So I don't see any problem with 60 days at all.
Yes, sir. And what part of our Medicaid funding is federal?
What
percentage?
part or
Sorry,
percentage?
Percentage. I apologize.
We basically have a 3-to-1 match.
It's about
Our match,
70,
okay.
74%.
Our match went down in 2 ways, and you know we're putting together a budget now. As the gentleman from the 80th alluded, we did have an increase in our match rate when COVID hit, and we went from about roughly 75 to 81. Now we've lost that, now, and that's not just West Virginia. All states have lost that. So we're back down to what our FMAP was before, which is roughly 75%. Now, I think we went down 0.6% more because actually our economy's improved. And it's the FMAP is determined on your state's economy. So as your economy gets better, so all states don't get as generous a match. We get one of the more generous matches, but ours did get a little less generous when those changes occurred.
Yes, sir. Last question. What percentage of our Medicaid services fall under the waiver program and state plan amendments?
Yeah, if the gentleman, we were into that on finance. Just a second. Okay. Of the waiver program is 51.9%, and the state plan is 48.1%. So it's roughly 50-50.
Yes, sir. Thank you, sir. Permission to speak to the bill?
Yes, gentleman is recognized.
Thank you, Mr. Speaker. First and foremost, this is hard work. This is a lot of hard work, and I do appreciate the gentleman's efforts in trying to do this. I do think that his intentions are good here. Where I disagree is the trigger. And I think the trigger is going to be very problematic for West Virginians. As we heard earlier, we have almost a third of West Virginians are on Medicaid. Going to this is going to be very problematic. When we're talking about the numbers, if we will use that $12 million number that we keep talking about, that trigger on our total state and federal match is only going to be roughly about 0.22% of growth. Only roughly about 0.22% of growth. Now, if you look at that, we're about 2% of our medical state growth through fiscal year 2026, only 2% of growth estimated. If you look at the federal and state match, it's going to be roughly about 4.6% growth. If you look at PEIA, that's only going to be about 5.8% growth. And if you look at private insurance, about 7.5%. And so if we're looking at Medicaid cost containment, currently we're doing a really good job with that. Currently, we're doing a really good job at that, and I would argue again, this strategy is a really good one, but the metrics that we're using are a little bit off. We need to raise the trigger. The reason that we need to raise the trigger, if we do not, it is going to severely slow down our services to our people. It's going to slow down reimbursements. It could slow down contracting. Again, I want to make this abundantly clear. The work and the efforts are great. The intention is good, but I think we need to rework the metrics and what we're using to make it work for West Virginians.
Gentleman, the 52nd, Nugget Rowe is recognized.
Thank you, Mr. Speaker. I would like to speak to the bill. I think the intent is very good, but we do need to acknowledge some things, just to have some understandings of what we're doing. The 1% reduction would result in, I just used a round figure of 4%. We're talking about a 4% program reduction, 4%. What's 4% of the population that are on Medicaid? It's somewhere maybe in the range of 20, 25,000 people. So we're talking real people here that would be hurt as a result of a significant drop in programming costs. The fiscal note is $646,000, and I'm not sure how they get that, but I'll guarantee you with the amount of paper we're going to produce and the analysis that's required, which is really a detailed analysis of everything about Medicaid. With the trigger of $3 million, we're going to be looking at everything. I mean, the change in the couch for the pizza guy is going to be important in this analysis, and it's going to be very, very costly. But do we do it? Well, we need to look at the program. And what's interesting is that the finance committees on a regular basis do exactly this. Now, they don't go into this kind of detail. They basically get numbers and gross from the departments and do the best that can be done on that. But this is going to really put it right in the laps of the two finance committees, and it's going to be quite a burden to do this sort of detailed analysis every year because of the $3 million trigger. It's really going to be a difficult burden, so we may have to come back if this passes and revisit that and the analysis that's required. So we're talking about people. We say a 1% cut on state match, that means 4% program cuts. You're talking a lot of money, and what's interesting, we are containing costs, but we also had a hospital maybe a year or 2 years ago say that we don't want to take your patients because we're not getting paid enough. And the push on medical costs increase come from the providers because they need to have enough to stay in business. So, there's a lot of things in play. This is the most important program that we engage in after public schools and other schools. So I encourage everybody to take a close look at this. I think I've come around to a no on it. But I think that is something that we need to look at. But I just think that the triggers and the 1% where we're going to be looking at dropping off maybe 20,000 people and reducing the program budget by 4%, I think it's probably a little too much. So I will be voting no on this. Thank you, sir.
Gentleman the 11th, like Fehrenbacher.
Thank you, Mr. Speaker. I'd like to speak to the bill. When I look at what has been proposed here, to me this is good financial stewardship. With these services basically being the single largest spend item in our general revenue budget, this is just good business sense. When I look at the items in Article 5, we're asking the Bureau of Medical Services to look at where the money is being spent, challenge them to come up with cost reduction items, compare that or benchmark that with other states. And when I think about that, there is nothing that makes us elect to stop services or to reduce the roles of those that are being covered. It provokes a discussion about where's the money being spent and whether or not there's an idea out there somewhere as to how we might reduce that spend. The results that we have seen in this state when we compare our health results of our people are we're spending a tremendous amount of money and getting poor results. And to me, for us to continue to spend that money and still get poor results is insane. I realize that the launch of these studies and the discussions could be challenging. But I believe that until we start this dialogue, we are going to find ourselves in a pattern of continuing to increase the amount of money we spend and, unless something changed, still delivering poor health results. I fully support all of this bill, but I also recognize, to the observation I think a number of us have had, that the trigger of $3 million in state funds may be too small, but let's start with a smaller number and adjust up if it's problematic. Last thing I'll say is that until we get some of these types of costs under control, the ripple effect in things like PEIA premiums is going to be an ongoing challenge. So keep that in your mind about an added benefit of this type of diligence. I would encourage you to vote yes on this bill. Thank you.
Gentleman, the 80th, David Williams.
Thank you, Mr. Speaker. Again, I want to reiterate that healthcare costs that have gone up over the years has been a natural part of inflation. I don't understand how we can use inflation as a talking point all the time over here, and then we forget about it over here like we are on this issue. Be very, very careful when we're talking about Medicaid spending being a quarter of the budget when we've run a flat budget for 8 straight years. If it continues like that, then the argument in another 8 years will be, well, guys, Medicaid's half the budget now. Well, of course it is. We're spending more as we should be, keeping up with inflation, providing benefits to Medicaid recipients. When compared to the rest of the budget, we're losing ground there. So I just feel like this bill is setting us up for a future argument of being put in the position where we're going to cut Medicaid benefits. Again, on its face, I don't question the intent. I don't think, in principle, it's a bad idea, but in execution, I think this will lead us astray and it will hurt our people. I ask you to vote no. Thank you.
Gentleman, the 26th, second word block to close debate on the bill.
Thank you, Mr. Speaker, and good afternoon again, ladies and gentlemen. I'm going to address several things here in closing. First of all, about 1 out of every $4 in our general fund goes to state Medicaid program. So if you think this is not already a lot of work on the finance chairs, you're mistaken. This is one of the biggest things we have to work on every budget cycle. Now, a lot of these reports are already generated for the federal government. So we're asking that they be brought in front of the state so we can just have the data. That's all this report asks. This bill requires us to act on nothing. It just gives us the data to analyze this program, because I do agree with the gentleman from Kanawha, this is a vital program for an awful lot of West Virginians. And we've got to have fiscal responsibility to ensure that this program is going to stay solvent. We can't, unfortunately, we don't have an unlimited source of money. So we have to act prudently and get an idea of one of the better things in this bill, I think, is have we seen results? These amendments, okay, this is going to save us money in this. Well, let's look back 5, 10 years later. Did it save money? If it didn't, then we ought to have some questions. And if you think that this bill is not important, I will remind you again, this is a 4th-year state budget. that you're talking about. So with that being said, Mr. Speaker, I urge passage of the bill.
Debate on the bill has been closed. Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 83 ayes, 11 nays, and 6 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5685 relating to Medicaid cost containment.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5698 relating to the Consumer Data Protection Act.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman 97, Douglas Hardy, to explain the bill.
Thank you, Mr. Speaker. This is a long one. Mr. Speaker, the bill would establish a law in the state to be used to protect certain consumer data. The bill would create rights in consumers with respect to the consumer's personal data in the possession of certain businesses. The bill first describes the business and other entities which the bill does and does not apply to, describes the type of data in which the bill does not apply, describes the rights the consumer may assert to a business with regards to the consumer's personal data, describes the responsibilities the businesses may make to the assertions of rights with regard to a consumer's personal data, describes what a business may and may not do with a consumer's personal data. Describes the privacy notice and business must provide consumers regarding personal data, describes the responsibilities of a processor with whom a business may contact to process personal data for business, describes the requirements and processes of conducting a data protection assessment that businesses must conduct, gives the Attorney General exclusive authority to enforce the article by bringing an action in the name of the state or on behalf of the persons residing in the state, and establishes a $7,500 penalty for each violation. Requires the Attorney General to establish a process whereby a consumer may use the personal data protection in the bill through the Attorney General's office, creates a consumer privacy fund consisting of civil penalties collected pursuant to the article to be used to support the work of the Office of the Attorney General to enforce the provisions of this article. Also, it provides that the article preempts any political subdivision law regarding the control or possession of personal data. That is the bill, Mr. Speaker.
You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman from the 76th, Douglas Garcia, is recognized.
Thank you, Mr. Speaker. Does the chairman of the Technology and Infrastructure Committee yield for a couple questions?
Yes.
Thank you, sir. First of all, we've had a number of different bills related to consumer data. I believe we had, this is 5698, we've also today had 5338, and we had 4381. Can you talk a little bit about the differences, because I know that you've been a big part of putting these together?
Yeah, so, well, in the House Finance Committee, I believe it was 5338 was the previous bill number. So we had one that deals with cybersecurity and essentially was a carrot for companies to enact the best cybersecurity policies that they can, which then allowed for them to essentially have an absolution from liability, supposing that they've done everything right, right? It's unfortunate that's where we live in, and so that centered around, obviously, potential breaches and where would someone have a cause of action. Well, the answer is if their personal data were breached and then leaked onto the dark web or something along those lines. So initially, this bill was in that bill, and the gentleman from the 72nd made a motion under Rule 42 to divide the question. The chair decided to divide the question into two separate bills and originated what is now before you, which is House Bill 5698. House Bill 5698 establishes three basic rights of consumers against, I say against, but that can be exercised with some of the very largest entities which control or process or have data about you. There's a number of items in the bill that go into what entities that those are this is against, but those 3 rights are the following: to view, to modify, or to have your data deleted by those entities. This would be the first time in West Virginia law that, to my knowledge, that has been protected or established for people. This is largely the Virginia model, which there's a number of models throughout the country. California has one, I believe Oregon has one, Connecticut has one, and Virginia has one. This appears to be the one that is the most preferred by the industry, and I think that they've understood at this point that though Congress has not acted, that states will begin to act. Why do we look to pursue perhaps more model legislation on this as compared to others? It's because the internet really doesn't respect state borders or territorial boundaries, political boundaries very well. So that's a basic understanding of what we've got before us.
How does that compare to 4381, which is also in the Consumer Protection Division? I wasn't quite sure whether that's more personal financial information.
Okay, so 4381 deals with financial data. This really does not. So this is about personal data surrounding you. So everything from geolocation to interests to things, basically how you are profiled for what advertisements, as a for instance, are put before you, and data which entities collect about you. Interestingly enough, I was in a conversation recently, and the WeatherBug app actually collects a whole lot of information about you. And just for having that on your phone, they might know where you are, or how you're using your phone, and some of those sorts of things. And so it just allows for folks to be able to exercise those rights.
So now, this bill that we're talking about, it has the Attorney General as an investigator. I mean, is there a cause of action? Because I know in 4381, there was a cause of action, or there was the ability of the AG to bring a suit, but there is also a consumer's ability to bring their own private cause of action for civil penalties. And I just wanted to see about the differences between why that was in that bill but not in this bill.
So I can't speak to the other bill because that was sponsored by another member, or what the justification there was. In this bill, there is no private right of action. I will submit that to you. The intent here being that we would hope that these entities which hold or process, this data about you and about 1.8 million other West Virginians will actually, allow for the exercise of these 3 rights, essentially, that we're creating, or that the bill would propose to create for West Virginians. And so, rather than just simply being litigious, and I don't mean that pejoratively to the gentleman, I understand your profession, but rather than being litigious surrounding it, the intent instead is to make sure that they are exercised. And you've got to easily realize that these are some of the very largest businesses on the planet, quite frankly, that hold the majority of this information, and that the Attorney General, we feel, and the state of Virginia also felt, is best suited to assist consumers in exercising those rights.
Okay. Last question. Have you conferred with the Attorney General's office about their ability to take something like this on? Because it seems to be, it's a 23-page bill, lots of different definitions, lots of different, I think, rights that and interactions that could happen. Is this going to grow the AG's office? What do you expect from it?
So we don't expect it really to grow the AG's office. So interestingly enough, the state of Virginia put off implementation of the law for about a year. I don't think Virginia has seen quite a huge increase there because generally the industry is also coming to the table on this and seeking to comply. And so I will tell you, in working with this piece of legislation, and we've worked it for, well more than a year, that representatives from some of the very largest companies on the planet have taken part and meaningfully engaged, rather than just sending a letter, in support or opposition. And their intent, at least as expressed to me, is to have a workable law, one with known rules of how they would operate, and to comply.
Okay. Thank you, sir. Thank you, Mr. Speaker.
Is there other debate on the bill? Gentleman in the 52nd row is recognized.
Thank you. Could you help me with some questions? All right. Does this bill give the consumer a right to call one of these regulated businesses and have their data not sold?
Well, if they were to delete that data, then they would not be able to have it sold because it would no longer exist.
Well, but let's say you deal with a bank and it has, what are the requirements? 100,000 customers and $25 million in West Virginia assets. and you discover that they're selling your data, I mean, are you able, is a consumer able to call up and say, don't sell my data? You can maintain it to let me do business, but don't sell it. Can that be done under this bill?
So a few answers to that. This bill was committee substituted in the Finance Committee, and I do believe that the chairman offered, quite frankly, direct protections for financial institutions. So no, I do not believe under the gentleman's example that would be a new right created by this bill.
Would the companion bill that was divided out, do you know, does it give us the right to tell them not to sell our data?
The companion bill, which was divided out, was simply for cybersecurity, and basically rather than a regulation, it's a carrot rather than a stick, asking companies to engage in good cybersecurity. So the answer to that, I believe, is no.
Now, the businesses identified are quite large, 100,000 customers and $25 million in West Virginia assets, if I remember that right. But what about the businesses that don't meet those threshold numbers? Are they just not subject to any regulation by the Attorney General? I mean, does the customer lose their right to sue those companies?
So they're not contemplated by the bill. So the following is, as I understand this bill, that a covered entity by this bill is persons or businesses that conduct business in the state or produce products or services that are targeted to residents of the state, and that, number one, during a calendar year, control or process personal data of at least 100,000 consumers. Right. Number two, control or process personal data of at least 25,000 consumers and derive over 50% of gross revenue from the sale of personal data. Or number three, have annual gross revenues generated in this state which exceed $25 million total dollars. So there is an effort there to make sure that you're not crippling some of your smallest entities with compliance costs, to be direct. And quite frankly, the mom and pop grocery or something like that, or the gas station down the street, that's locally owned, really isn't profiting off trying to sell your data.
Thank you, Mr. Speaker.
Question again is, shall the bill pass? Is there debate on the bill? Does the gentleman wish to close debate on the bill? Gentleman from 97th, to close debate on the bill.
Not to close. I had a few questions for the gentleman myself.
Okay. Does the gentleman yield for a question?
Sure.
Gentleman's recognized.
Thank you, Mr. Speaker. Just a couple quick questions. Listen, we know that the buying and selling of data right now is one of the largest businesses in the world, and it's very popular. And there are businesses that specialize in that, and those businesses may want to locate in the state of West Virginia, and also in my area of the state. Data's not specifically to the Eastern Panhandle yet, but in the Northern Virginia area, there are a lot of data centers. Mm-hmm. These data centers are located in the Northern Virginia area. They look at the Eastern Panhandle because, one, we are a little further away from the D.C. area. We're in different electric grid, then they may be such protected. Do you feel that this bill, it is a large bill and it has a large reach? Could there be problematic in maybe forcing companies to not want to come to West Virginia, not want to do business in the state of West Virginia because of legislation like this?
No, I don't believe so. Now, you're asking me to sort of predict behavior, but I can tell you one of the largest owners of data centers, so if you're looking at that, is Microsoft, right? And Microsoft specifically presented before the Joint Committee on Technology, before it was the Joint Committee on Technology and Infrastructure, and requested a bill of this nature. They engaged with us from the very beginning on this. We went through the different state models. Actually, the gentlelady from Kanawha and I, now former member Capito, and others actually worked together on this. And of course, one additional thing to your question, this is basically the Virginia model. And so with Ashburn, Virginia being where the greatest collection of data centers are in the country, do I think that this would harm businesses looking to site here? No. In fact, we're modeling our policy after the very state that has the largest amount of data centers, period.
Thank you, Mr. Speaker.
Is there other debate on the bill? Is there other debate on the bill? If not, does the gentleman wish to close debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 86 ayes, 7 nays, 7 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5698 relating to the Consumer Data Protection Act.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Do we have other bills on third reading at this time? If not, bills on second reading.
Senate Bill 240, increasing fees charged by sheriff.
Are there amendments? If not, the bill will be advanced.
Senate Bill 752, authorizing Department of Agriculture to complete certain land transfers.
Are there amendments? If not, the bill will be advanced. Other bills on second reading. Bills on first reading.
Senate Bill 164, relating generally to trespassing.
Bill will be advanced.
Committee substitute for Senate Bill 370, updating Public Employees Grievance Board procedure that certain decisions be appealed to Intermediate Court of Appeals.
Bill will be advanced.
Committee substitute for Senate Bill 451, directing Prosecuting Attorneys Institute to make training available to certain new prosecuting attorneys.
Bill will be advanced.
Senate Bill 529, including Salem University in Promise Scholarship Program.
Bill will be advanced.
Committee substitute for Senate Bill 539, creating cold case database.
Bill will be advanced. We have other bills on first reading. If not, unfinished business.
Committee substitute for Senate Concurrent Resolution 4, U.S. Army Second Lieutenant Eston Kuhn Memorial Bridge.
Ladies and gentlemen, the question is on the adoption of the infrastructure naming resolution just read by the clerk. Is there debate on the resolution? Gentleman from the 100th Delegate right now is recognized.
Thank you, Mr. Speaker. I'd like to speak briefly on the circumstances of Second Lieutenant Eston Kuhn's service and passing. Lieutenant Kuhn served in the U.S. Army Air Force's 71st Troop Carrier Squadron of the 435th, or the 434th Troop Carrier Group. The men who piloted the C-47s that dropped the 82nd and 101st Airborne Divisions into Normandy on D-Day were a special breed. Much had been learned from the disastrous paratroop and glider operations at Sicily in 1943. There was no armor on the C-47s. Flak bursts easily demolished these aircraft. There was no way for the pilots of a crippled C-47 to bail out. If hit, they had to write it down and hope for the best. The troop carrier groups trained extensively for months prior to D-Day. They knew their missions and believed that they would be flying into an inferno. This constant training took its toll in terms of accidents, but the training paid off. These crews were now highly trained, skilled, and painstakingly trained soldiers. At 1 a.m. on 6 June 1944, as part of Operation Chicago, the aerial reinforcement of the initial troop drops, Lieutenant Kuhn took off in his C-47 towing a glider, carrying 101st Airborne Division anti-tank guns and engineers to within a few miles of the drop zone on the Cherbourg Peninsula. The gliders slowed the C-47s, making them better targets for the experienced German flak gunners. Earlier, during the initial parachute drops, over 40 C-47s were lost to furious, concentrated anti-aircraft fire. After dropping its glider, Lieutenant Kuhn's C-47 was the only plane shot down among the 52 C-47s in Operation Chicago. His C-47 burst into flames, but the pilots were able to successfully crash land near the port of Cherbourg. Everyone survived the crash, but this was a chaotic battlefield. American and British troops, paratroops, and gliders had been unintentionally dropped over a vast area. Deadly firefights and ambushes occurred throughout the peninsula as Germans and Americans hunted each other with deadly fury. A German patrol ambushed Lieutenant Kuhn's crew, killing one of the crewmen, taking the others prisoner. They were thrown onto a German truck and convoyed to a POW collecting area at the town of St. Lo. En route, they were strafed by American fighters trying to support the scattered Allied airborne forces. Several POWs, including Lieutenant Kuhn, were killed. He was buried by his fellow crew members. C-47 crews who flew during World War II performed absolutely essential services for the fighting forces. Aerial resupply, air transport, and paratroop and glider operations were critical for Allied operations in all theaters throughout the war and afterward. Thousands of these crewmen gave their lives flying these often very dangerous missions. The sacrifices of these men, and sometimes women, made it often overlooked, but was often critical in supporting the eventual defeat of the Germans and the Japanese. Thank you, Mr. Speaker.
The question is on the adoption of Senate concurrent resolution for committee substitute for Senate concurrent resolution 4. Is there debate on the resolution? If not, those in favor of adoption of the resolution will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares the resolution adopted. Clerk will please communicate the action of the House to the Senate. Next item of unfinished business.
Committee substitute for Senate concurrent resolution 22, U.S. Marine Corps Major Cornelius Burdett Memorial Road.
The question is, shall the resolution be adopted? Is there debate on the resolution? Is there debate on the resolution? If not, those in favor of adoption of the resolution will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares that resolution adopted. The clerk will please communicate the action of the House to the Senate. Next item of unfinished business.
Senate concurrent resolution 23, U.S. Navy Lieutenant Louis Joseph D'Antoni Memorial Road.
The question is on the adoption of Senate concurrent resolution 23. Is there debate on the resolution? Is there debate on the resolution? If not, those in favor of adoption of the resolution will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares that resolution adopted. The clerk will please communicate the action of the House to the Senate. Next resolution.
Senate concurrent resolution 25, U.S. Army Sergeant Wyatt K. Hinton Memorial Bridge.
The question is on the adoption of Senate concurrent resolution 25. Is there debate on the resolution? Is there debate on the resolution? If not, those in favor of adoption of Senate concurrent resolution 25 will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares that resolution adopted. Next item, or next resolution.
Committee substitute for Senate concurrent resolution 26, U.S. Army Private Clarence William Buck Holliday Memorial Road.
The question is on the adoption of committee substitute for Senate concurrent resolution 26. Is there debate on the resolution? Gentleman from the 100th, right now is recognized.
Thank you, Mr. Speaker. Private Clarence Holliday entered the U.S. Army on April 18. 1944. He had 6 months to live. In early 1944, the U.S. Army finally realized that the casualties during the major fighting in New Guinea, the Pacific Islands amphibious assaults, and in the North African and Italian campaigns was becoming a crisis with the impending invasions of the Philippines and France. The critical shortage was infantry, and the U.S. Army cut training time to 17 intensive weeks, eliminating anything but not focused on combat. The 104th Infantry Division had recently arrived in France, and on the 23rd of October began fighting in the vicious battle of the Scheldt Estuary for the islands west of the critical port of Antwerp. Private Holliday joined the 101st Division in Belgium on 5 November, shortly before the fighting ended. The weather was wet and cold. Under miserable conditions, the 104th had suffered 1,400 casualties. Excuse me, including over 400 dead in 2 weeks. The 104th was immediately transferred east to prepare to attack into the Hurtgen Forest. Private Holliday and his fellow infantrymen were soon involved in some of the worst fighting on the Western Front during the war. This area of the Hurtgen was part of the Siegfried Line, with concrete and improvised wooden blockhouses, minefields, barbed wire, and booby traps hidden by mud and snow. The dense forest made it impossible to establish a front line. German machine gun, mortar, and artillery units sighted along the limited avenues of approach, making these death traps. Tanks could only move along the roads and were knocked out by German bazooka teams. The dense forest also negated American artillery and air attacks, making this basically an infantry slugfest. Heavy artillery also hit the German positions. The Germans were severely shaken but recovered quickly. The 104th's first objective, Donnersberg Hill, was taken with heavy casualties. The 104th next took Stolberg on the 19th of November, but ran into a buzzsaw at Ischweiler over the next 3 days. The 104th attempted to encircle the town. On Thanksgiving Day, Private Holliday was killed during the encirclement. He had been in Europe for 18 days. During the war, U.S. Army infantry suffered 87% casualties, not including those evacuated for severe diseases, particularly those in the Pacific, North Africa, and Italy. No combat was more brutal than the Hurtgen Forest. Thank you, Mr. Speaker.
The question is on the adoption of committee substitute for Senate Concurrent Resolution 26. Is there debate on the resolution? If not, those in favor of adoption of the resolution will please say aye. Aye. Those opposed will please say no. The ayes have it, and the chair declares that resolution adopted. The clerk will please communicate the action of the House to the Senate. Are there further items of unfinished business at this time? If not, let's return to consideration of bills on third reading. Clerk will please report the next bill on third reading.
House Bill 5551 relating to continuing education concerning domestic violence.
Are there objections to having the bill explained in lieu of having the bill read? Gentleman to 68, Delegate Phillips.
Thank you, Mr. Speaker. Ask unanimous consent to return or to amend on third on this bill.
Gentleman asked unanimous consent to offer an amendment to the bill on third reading. Are there objections? No objections are heard. Clerk will please report the amendment.
Delegate Phillips moves to amend the bill on page 2, section 7A, line 22, by striking the word and inserting in lieu thereof the word or.
That is the amendment. It's just a technical correction to make sure that we are not requiring someone to be a licensed social worker, psychologist, and professional counselor.
You've heard the amendment. The question now is, shall the amendment be adopted? Is there debate on the amendment? If not, those in favor of adoption of the amendment will please say aye. Aye. Those opposed will please say no. The ayes have it, and the chair declares that amendment adopted. Now, are there objections? The clerk will please read the bill a third time.
House Bill 5551 relating to continuing education concerning domestic violence.
Are there objections to having the bill explained in lieu of having it read in full? No objections are heard, and the gentleman to 68th, Delegate Phillips, is recognized to explain the bill.
Thank you, Mr. Speaker. House Bill 5551 requires completion of a one-time continuing education course on domestic violence by licensed social workers, psychologists, or professional counselors within 2 years of licensure. I urge passage. You've heard the bill explained. The question now is, shall the bill pass? Is there debate on the bill?
Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member now voted? If so, the clerk will close the machine and ascertain the result on that question. There were 90 ayes, 1 nay, and 9 members absent. Majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5551, relating to continuing education concerning domestic violence.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5617, authorizing the Public Service Commission to promulgate rules for maintenance, flushing, flow testing, and marking of fire hydrants owned by water utilities.
Ladies and gentlemen, this bill was advanced to third reading with the right to amend. Are there amendments? Gentleman from the 22nd, Doug Linville.
Thank you, Mr. Speaker. After consulting with the amendment's co-sponsor with me, I would ask unanimous consent to withdraw the pending amendments.
Gentleman from the 22nd, ask unanimous consent to withdraw the amendment currently pending. Are there objections? There are no objections heard. Are there other amendments to the bill?
Delegates Akers and Linville move to amend the bill.
22nd.
Mr. Speaker, the unanimous consent request was to withdraw all pending amendments.
All pending amendments. Understood. Are there objections? There are no objections heard. Those amendments will be withdrawn. Are there other amendments to the bill? If not, clerk will please read the bill a third time.
Committee substitute for House Bill 5617, authorizing the Public Service Commission to promulgate rules for maintenance, flushing, flow testing, and marking of fire hydrants owned by water utilities.
Question before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Gentleman from the 55th, Doug Akers.
Thank you, Mr. Speaker. After a long day, I thought everyone would be very excited to finish on a discussion about fire hydrants. This is actually a really important issue, and I hope it's one that you all are able to take back to your districts to keep an eye on. The lead sponsor of the bill, this is his work. After discussing this with him, he didn't want to continue with a proposed amendment that we had, so out of respect and deference to him, I was willing to withdraw that amendment. But the reason why this is important is because this bill came to be because of a fire that occurred in a neighboring district of mine last year. And when the fire department responded, 3 of the closest fire hydrants did not work because there was not enough water pressure. After further investigation, there were other PSDs where it was discovered that this same problem existed in other places. This probably exists somewhere in all of your districts. It's a really important issue. 2 of the homes I talked about before, one was a business, one was a home burnt completely to the ground. And the fire departments in both of those places said they thought they probably could have saved those structures if not for the fact that the fire hydrants did not work. We'll never really know. The amendment we were going to propose, and what I would ask you all to please keep an eye on when you return back to your districts and talk to your constituents, revolved around the ability of either a utility or a PSD to go to charge what's called rate making or get a rate recovery. And what I was trying to prevent was rate recovery for the inspection or maintenance or flow testing of hydrants that already exist, because that should have already been built into the original rate recovery. Now, if there was going to be new construction or new work done on these hydrants or replacement of hydrants, I felt like that was appropriate. We could have allowed rate recovery from that, and I was willing to allow that in the amendment. But I do not think that a rate recovery or charging your constituents twice for essentially the same work in order to make sure that the hydrants are appropriately working was the right thing to do. The reason why, and I'm going to be much quicker than I would have been if we debated this bill, but the bill, if you'll read, requires the utilities or PSDs, for example, to adhere to 64 CSR 77. That's already the law. The utilities are already supposed to make sure that the flow to the hydrants in your constituents' districts are sufficient to help put out a fire. So this bill is another one where we're requiring someone to actually comply with the law that already exists. And you have to understand the PSC process is very complicated and has a lot of upfront work. 150 CSR 02 requires the utilities to put in their tariff forms and rate requests and rate recovery sheets, things like maintenance costs and operating costs going forward. So making sure that the hydrants work as part of an existing system was supposed to be part of the rate recovery that your constituents were charged in the first place. They should not be charged for that again. Now, there was some discussion in Judiciary Committee. Someone said that it's unconstitutional to get a rate recovery, and that's true for what they're going to do, but I would certainly argue to you that it's not unconstitutional to tell them they can't charge constituents twice for the same work. So, I'm not pointing to any particular utility or PSD. This is something that could be existing anywhere. But again, if you have hydrants in your district, they are supposed to be working right now, and they're supposed to be checked and maintained right now. Your constituents should not have to pay to have those existing systems checked to make sure the water flow is sufficient if they're already there. So I would just urge you all, I'm not going to oppose this bill because it does do some good things. The only thing I didn't think should happen in this particular circumstance is that we should allow a rate recovery to make sure the water flow to your constituents' existing hydrants is adequate. It should be already. That's part of what they paid for. So please keep that in mind, and I'll also urge you to keep this issue in mind when you go home to make sure that the hydrants in your constituents' districts are working appropriately, that they're tested and inspected. We've had some potentially tragic results here, and it probably exists everywhere in the state. Thank you for your deference and letting me talk at the end of a long day.
Ladies and gentlemen, the chair was in error on that bill and did not permit an opportunity for the bill to be explained to the members. Are there objections at this time for an explanation of the bill? No objections are heard. Gentleman from the 51st to explain the bill.
I debated whether I should object, Mr. Speaker, but I won't. I will explain the bill.
Would have been fine.
Okay, the bill finds that it is in the public interest of the citizens of West Virginia for public water utilities to follow the National Fire Protection Association's recommended practices for fire flow testing and markings of hydrants, Standard 291, and the American Water Works Association Fire Hydrants Installation, Field Testing and Maintenance Manual, Manual 17, and 64 WV CSR 77, Public Water Systems Design Standards, all to ensure that all installed fire hydrants are working properly. Those standards are hereby adopted, and the Public Service Commission may promulgate rules in accordance with the provisions of 29A13 et sec of this code on the inspection, flushing, flow, testing, and marking of fire hydrants owned by public water utilities as set forth in those standards. All public water utilities shall comply with these standards and any rules the Commission may promulgate. A public water utility may use its cash. That is not correct in that the public utilities may use rate making subject to approval of the PSC to pay for this maintenance of the fire hydrants. That is a summary, Mr. Speaker, and I urge passage.
Now the question before the House is, shall the bill pass? Gentleman from the 22nd, Doug at Linville.
Thank you, Mr. Speaker. Let me perhaps give a little bit of background, and colleagues, I'll endeavor to be brief. I was actually on a press conference with the governor announcing an economic development initiative that we actually finally finished and penned, and I announced actually here from the floor of the House earlier this year, when there were some questions on his press conference about another matter, that being what my friend from Kanawha put forward surrounding a fire where a number of fire hydrants did not work. And I've listened to that 911 call, and the governor then called upon both the legislature and the Public Service Commission to investigate what was going on and to fix the problem if there's a problem. Well, friends, what we know is that there is a problem. There is a problem. That has been documented at length in the Committee on Technology and Infrastructure, both in the interim period and now. And I will take you back quickly to the interims. From that podium right there, with I and my Senate counterpart up where the clerk is sitting, we received testimony initially from staff of the Public Service Commission, which seemed to indicate that Public Service Commission did at that point have rules which did or would require that the fire hydrants continue to work. Over a period of time, we actually found out that was incorrect, and there was no malice there. There was no intent to deceive the members of the legislature. Quite frankly, we've had a technology that's been here for 100 years, and we're asking ourselves now, how in the world do we not have this down pat? How is the present body of regulation insufficient to ensure that when West Virginians are in their absolute worst moment of their lives, their moment of need, that those fire hydrants work? Well, the answer is no one realized that it wasn't all entirely contained in Public Service Commission code. Here we are. 64 CSR 77 is actually public health, believe it or not, and they're the enforcement there. So what the bill essentially does is place that enforcement in the Public Service Commission. In the Public Service Commission. Now, my friend also is in agreement with me, and this is actually, we've had differences between the Committee on Technology and Infrastructure and the Committee on Judiciary in regards to applicability for someone to be able to that on the bill simply costs about $100 per hydrant. The staff actually put a memo flat saying that whether or not the PSC had a rule on this, the moral obligation for owners to make these hydrants work. Friends, I know that we're at the end of a long day, but there are a few things that you can do and literally say for people that you'll never know that you likely will save a life, and that is what's before us today. That is what's before us with this very bill. Now, I will tell you that I believe those fire hydrants have always had to work. I think if you go ask any of your first responders, they're going to also tell you those fire hydrants have always had to work. I will also tell you that there are certainly charges and fees and things of that nature which your water service providers have already charged to maintain and improve your fire hydrants within their systems. And I would ask each and every one of you, please, as we return home, hopefully this bill becomes law, but as we return home, that you scrutinize everything that's going on with this, and you watch for any requests for rate increases, and you scrutinize those very directly. Because I'm telling you, people like to scapegoat the legislature. They like to point at us and say, oh, we had to raise your rates because of something that they did. I reject that argument. I reject that argument here. But folks, you very well may save a life with this vote. And I've never said that from the floor of this House. There's a lot of times we draw on additional imagery and things of that nature. But I want to share one final thing with you. Sunday was the 11-year anniversary of my grandfather passing away in a house fire. Sunday. As this bill has been contemplated, that has been on my mind. It wasn't because a fire hydrant didn't work. Grandma made it out the back. Grandpa made it out the front. They went around the house, couldn't find each other, and he ran back in after her. They found him 9 feet from the front door. A fire can change people's lives. And I urge passage of this bill. I urge scrutiny as it happens. Let's take care of this. Let's take care of this right now. It's a great way to end the day. Mr. Speaker, I urge passage.
Gentleman, the 84th, Jennings.
Yes, thank you, Mr. Speaker. Would the delegate yield?
Me, yes.
First off, the cost, but I can tell you in these little PSDs, they don't have this, a lot of them don't have the money. So what we'll wind up with is black bags over fire hydrants, because if they, for one thing, you said it has to have pressure. In West Virginia, that pressure, if you've got the fire hydrant too close to the top of the hill, you don't have the pressure. So you don't have volume that you need to run the pumps on the trucks. Well, you have some, but you don't have what was adequate. If there's a requirement that there has to be enough, how are they going to require that? Are they going to require a certain amount, or?
No, I think maybe there's some miscommunication or some confusion here. Under this bill before you, the PSC can still now ask for a rate increase to pay for this maintenance work of these fire hydrants, okay? And there was debate as to whether whether preclude request a rate increase, okay? So if now, the testimony also was that if the PSC had already granted an increase for the purposes of maintenance of fire hydrants, then most likely they would not get a new rate increase because that was supposed to already have been built into the rates to take care of these fire hydrants. But if you have a situation where they're not already charging customers to maintain these fire hydrants, funds under this bill, they could go to the PSC and request a rate increase to take care of this.
Government puts in fire hydrant every, I think, 1,000 feet. So if it's a good ways, you know, I know one place in Preston County where it's a long ways, and there is a lot of fire hydrants, and there's no houses, there's nothing around, but there's those fire hydrants. Will those be included in having to be brought to?
My understanding is that if it is in the PSC's jurisdiction,
well, they're the ones supply the water.
They would have to maintain those fire hydrants, yes. But if they need additional money to do that, they can. There is a United States Supreme Court case that came out of West Virginia, Bluefield Waterworks versus Public Service Commission, where the U.S. Supreme Court emphatically stated that a public utility is allowed to make a reasonable profit. And if that includes rate increases to do their job plus make a reasonable profit, they are absolutely allowed to do that. So if money is needed, unless they've already built that into the current rates, and even then, if the PSC could consider an additional request, but that would have to go through the PSC as any rate increase would. So there are mechanisms to pay for maintaining these fire hydrants. Yes.
Okay, I mean, this is a good idea. I want the fire hydrants to work because I'm in the fire department. There's nothing worse than when you start cranking it up, nothing happens. And so then you got to go to the next one. But I just want everybody to understand these little PSDs, they don't have a lot of money, and this might cause a problem. That's all. But thank you.
Gentleman from the 69th, second Marple.
Thank you, Mr. Chairman. I favor what the delegate from Preston County, the 84th District says. I second that adoption of this bill. I came back to West Virginia in 1993, and I've been running with the volunteer fire department ever since. There's nothing more disappointing than to pull up to a hydrant and it doesn't work. And I'll tell you who it's more disappointing to: the person who has a house on fire or a building on fire or a barn on fire, and you've got to use your water up and you're waiting for the next volunteer fire department to roll in, and they may be 10, 15, 20, 30 minutes before they get there. So urge passage of this bill, and if we find through the testing that these hydrants So many of them don't work, and these public service companies cannot pay to fix them. I'm sure the next governor coming in here is going to come to this legislature and ask for some money, emergency money, to get all the fire hydrants in West Virginia working. Thank you, Mr. Chairman.
Gentleman from the 72nd, Delegate Riley.
Thank you, Mr. Speaker, and I would like to compliment my friend from the 22nd. This is a real issue. It's a real issue in every city, in every county in this state. I passed out yesterday a picture of a 16-inch water line, so you could see what the insides of one of those looks like. You know, I've installed over 1,000 fire hydrants, and I've been through dozens and dozens of great cases at the Public Service Commission. One thing I do want to clear up, will be some impact. Make no mistake about it, because you're going to be able to require some things that have not been required in the past. And that's okay, because what we're really trying to do is protect lives, and that was the gentleman from the 22nd, his whole point. And I agree with him. And I'm glad that we did not take up the amendments, because the gentleman from the 84th is exactly right. There would have been unintended consequences. They would have painted fire hydrants black, which is in M17 and NFPA 21. We would have reduced the fire protection for our people. And so now I'm glad that I'm able to stand and support this bill. I will be voting green. I hope you will too.
Gentleman from the 2nd, Delegate Teslo.
Mr. Speaker, the hour is late. This bill is real simple. I commend the gentleman from the 55th for rescinding his amendment. This bill is for the PSC to take the first steps to get an idea of what kind of problems exist out there in our state. We have to do this step. I promise you all that once we sort out and find out what all the problems are, we're going to have a host of issues that we have no knowledge of right now. This is not the time to argue about who's going to pay. We have to get to the heart of the problem. Let's just vote on this and get moving, and next year if we need to, we can do that, and I'll be glad to do what I can to help. But let's get this thing moving, and let's let the PSC do what they have outlined they want to do, and hopefully everybody will be all the safer for it. Thank you.
Is there more debate on the bill? Does the gentleman from the 51st wish to close debate on the bill? If not, the question is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 89 ayes, 2 nays, and 9 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5617, authorizing the Public Service Commission to promulgate rules for maintenance, flushing, flow testing, and marking of fire hydrants owned by water utilities.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Further bills on third reading today. If not, report to standing committees.
Your Committee on Education has had under consideration Senate Bill 162, establishing summer feeding for all program, and reports the same back with the recommendation that it do pass, but that it first be referred to the Committee on Finance.
Report to be received. The bill will be referred to the Committee on Finance.
Your Committee on Education has had under consideration committee substitute for Senate Bill 292, Hunger-Free Campus Act, and reports the same back with the recommendation that it do pass.
Report to be received.
Your Committee on Rules has had under consideration House Resolution 9, reaffirming the long-standing sisterhood partnership between West Virginia and Taiwan, and reports the same back with the recommendation that it be adopted.
Report to be received.
Your Committee on Economic Development and Tourism has had under consideration committee substitute for Senate Bill 571, creating West Virginia Corridor H, Advanced Energy and Economic Corridor. The same back with recommendation that it do pass, be referred to the Committee on Finance.
Report to be received. The bill Finance.
Committee on Economic Development and Tourism has defining deadlines for local permits and extensions for property development or improvement, and reports the same by pass.
Report to be received.
Your Committee on Technology and Infrastructure has had under consideration Committee Substitute for Senate Concurrent Resolution 1, U.S. Army Private First Class Leon Charles Trader Memorial Bridge. Senate Concurrent Resolution 2, U.S. Army Private First Class John Henry Trail Memorial Bridge. Committee Substitute for Senate Concurrent Resolution 5, U.S. Army First Lieutenant Herschel Gerald Memorial Road. Committee Substitute for Senate Concurrent Resolution 6, U.S. Army Staff Sergeant Orland Jackson Toms Memorial Road. Senate Concurrent Resolution 8, U.S. Army Corporal Clement Knapp Memorial Bridge. Committee Substitute for Senate Concurrent Resolution 11, U.S. Marine Corps Private First Class Noel Harper Fields Memorial Bridge. Committee Substitute for Senate Concurrent Resolution 12, U.S. Army Private Raymond Lee Perkins Memorial Bridge. Committee Substitute for Senate Concurrent Resolution 14, U.S. Army Private First Class William Gorman Memorial Bridge. Senate Concurrent Resolution 15, Chief Edward Eddie Kiesecker Memorial Bridge. Senate Concurrent Resolution 18, Stanley W. and Evelyn C. Memorial Bridge. And Senate Concurrent Resolution 19, U.S. Class Henry W. Baldwin Memorial Bridge, and reports the same back with recommendation that they each be adopted, but that they first be referred to the Committee on Rules.
That report will be received. Gentleman from the 61st, Delegate Jeffries.
Mr. Speaker, I ask unanimous consent to take all resolutions up for immediate consideration, dispense with committee reference, and put upon their adoption.
Gentleman from the 61st, ask unanimous consent that the infrastructure naming resolutions just reported by the clerk from the Committee on Technology and Infrastructure be taken up for immediate consideration, have the reference to the Committee on Rules be dispensed with, and be put upon their adoption. Are there objections? Are there objections? No objections are heard. Those resolutions will be taken up for immediate consideration. Would any member like separate consideration of any of the naming resolutions just read? If not, the question is, shall those resolutions be adopted? Is there debate on the resolutions? If not, then the question is, shall committee substitute for Senate Resolution 8, committee substitute for Senate Resolution 12 and 14, Resolutions 15, 18, and 19 adopted. Those in favor of adoption will please say aye. Those opposed will please say no. The ayes have it. Chair, those resolutions adopted. The clerk will please communicate the action of the House to the Senate. Further standing committee report. If not, Senate message.
House concurrent clerk of the Senate announces that the Senate has, with amendment, the following resolutions. House concurrent resolution 2, U.S. Army Specialist Stephen W. Herron Memorial Bridge. Committee substitute for House concurrent resolution 3, Legg Brothers World War II Veterans Memorial Bridge. Committee substitute for House concurrent resolution 7, U.S. Navy Radarman, 3rd Class Craig W. Haynes Memorial Bridge. House Concurrent Resolution 8, Judy Brothers Memorial Bridge. Committee substitute for House Concurrent Resolution 9, Private Jefferson Howell Memorial Road. House Concurrent Resolution 18, Caldwell Brothers Memorial Bridge. Committee substitute for House Concurrent Resolution 19, Corporal Thomas Lowell Wines Memorial Bridge. House Concurrent Resolution 20, Specialist for Donnie Lee Hackney Memorial Bridge. Committee substitute for House Concurrent Resolution 26, Private First Class Jerry Lee Bassett Memorial Bridge. House Concurrent Resolution 30, Jack L. Hart Memorial Bridge. House Concurrent Resolution 32, Sloan Brothers Memorial Bridge. House Concurrent Resolution 36, Chief Master Sergeant Dan Chandler Bridge. Committee substitute for House Concurrent Resolution 39, U.S. Army Specialist 3, Delbert Sheridan Buck Huffman Sr. Memorial Bridge. Committee substitute for House Concurrent Resolution 40, U.S. Marine Corps Master Sergeant Edward P. and MP Carl A. McRae Memorial Bridge. House Concurrent Resolution 44, Frank Walker Mosley Memorial Bridge. House Concurrent Resolution 53, U.S. Navy Quartermaster 3rd Class Lawrence Earl Boggs Memorial Bridge. House Concurrent Resolution 60, Tara Dawn Lewis Memorial Road and Bridge. House Concurrent Resolution 61, Mollahan Brothers Memorial Bridge. House Concurrent Resolution 68, U.S. Army Air Force Major Willis Scotty Adams Memorial Bridge.
Ladies and gentlemen, the chair is advised that the Senate amendments to the House infrastructure naming resolutions are technical in nature. This time, are there objections to taking up for immediate consideration each of the infrastructure naming resolutions just read by the clerk? No objections are heard. Would any member like separate consideration of each of the resolutions just read by the clerk? If not, the question is there unanimous consent to adopt each of the Senate amendments to the infrastructure resolutions? To be clear, it would be a concurrence in the Senate amendments. So are there objections to concurring in the Senate amendments to each of the infrastructure naming resolutions just read by the clerk? Gentleman 100, take it right now is recognized.
Mr. Speaker, if I could just clarify what we're doing.
Yes.
So we would be accepting these resolutions. We would not be discussing these any further. We'd be voting on them today, correct?
Gentleman is correct. However, the chair will permit separate consideration for any resolution on which members seek separate consideration. These are House resolutions that have been through the body once before.
Very good. Thank you. That's all I need to know. Thank you, Mr. Chairman. Or Mr.
For what purpose does the gentleman 22nd seek recognition? Dr. Linville?
Simply to clarify for the gentleman from the 100th if he needed any clarification. The Senate has a tendency to tinker. They tinkered. The resolutions are still substantively the same. And so I would urge concurrence in the Senate amendments and ultimately adoption.
Lady in the 71st, Dr. Kimball.
Thank you, Mr. Speaker. I ask you, I guess, unanimous consent that I would like consideration of House Concurrent Resolution number 68, separate and apart.
68, we will give separate consideration to. Question again is, are there objections to amendments to each of the infrastructure naming resolutions just read by the clerk, accepting House Concurrent Resolution 68? No objections are heard. So the question now is, are there objections, or shall the resolutions be adopted as amended? Shall the resolutions be adopted as amended? Those in favor of adoption of the resolutions as amended will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares each of those infrastructure naming resolutions as amended adopted. Now before the House is House Concurrent Resolution 68. House Concurrent Resolution 68. First, the question is, shall the House concur in the Senate amendment to House Concurrent Resolution 68? Are those in favor of concurring in the Senate amendment to House Concurrent Resolution 68 will please say aye. Aye. Those opposed will please say no. The ayes have it. Chair declares the amendments adopted. Now the question is on the adoption of House Concurrent Resolution 68 as amended. Is there debate or discussion on the resolution? If not, the question is, shall the resolution be adopted? Those in favor of adoption of the resolution will please say aye. Aye. Those opposed will please say no. The ayes have it, and the chair declares House Concurrent Resolution 68 adopted. The clerk will please communicate the action of the House to the Senate. Gentleman from the 22nd, Dr. Linville.
Point of inquiry of the chair. Is the House in possession of House Concurrent Resolution 6, 21, 37, 47, 49, or 67?
The chair is not.
Point of inquiry of the clerk. That's 6 naming resolutions that we had sent over to the Senate that have not been adopted.
Have they been amended by the Senate?
I do not believe so.
If they've not been amended by the Senate, we don't need to be in possession of them.
Okay. Is the clerk aware as to whether or not the Senate passed those 6 resolutions? Numbers 6, 21, 37, 47, 49, and 67.
If the gentleman please bring those numbers to the clerk's desk, we'll quickly check.
Because they just figured, maybe they just figured that it was.
Gentleman with 22nd will please approach the podium. Ladies and gentlemen, today is the deadline for passage of infrastructure naming resolutions pursuant to the joint rules. So we're going to take just a few moments and confirm that we have reached finality on that before we adjourn for the day. So please just be at ease for a few moments while we confirm completion of the infrastructure naming resolutions. House will please return to order. House will please return to order. Leaves of absence, introductions, miscellaneous business. Gentleman from the 61st, or lady from the 71st.
Thank you, Mr. Speaker. Pursuant to Rule 48, I ask unanimous consent and request that my explanation as to my vote in regard to House Bill 4722 shall be recorded in the Journal.
Lady is recognized for that purpose.
Thank you. And then I have a second request.
Yes, lady has the floor.
Thank you. I ask unanimous consent to be added as a sponsor to House Bill 5510.
5510, is there space on the bill? There is space on the bill. Are there objections?
Thank you.
No objections are heard, and the lady will be so added. Gentleman from the 100th.
Mr. Speaker, I request that my comments on Senate Resolutions 4 and 26 be included within the Journal.
Are there objections? Yep. Are there objections to the gentleman's comment in the appendix? No objections are heard.
Subject to announce that we adjourn until 11 a.m.
Are there announcements? Gentleman 61st.
Yes, Mr. Speaker, your committee rules will meet at 10:45 a.m. behind the members' lounge tomorrow morning.
Gentleman 97th, Hardy.
Thank you, Mr. Chairman. Your Committee on Finance will meet tomorrow morning at 9 o'clock. Republican members will caucus in the committee room at 8:30. Thank you, Mr. Speaker.
Gentleman from the 8th, Kelly.
Thank you, Mr. Speaker. Your Committee on the Judiciary will meet tomorrow morning at 9:30 in the House Committee Room. Also, Mr. Speaker, Republican members will caucus in the Chairman's office at 9:10, and the agenda will be posted. Thank you, Mr. Speaker.
Gentleman from the 26th, Second Rohrbach.
Thank you, Mr. To remind those of you who belong to the Mississippi, we will be taking tomorrow.
Gentleman from the 99th, Doug Clark.
Thank you, Mr. Speaker. Your Committee on Economy will meet tomorrow at 3 p.m. in House Judiciary. Republican members will caucus at 2:45.
Gentleman from the 21st, Doug Cannon.
Thank you, Mr. Speaker. Your Committee on Technology and Infrastructure will not meet tomorrow.
Gentleman from the 2nd, Doug Teslo.
Time when we get out. The agenda will be posted, and you to bring your computer. Thank you.
Are there further announcements? If not, the question is on the motion that the House adjourn until 11 a.m. tomorrow. Those in favor of the motion will please say aye. Those opposed will please say no. The ayes have it. The motion is adopted. The House is adjourned until 11 a.m. tomorrow.